1147. The power of blessing those sacred utensils which must, according to the liturgical laws, be blessed before they are used for their proper purpose, is given to 1. All cardinals and bishops, 2. Local ordinaries not having episcopal consecration, for the churches and oratories of their own territory, 3. Pastors for the churches and oratories within the limits of their parish, and rectors of churches for their churches, 4. Priests delegated by the ordinary, within the limits of the delegation and the jurisdiction of the delegating ordinary, 5. Religious superiors, and priests of the same order delegated by them, for their own churches and oratories, and for the churches of the nuns subject to them. Canon 1304, 1148. Sacred utensils that have been blessed or consecrated lose their blessing or consecration. 1. If they suffered such damage or change that they lost their original shape and are no longer fit for their purpose. 2. If they have been used for unbecoming purposes, or have been exposed for public sale. Chalice and paten do not lose their consecration by the wearing off or renewal of the gold plating, saving the grave obliga. Vow 269. Of having the gold plating renewed when worn out. Canon 1305, 1149. Care must be taken that the chalice and paten, and unwashed purificators, palls and corporals, are not touched except by clerics or those who have the custody of these utensils. The purificators, palls and corporals used in the Holy Mass shall not be given to lay persons, even religious, to be washed until they have first been washed by a cleric in major orders. The water of the first washing shall be poured into the sacrarium, or, if there is none, into the fire. Canon 1306. Title 19. Vow and Oath. Chapter 1. Vow. 1150. A vow is a free and deliberate promise to God of something possible and better, and it imposes an obligation by reason of the virtue of religion. All persons having sufficient use of reason in proportion to the object of the vow, may make a vow unless they are forbidden by law. A vow made from grave, unjust fear is invalid by the very fact. Canon 1307, 1151. A vow is called public, if it is accepted in the name of the Church by legitimate ecclesiastical superior; otherwise it is private. Solemn, if recognized as such by the Church; otherwise it is simple. Reserved, if dispensation from it can be given only by the Holy See. Personal, if an act of the person making the vow is promised. Real, if some object is promised. Mixed, if it partakes of the nature of both, personal and real vow. Canon 1308, 1152. Of private vows there are reserved to the Holy See these two: the vow of perfect and perpetual chastity, and the vow to enter a religious order in which solemn vows are taken, if they are made unconditionally, and after the completion of the 18th year of age. Canon 1309, 270. The New Canon Law. 1153. By virtue of a vow no one else except the one making the vow is held. The obligation of a real vow goes over to the heirs, as also the mixed vow to the extent as it is real. Canon 1310, 1154. The vow ceases in the following cases: when the time expires which was annexed to it for the finishing of the obligation, by substantial change of the object which was promised, by cessation of the condition on which a vow was made dependent or its final purpose, by irritation, dispensation, commutation. Canon 1311, 1155. He who has dominative power over the will of the person making a vow, can annul his or her vows validly, and for good cause also licitly, so that its obligation does in no way revive afterwards. He who has not indeed power over the will of another, but over the matter which is made the object of the promise, can suspend the obligation of the vow for such a length of time as the fulfillment of the vow would be to his prejudice. Canon 1312, 1156. Vows which are not reserved, and the dispensation from which does not injure the acquired rights of a third party, may for good reason be dispensed with. 1. By the ordinary of the diocese, who can dispense all his subjects and the Peregrini. 2. The religious superior in clerical exempt religious communities, who dispenses his subjects in the order, and all those habitually living under the same roof with his religious. 3. Persons delegated by the Holy See to dispense from vows. Canon 1313, 1157. The good work promised in a non-reserved vow can be commuted into a better, or an equal one, by the individual himself who made the vow, but for changing it into a lesser work the power of dispensation is required, according to the rules of the foregoing canon. Canon 1314. 1158. Vows made before entering a religious community are suspended as long as the person remains in a religious life. Canon 1315. Chapter N less than. Oath. 1159. An oath, which is an invocation of the divine name and witness of the truth, cannot be taken except with truth, judgment and justice. Oath 271. An oath which the canons demand or permit cannot validly be taken by proxy. Canon 1316, 1160. The person who freely takes an oath to do some work is held by the special obligation of religion to do what he has promised under oath. An oath exacted by violence or grave fear is valid, but it may be released by the ecclesiastical superior. An oath, made without violence or deceit, by which a person renounces some private good or favor given him by the law itself, must be observed whenever it does not involve the ruin of the soul. Canon 1317, 1161. A promissory oath follows the nature and conditions of the act to which the oath is added. If an act involving directly the damage of others, or the prejudice of the common weal, or eternal salvation, is confirmed by an oath, the act does not thereby acquire any firmness. Canon 1318, 1162. The obligation induced by a promissory oath ceases. 1. If it is released by him in whose favor the oath was made. 2. If the object promised by oath has changed substantially, or if, on account of changed circumstances, the oath becomes either sinful or altogether a matter of indifference, or, finally, if it impedes a higher good. 3. If the final purpose or the condition under which the oath was taken ceases. 4. By annulment, dispensation, commutation, according to Canon 1320, Canon 1319, 1163. Those who have the power to annul, dispense, commute vows, have the same power also over a promissory oath. If, however, the dispensation from an oath turns to the prejudice of others who are not willing to remit the obligation, the Holy See alone can dispense from such an oath for reason of the necessity or utility of the Church. Canon 1320, 1164. An oath must be strictly interpreted, according to law, and the intention of the person taking the oath, or, if he should act with deceit, according to the intention of the one to whom the oath was made. Canon 1321, 272. The New Canon Law, Part 4, the teaching authority of the Church. 1165. The Lord Jesus Christ confided to the Church the deposit of faith, in order that she, with the perpetual assistance of the Holy Ghost, may faithfully preserve and expound the revealed doctrine. The Church has independently of any civil power the right and the duty to teach all nations the evangelical doctrine, and all are bound by divine law to learn this doctrine, and to embrace the true Church of God. Canon 1322, 1166. By divine and Catholic faith must be believed all those truths contained in the written or traditional Word of God, and which are either in solemn judgment or by the ordinary and universal teaching authority, proposed to our belief by the Church, as divinely revealed truths. The solemn judgment in this matter is reserved either to a general council, or to the Roman Pontiff speaking ex cathedra, that is to say, in his supreme teaching authority. No part of the religious teaching is to be understood as dogmatically declared and defined, unless such declaration or definition is clearly known to have been made. Canon 1323, 1167. It is not sufficient to avoid heretical error, but also all those errors which more or less approach heresy. Wherefore all constitutions and decrees by which the Holy See has condemned and prohibited such false opinions must be observed. Canon 1324, 1168. The faithful are in conscience obliged to profess their faith publicly whenever their silence, subterfuge, or manner of acting, imports an implicit denial of their faith, a contempt of religion, or an insult to God, or scandal to the neighbor. A baptized Christian, who calls himself a Christian, yet obstinately denies or calls into doubt any of the truths to be believed by divine and Catholic faith, is a heretic. If he abandons the Christian faith altogether, he is called an apostate. If, finally, he refuses to be subject to the Supreme Pontiff, or to have communication with the members of the Church subject to the Roman Pontiff, he is a schismatic. The Catholics shall not enter into any dispute or conferences with non-Catholics, especially public ones, without permiss. Preaching of the Word of God. 273. Sign of the Holy See, or, in urgent case, of the ordinary. Canon 1325, 1169. The bishops also, though not possessing, either individually nor in particular councils, the authority of infallible teachers, are, under the authority of the Roman Pontiff, truly doctors and teachers for the faithful committed to their care. Canon 1326, Title 20, Preaching of the Word of God. 1170. The office of preaching the Catholic faith is principally committed to the Roman Pontiff for the universal Church, and to the bishops for the subjects of their diocese. The bishops are bound to preach in person the Holy Gospel, unless they are legitimately impeded. In addition, they must employ, besides the pastors, the help of other qualified persons for the salutary fulfillment of the office of preaching. Canon 1327, 1171. No one is allowed to exercise the ministry of preaching unless he has received commission from the legitimate superior, by special faculty or by appointment to an office to which the office of preaching is attached by the sacred canons. Canon 1328. Chapter 1. Catechetical Instruction. 1172. It is the proper and most serious office of the pastors of souls to attend to the catechetical instruction of the Christian people. Canon 1329, 1173. The pastor must, 1. At stated times each year prepare, by instructions on several days in succession, the children for the reception of the sacraments of penance and confirmation. 2. Prepare the children with all possible care, preferably in Lent if nothing stands in the way, to receive First Holy Communion worthily. Canon 1330, 1174. Besides the instructions for First Holy Communion, spoken of in the preceding canon, the pastor shall instruct more fully in Christian doctrine the children who recently made their First Communion. Canon 1331, 1175. On Sundays and other holidays of obligation. The 274. The New Canon Law. Pastor must at an hour more convenient for the majority of the faithful give catechetical instruction to the adults, in such a form as is best suited to their capacity. Canon 1332, 1176. The pastor must, for the purpose of religious instruction of the children, if he is legitimately impeded, employ the help of other priests in the parish, and also, if necessary, of pious laypeople, especially those who belong to the sodality of Christian doctrine, or a similar society established in the parish. The priests and other clerics, unless excused by legitimate impediment, must assist their own pastor in this most holy work, and they can be commanded to do so by the ordinary, also under threat of ecclesiastical penalties. Canon 1333, 1177. If according to the judgment of the bishop the help of the religious is deemed necessary for the catechetical instruction of the people, the religious superiors, even though exempt, are obliged, when so requested by the bishop, to give catechetical instruction either in person or through their subjects, especially in their own churches, without, however, any detriment to religious discipline. Canon 1334, 1178. Not only the parents, but also all others holding the place of the parents, also masters and godparents, are obliged in conscience to see to it that those subject or commended to them receive catechetical instruction. Canon 1335, 1179. Local ordinaries have the right to pass regulations concerning the teaching of Christian doctrine to the people, and exempt religious are also bound to observe those rules whenever they teach non-exempt persons. Canon 1336, Chapter 2, Sacred Preaching, 1180. The faculty of preaching, for the secular clergy as well as for the non-exempt religious, can be given only by the local ordinary in his diocese. Canon 1337, 1181. If a sermon is to be given only to the exempt religious and to persons of their household, the religious superior of a clerical exempt community, who has this right according to the constitutions, grants the faculty. He can also give this faculty to secular priests, and to those of another religious order, provided they have been declared qualified by their ordinary or by their religious superior. Sacred Preaching 275. If a sermon is to be given to others, also to none subject to the regulars, the faculty of preaching must be obtained, by both secular and exempt religious priests, from the ordinary of the place where the sermon is to be given, the preacher who is to address exempt nuns needs, moreover, the permission of their religious superior. The faculty of preaching to the members of an exempt local order is to be given by the ordinary. The preacher cannot make use of his faculty without the assent of the religious superior. Canon 1338, 1182. The local ordinaries should not without grave reason refuse to give their faculty of preaching to those religious who are presented by their superior, nor recall the faculty which was granted, especially not for all of the priests of one community at the same time. The rule of Canon 1340, however, is to observed. Religious priests are not allowed to make use of the faculty of preaching without the permission of their superior. Canon 1339, 1183. The ordinary, and the religious superior are, under grave obligation of conscience, forbidden to give faculty or permission to preach except to priests of good moral standing and of sufficient knowledge to be ascertained by examination, as amended by Canon 877, 1. If after giving faculty or permission, they find that the preacher is lacking the necessary qualifications, they must recall the faculty. When doubt arises as to the necessary knowledge, they must make sure of it, even by a new examination, if necessary. In the case of deprivation of the faculty of preaching, recourse to the higher superiors is permitted, but no appeal in suspensivo, which means to say that the order of the superior must be obeyed in the meantime. Canon 1340, 1184. Priests of another diocese, seculars as well as religious, shall not be invited to preach unless permission has first been obtained from the bishop of the place where the sermon is to be given. The bishop, unless the priest is otherwise known to him, shall not give faculty to preach unless he has first received from his ordinary a good testimonial concerning the knowledge, piety, and good character of the preacher. The ordinary giving the testimonials is bound by serious duty of conscience to make a truthful statement. 276. The New Canon Law. The pastor must apply for the faculty in good time when there is question of the parochial or another church subject to him, in a church exempt from the jurisdiction of the pastor, the rector, and if there is questions of a capitular church, the first dignity of the chapter with the consent of the chapter, and the director or chaplain of a confraternity if it has a church of its own. If the parochial church is at the same time the proper church for a chapter or confraternity, the priest who, by right performs the sacred functions is to apply for the faculty of an outside preacher. Canon 1341, 1185. The faculty of preaching should be given only to priests or deacons, not, however, to other clerics unless the bishop see fit to grant it in individual cases. All laymen, even religious, are forbidden to preach in church. Canon 1342, 1186. The ordinaries of places have the right to preach in any church of their territory, not excluding exempt churches. Unless the city is very large, the bishop can forbid sermons to the people in other churches of the town or city at the time when he either himself preaches, or has a sermon preached in his presence on some public and extraordinary occasion. Canon 1343, 1187. On Sundays and holidays of obligation throughout the year it is the duty of the pastor to preach to the people the word of God in the customary homily, especially during the Holy Mass, in which the attendance of the people usually is more numerous. The pastor cannot fulfill this obligation habitually through another priest, unless he has a just excuse, to be approved by the bishop. The ordinary may permit that on the more solemn feasts, and for a good reason also on some Sundays, the sermon is omitted. Canon 1344, 1188. It is to be desired that in all churches and public oratories where people assist at Holy Mass on Sundays and holy days of obligation, a short explanation of the Holy Gospel, or on any other point of Christian doctrine, be given to the people. If the ordinary has given orders concerning this affair, they must be obeyed, not only by the secular clergy, but also by non-exempt and exempt religious in their own churches. Canon 1345, Sacred Missions 277, 1189, local ordinaries shall attend to it that during the Lenten season, and also, if they judge it useful, during Advent, sermons are more frequently given in cathedral and parochial churches. The canons and others belonging to the cathedral chapter shall be obliged to be present at these sermons if they are held immediately after the choir services, unless they are detained elsewhere for good reasons. The ordinary can oblige them to be present even under canonical penalties. Canon 1346, 1190. In the sacred sermons there should be explained above all else the things which the faithful must believe and do to save their souls. The preachers of the Word of God should abstain from profane arguments or arguments so deep as to exceed the common understanding of their hearers, and they should not exercise the evangelical ministry in skilled words of human wisdom, nor with a profane demonstration of vain and ambitious eloquence, but in the power and strength of the Spirit of God, not preaching themselves but Christ crucified. If it should unfortunately happen that a preacher disseminates errors and scandals, he shall be forbidden to preach, to hear confessions, or to exercise any office of teaching. If his preaching is heretical, he should be dealt with according to the rules of law. Canon 1347, 1191. The faithful are to be zealously admonished to be frequently present at sermons. Canon 1348. Chapter 3, Sacred Missions, 1192. The ordinaries should insist that the pastors have a mission given to their parishioners at least once in 10 years. The pastors, not excluding those of religious orders, are held to obey the ordinary's regulations concerning these missions. Canon 1349. 1193. Local ordinaries and pastors should interest themselves in the welfare of the souls of the non-Catholics in their dioceses and parishes. In other territories the entire care for the missions among non-Catholics is exclusively reserved to the Holy See. Canon 1350, 278. The New Canon Law 194. Nobody must be forced to embrace the Catholic faith against his will. Canon 1351, Title 21, Seminaries, 1195. It is the proper and exclusive right of the Church to educate the men who desire to give themselves to the ecclesiastical ministry. Canon 1352, 1196. The priests, especially the pastors, should give attention to boys who show signs of ecclesiastical vocation, and take pains to keep them from the contamination of the world. Instruct them in piety, give them their first lessons in the study of letters, and foster the seed of vocation in them. Canon 1353, 1197. In every diocese the bishop shall erect in a suitable place a seminary or college, in which, according to the means and the requirements of the diocese, a certain number of young men are to be educated for the clerical state. Care should be taken to have, especially in large dioceses, 2 seminaries, a minor seminary for the boys for the study of letters and sciences, and a major seminary for the study of philosophy and theology. If a diocesan seminary cannot be erected, or if in such a seminary a regular course in philosophy and theology cannot be given, the bishop should send the students to an outside seminary, unless there is an interdiocesan, or provincial, seminary erected by the authority of the Holy See. Canon 1354, 1198. If there are no proper revenues for the building and maintenance of the seminary and the students, the bishop can, 1. Order the pastors and rectors of churches, also the exempt ones, to take up at stated times a collection for that purpose. 2. Impose a seminary tax. 3. If these means are not sufficient, he may annex some simple benefices to the seminary. Canon 1355, 1199. The seminary tax or assessment must be paid by the mensa episcopalis, by all benefices, including those of regulars and those over which someone has the right of patronage, by all parishes and quasi-parishes, though they have no other revenue than the offerings of the faithful, by hospitals erected by eccles. Seminaries 279, Iastical authority, by sodalities canonically erected, and by church buildings which have their own revenue, and by every religious house though exempt, unless the religious live solely on alms or have actually in their houses a college for pupils or teachers for the commonweal of the church. All contrary custom is disapproved and every kind of contrary privilege is recalled, and no appeal granted. This assessment must be general, and of the same percentage for all churches and institutions subject to the tax, and may be larger or smaller, according to the needs of the seminary. The annual tax must not exceed 5% of the income, and it is to be lowered as the revenue of the seminary increases. The taxable income is that which remains over and above at the end of the year, after the obligations and necessary expenditures have been paid. In benefices of cathedral or collegiate churches, where the members of the cathedral or collegiate chapter receive daily distributions besides the regular revenue of their benefice, the daily distributions are not taxable. If the benefice consists only of the daily distributions, the third part of them is taxable. In parishes the offerings of the faithful are not taxable revenue of the parish, unless the parish has no other revenue than the offerings of the faithful, in which case 1/3 of the offerings is taxable. Canon 1356, 1200. The bishop has the right to pass regulations for the proper administration, government and progress of the diocesan seminary and to enforce these regulations, saving the rules which the Holy See may have laid down for special cases. The bishop should take special care to frequently visit the seminary himself, watch over the manner in which secular and ecclesiastical sciences are taught, and obtain personal knowledge of the vocation and character and standing in studies of the pupils, especially at the time of ordinations. Every seminary shall have its laws approved by the bishop, in which regulations are given both for the students and for the professors of the seminary. The interdiocesan, or provincial, seminary shall be governed and administrated according to the laws passed by the Holy See. Canon 1351, 1201. In every seminary there must be a rector for the government of the house, professors, and economic distinct from the 280 the new canon law. Rector for the administration of the temporalities, at least 2 ordinary confessors, and a spiritual director. Canon 1358, 1202. There should be appointed 2 boards for each seminary, one for discipline, the other for the administration of the temporal goods. Each board is to consist of 2 priests chosen by the bishop with the advice of the chapter or of the diocesan consultors, the vicar general, priests living in the bishop's house, the rector of the seminary, the economists, and the ordinary confessors, are excluded from either board. The office of the members of the 2 boards lasts for 6 years, and those appointed should not be removed without a serious cause. They may be reappointed. The bishop must consult the boards in affairs of importance. Canon 1359, 1203. To the office of rector, spiritual director, confessor, and professor of the seminary, are to be appointed men qualified for these offices not only by their learning, but also by virtue and discretion, so that they may in word and deed be an example to the alumni. According to Canon 891 the rector may not be confessor for the seminarians. The rector of the seminary must be obeyed by all in the exercise of his office. Canon 1360, 1204. Besides the ordinary confessors, other confessors should be appointed, to whom the seminarians may freely go to confession. If these confessors live outside the seminary, and the student requests the rector to call one of them to hear his confession, the rector is forbidden in any way to inquire for the reason why or to show displeasure. If the confessors live in the seminary, the seminarians may freely approach them, saving the discipline of the seminary, When there is question of admitting a seminarian to orders, or of dismissing him from the seminary, the vote of the confere must never be asked. Canon 1361, 1205. The income derived from legacies for the education of clerics may be used in favor of alumni of the minor as well as the major seminary, though they are not as yet clerics properly so called by reception of the tonsure, unless the terms under which a legacy was left to the seminary explicitly restricts the use of the money to clerics proper. Canon 1362. Seminaries 281, 1206. The bishop should receive into the seminary only boys of legitimate birth, and of such a character that there is good reason to believe they will persevere and work with success in the ecclesiastical ministry. Before they are received they must present testimonials of legitimate birth, of baptism and confirmation, and of conduct. Students who have been discharged from another seminary or from a religious community should not be received unless the bishop has first obtained information also in secret from the superiors and others about the reason of their dismissal, and testimonials as to their character and talents, and has ascertained that there is nothing in their character which would be unbecoming to the sacerdotal state. Superiors and others asked for information are bound by grave obligation of conscience to answer truthfully. Canon 1363, 1207. In the lower grades of the seminary, 1. The religious instruction should occupy the first place, and it is to be adapted to the age and intelligence of the pupils. 2. The students should accurately learn Latin and the vernacular language. 3. In other branches of study the requirements of the clergy of the respective countries is to be taken into consideration. Canon 1364, 1208. The course of philosophy, together with other, allied subjects, is to last at least 2 years. The theological course must last 4 years. Besides dogmatic and moral theology, special attention must be paid to the study of the sacred scriptures, church history, canon law, liturgy, sacred eloquence, and ecclesiastical chant. There are to be also classes of pastoral theology, with practical exercises of how to teach catechism to children and others, how to hear confessions, visit the sick, and assist the dying. Canon 1365, 1209. As professors of philosophy, theology and law, the bishop and seminary board should prefer those who have the degree of doctor in a university, or a faculty recognized by the Holy See, or, if there is question of religious, those who have received a similar title from their major superiors. Philosophy and theology shall be taught by the professors absolutely according to the manner of the angelic doctor, without deviating from his doctrine and principles. 282. The New Canon Law. There should be distinct professors at least for sacred scripture, dogmatic theology, moral theology, and church history. Canon 1366, 1210. The bishop shall see to it that the seminarians, 1. Daily say their morning and night prayers, hold a meditation in common, and assist at Holy Mass. 2. Owe to confession at least once a week, and frequently receive Holy Communion. 3. On Sundays and holidays of obligation assist at solemn Mass and Vespers, serve at the altar and take part in the sacred ceremonies, especially in the cathedral. If this, according to the bishop's judgment, can be done without detriment to discipline and studies. 4. Each year make a retreat for a few days. 5. Once a week attend an instruction on spiritual life. Canon 1367, 1211. The seminary shall be exempt from parochial jurisdiction. The rector of the seminary and his delegate shall have the office of pastor for all persons living in the seminary, with the exception of affairs of the sacrament of marriage, unless the Holy See has passed other regulations for particular seminaries. Canon 1368, 1212. The rector of the seminary, and others under his authority, shall attend to it that the alumni faithfully observe the statutes approved by the bishop, that the plan of studies is accurately followed, and that the students are imbued with a truly ecclesiastical spirit. True Christian politeness should be taught and practiced by the professors for an example to the seminarians. The requirements of hygiene, cleanliness of clothes and person, courtesy, moderation and gravity shall be observed by the students. The rector shall watch that the professors properly attend to the duties of their office. Canon 1369, 1213. Whenever seminarians live outside the seminary for any reason, the bishop shall appoint a priest who is responsible for them, according to Canon 972, 2, Canon 1370, 1214. Disorderly, incorrigible, seditious character shall not be suffered in the seminary, nor, in general, those whose behavior or talents do not make them desirable candidates for the clerical state. Students who advance but little in studies, so that Catholic Schools 283, there is not much hope that they will acquire sufficient learning, shall be dismissed. If a seminarian has been guilty of immorality, or of offenses against Catholic belief, he shall be immediately discharged. Canon 1371, Title 22. Catholic Schools 1215. Catholic children are to be educated in schools where not only nothing contrary to Catholic faith and morals is taught, but rather in schools where religious and moral training occupy the first place. Not only the parents, as mentioned in Canon 1113, but also all those who take their place have the right, and the most serious obligation of caring for the Christian education of the children. Canon 1372, 1216. In every elementary school the children must, according to their age, be instructed in Christian doctrine. The young people who attend the higher schools are to receive a deeper religious knowledge, and the bishops shall appoint priests qualified for such work by their learning and piety. Canon 1373, 1217. Catholic children shall not attend non-Catholic, indifferent, schools that are mixed, that is to say, schools open to Catholics and non-Catholics alike. The bishop of the diocese only has the right, in harmony with the instructions of the Holy See, to decide under what circumstances, and with what safeguards to prevent loss of faith, it may be tolerated that Catholic children go to such schools. Canon 1374, 1218. The Church has the right to establish elementary schools as well as any kind of schools. Canon 1375, 1219. The canonical erection of a Catholic university or of a Catholic faculty is reserved to the Holy See. A Catholic university or faculty, also those in charge of any religious family, must have its statutes approved by the Holy See. Canon 1376, 1220. Academic degrees to be recognized in canon law cannot be conferred except by faculty of the Holy See. Canon 1377, 284. The New Canon Law 1221. Doctors, who have received their degrees legitimately, have the right, outside of sacred functions, to wear a ring with a stone, and the doctor's hat, and in conferring the various offices and ecclesiastical benefices the bishop is to give preference, according to the sacred canons, to those having the doctorate or licentiate, all other things being equal. Canon 1378, 1222. If there are no Catholic elementary or mediate schools, spoken of in Canon 1373, the ordinary should take care to have them established. Likewise, if the public universities are not imbued with the Catholic doctrine and spirit, it is to be desired that in the nation or province a Catholic university be erected. The Catholics should not refuse to contribute according to their means towards the building and maintenance of Catholic schools. Canon 1379, 1223. It is desirable that the ordinary send pious and gifted clerics to universities approved by the Church, in order that they may take up specially the studies of philosophy, theology and canon law and obtain academic degrees. Canon 1380, 1224. The religious teaching of youth in any schools is subject to the authority and inspection of the Church. The local ordinaries have the right and duty to watch that nothing is taught contrary to faith or good morals, in any of the schools of their territory. They, moreover, have the right to approve the books of Christian doctrine and the teachers of religion, and to demand, for the sake of safeguarding religion and morals, the removal of teachers and books. Canon 1381, 1225. Ordinaries of dioceses have the right, either in person or through others, to visit in reference to religious and moral instruction any schools, oratories, summer schools, etc., and from this visitation the schools conducted by a religious community are not accepted unless it is a school exclusively for the professed members of an exempt order. Canon 1382, 1226. In the religious education of the students of any college the rule of Canon 891 must be observed, namely, that the superior of the institution must not hear the confessions of the inmates. Canon 1383, Censorship of Books 285, Title 23, Censorship and Prohibition of Books 1227. The Church has the right to rule that Catholics shall not publish any books unless they have first been subjected to the approval of the Church, and to forbid for a good reason the faithful to read certain books, no matter by whom they are published. The rules of this title concerning books are to be applied also to daily papers, periodicals, and any other publication, unless the contrary is clear from the canons. Canon 1384, Chapter 1, Censorship of Books, 1228. Without previous ecclesiastical approval even laymen are not allowed to publish 1. The books of Holy Scripture, or annotations and commentaries of the same; 2. Books treating of sacred scripture, theology, church history, canon law, natural theology, ethics, and other sciences concerning religion and morals. Furthermore, prayer books, pamphlets and books of devotion, of religious teaching, either moral, ascetic, or mystic, and any writing in general in which there is anything that has a special bearing on religion or morality. 3. Sacred images reproduced in any manner, either with or without prayers. The permission to publish books and images spoken of in this canon may be given either by the proper ordinary of the author, or by the ordinary of the place where they are published, or by the ordinary of the place where they are printed. If, however, any one of the ordinaries who has a right to give approval refuses it, the author cannot ask it of another unless he informs him of the refusal of the ordinary first requested. The religious must, moreover, first obtain permission from their major superior. Canon 1385, 1229. The secular clergy are forbidden without the consent of their bishop, the religious without the permission of the major superior and the bishop, to publish any book on secular topics, or to be a contributor to, or editor, of daily papers, periodicals, booklets, etc. 286. The New Canon Law. In papers, pamphlets and magazines which, as a rule, attack the Catholic religion or good morals, not even laymen should write anything except for a good and reasonable cause, to be approved by the ordinary. Canon 1386, 1230. Matters pertaining in any manner to the causes of beatification and canonization of the servants of God, may not be published without permission from the Sacred Congregation of Rites. Canon 1387, 1231. All books, summaries, booklets and papers, etc., in which the concession of indulgences is mentioned, shall not be published without permission of the ordinary of a diocese. Special permission of the Holy See is required for printing in any language authentic collections of prayers and good works to which the Holy See has attached indulgences, as also a list of the papal indulgences and summaries of indulgences previously collected, but never approved, and summaries to be now made up from the various concessions. Canon 1388, 1232. The collections of decrees of the Roman congregations cannot be published anew without first obtaining permission from the respective congregation, and observing the conditions which the prefect of the congregation may lay down in giving permission. Canon 1389, 1233. In the publication of liturgical books, or parts thereof, and in reprints of litanies approved by the Holy See, the ordinary of the place where the printing is done, or where they are published, must attest that the copy agrees with the original official edition. Canon 1390, 1234. Translations of the Holy Scriptures in the vernacular languages may not be published unless they are either approved by the Holy See, or they are published, under the supervision of the bishop, with annotations chiefly taken from the Holy Fathers of the Church and learned Catholic writers. Canon 1391, 1235. When a work is approved in its original text, the approval does not extend to translations into other languages nor to other editions, wherefore both the translation and the new edition of a work already approved needs a new approval. If various chapters that have appeared in approved magazines, or other periodicals, are collected and published in book form, they are not considered a new edition and do therefore not need a new approval. Canon 1392, Prohibition of Books 287, 1236. In every episcopal curia there should be official censors, who shall examine the works to be published. The examiner should be free from all human respect in the exercise of their office, and shall have before their eyes only the dogmas of the Church and the universal Catholic teaching contained in the decrees of the general councils, in the constitutions and orders of the Holy See, and in the consent of approved doctors. The censors should be taken from both the secular and religious clergy, and should be men of mature age, of tried learning and prudence, who will take the golden mean in approving or rejecting doctrines. The censor must give his opinion in writing. If it is favorable, the ordinary may allow the manuscript to be published. The imprimatur of the bishop is preceded by the opinion of the censor over his signature. Only in extraordinary cases and rare circumstances may, according to the bishop's judgment, the name of the censor be omitted. The author shall never be informed of the name of the censor who is to revise his book before he has given his judgment. Canon 1393, 1237. The permission of the ordinary by which he grants faculty to publish a manuscript shall be given in writing, and shall be printed either at the beginning or the end of a book, magazine, or on pictures, with his name and the date and place of the concession. If permission for publication is to be denied, the reasons should be given to the author unless there are grave reasons why this should not be done. Canon 1394, Chapter 2, Prohibition of Books, 1238. The right and duty to prohibit books for a good reason rests with the Supreme Pontiff for the whole Church, with the particular councils for their territory, with the individual ordinary for his diocese. From the prohibition of inferior authorities recourse may be had to the Holy See, not however, in suspensive, which means that the prohibition must be obeyed until Rome has rescinded the orders of the inferior authority. 288. The New Canon Law. Also the abbot of an independent monastery, and the supreme superior of a clerical exempt religious body, may with their respective council or chapter prohibit books to their subjects for good reasons. The same authority possess other major superiors in union with their council in cases where immediate action is necessary, with the duty, however, to refer the matter as soon as possible to the Supreme Superior. Canon 1395, 1239. Books forbidden by the Holy See are to be considered forbidden everywhere, and in any translation into other languages. Canon 1396, 1240. It is the duty of all the faithful, and especially of the clergy, of ecclesiastical dignitaries, and of men of extraordinary learning, to refer books which they think pernicious to the ordinary or to the Holy See. This duty pertains by special title to the legates of the Holy See, to the local ordinaries, and to rectors of Catholic universities. It is expedient in the denunciation of a book to not only indicate the title of the book, but also, as far as possible, the reasons why a book is thought to deserve condemnation. Those to whom the book is denounced are by sacred duty bound to keep secret the names of those who denounce it. The local ordinaries must, either in person or, if necessary, through other capable priests, watch over the books which are published or sold in their territory. The ordinaries should refer to the Holy See those books which require a more searching examination, also works which for their effective prohibition demand the weight of the supreme authority. Canon 1397, 1241. The prohibition of books has this effect that the forbidden books may not without permission be published, read, retained, sold, nor translated into another language, nor made known to others in any way. The book which has in any way been forbidden may not again be published except after the demanded corrections have been made and the authority which forbade the book, or his superior, or successor, has given permission. Canon 1398, 1242, by the very law are forbidden. 1. Editions of the original text, or of ancient Catholic versins, of the sacred scriptures, also of the Oriental Church, published by non-Catholics, likewise any translations in any language made or published by them. Prohibition of books 289. 2. Books of any writers defending heresy or schism, or tending in any way to undermine the foundations of religion. 3. Books which purposely fight against religion and good morals. 4. Books of any non-Catholic treating professedly of religion unless it is certain that nothing is contained therein against the Catholic faith. 5. Books on the Holy Scriptures or on religious subjects which have been published without the permission required by Canons 1385, 1, NN 1, and 1391, books and leaflets which bring an account of new apparitions, revelations, visions, prophecies, miracles, or introduce new devotions even though under the pretext that they are private, if these books, etc., are published against the rules of the canons. 6. Books which attack or ridicule any of the Catholic dogmas, books which defend errors condemned by the Holy See, or which disparage divine worship, or tend to undermine ecclesiastical discipline, or which purposely insult the ecclesiastical hierarchy, or the clerical and religious states. 7. Books which teach or approve of any kind of superstition, fortune-telling, sorcery, magic, communication with spirits and such like affairs. 8. Books which declare duels, suicide, divorce as licit, books which treat of Masonic and other sects of the same kind, and contend that they are not pernicious, but rather useful to the Church and civil society. 9. Books which professedly treat of impure and obscene subjects, narrate or teach them. 10. Editions of liturgical books approved by the Holy See, but which have been unlawfully changed in some things so that they no longer agree with the editions authorized by the Holy See. 11. Books which publish apocryphal indulgences, or those condemned or recalled by the Holy See. 12. Images of our Lord, of the Blessed Virgin, angels, saints, and other servants of God, which are not in accord with the mind and the decrees of the Church. Canon 1399, 1243, books mentioned in N. 1 of the preceding canon, and books published against the law of Canon 1391, are allowed to those who in any way engage in theological or biblical studies, provided these books are faithful and complete copies of the Reg. 290 the New Canon Law, and do not in their introduction, or in their notes, attack Catholic dogmas. Canon 1400, 1244, cardinals and bishops, both residential and titular, are not bound by the ecclesiastical prohibition of books, provided they use the necessary precautions. Canon 1401, 1245, ordinaries can give permission to their subjects for the reading of books forbidden by the general law of the Code, as well as by decree of the Holy See, for individual books and in individual and urgent cases only. If the ordinaries have obtained from the Holy See general faculty to allow their subjects the keeping and reading of forbidden books, they should give this permission with discretion. Canon 1402, 1246, persons who have obtained from the Holy See the faculty of reading and keeping forbidden books cannot for that reason read and keep books forbidden by their ordinaries, unless the apostolic indult explicitly gives them the faculty to read and keep books forbidden by any authority. Moreover, they are held by grave precept to guard the forbidden books in order that they may not fall into the hands of others. Canon 1403, 1247, book dealers shall not sell, loan, or keep books which professedly treat of obscene matters. Other forbidden books they should not have for sale unless they have obtained permission from the Holy See, nor should they sell them to anyone except they can reasonably judge that the buyer has the right to ask for these books. Canon 1404, 1248. By the permission to read forbidden books no one is exempted from the prohibition of the natural law not to read books which are to the reader approximate occasion of sin. local ordinaries, and others having the care of souls, shall at proper times and occasions warn the faithful of the danger and harm of bad books, especially of those that are forbidden. Canon 1405, Title 24, Profession of Faith. 1249. The following persons are held to make the profession of faith according to the form approved by the Holy See. 1. Those who assist, either with a decisive or a consultative, profession of faith. 291. Vote at a general or particular council, or diocesan synod, before the president of the assembly or his delegate, the president before the council or synod. 2. Those promoted to the dignity of cardinals before the dean of the Sacred College, the first cardinal priest and cardinal deacon, and the chamberlain of the Holy Roman Church. 3. Those promoted to an episcopal see, though titular, or to the government of an abbey, or prelacy nullius, vicariate and prefecture apostolic, before the apostolic delegate. 4. The vicar capitular before the cathedral chapter. 5. Those promoted to an ecclesiastical dignity, or to membership among the canons, before the bishop or his delegate and a chapter. 6. Those appointed to the office of diocesan consultor before the ordinary or his delegate and the other consultors. 7. The vicar general, pastors, and others obtaining any benefice, though removable, to which the care of souls is attached, rectors, professors of sacred theology, canon law and philosophy in seminaries, at the beginning of each scholastic year, or, at least, the beginning of their office, all candidates for subdeaconship, censors of books mentioned in Canon 1393, priests approved for confessions and preaching before they receive faculty to exercise these duties. All these ecclesiastics must take the oath before the bishop or his delegate. 8. The rector of a Catholic university or faculty before the ordinary or his delegate. All professors of a canonically erected university or faculty at the beginning of each scholastic year, or, at least, at the commencement of their office, and those who after a successful examination are to receive academic degrees, before the rector of the university or faculty, or his delegate. 9. Superiors and clerical religious organizations before the chapter or the superior who appointed them, or their delegate. He who relinquishes a former and receives a new office, benefice or dignity, even of the same species, must again make the profession of faith according to the present canon. Canon 1406, 1250. One does not satisfy his obligation of making the profession of faith by doing so through a proxy, or by making it before a layman. Canon 1407, 292. The New Canon Law. 1251. Every custom contrary to the canons under this title of profession of faith is disapproved by law. Canon 1408, Part 5, Benefices and other non-collegiate institutes of the Church. Title 25. Ecclesiastical Benefices. 1252. An ecclesiastical benefice is a juridical being, constituted perpetually by competent ecclesiastical authority, consisting of a sacred office and the right to receive the revenue accruing from the endowment of the office. Canon 1409, 1253. The endowment of a benefice consists either in goods owned by the benefice itself in its juridical capacity, or of certain payments obligatory upon some family or moral person, or of certain voluntary offerings of the faithful, which belong to the rector of a benefice, or so-called stole fees demanded within the limits of diocesan statutes or legitimate custom, or choral distributions to the exclusion of 1/3 part, if all the revenues of a benefice consist in choral distributions. Canon 1410, 1254. Ecclesiastical benefices are called, 1. Consistorial, if they are usually conferred in consistory; others are known as non-consistorial. 2. Secular or religions, inasmuch as they either belong exclusively to the secular or the religious clergy. All benefices erected outside the churches or houses of religious are in case of controversy to be presumed as secular. 3. Double or residential, simple or non-residential, inasmuch as the duty of residence is or is not attached to the benefice, besides the other duties of the respective benefice. 4. Manual, temporary or removable, perpetual or immovable, inasmuch as they are conferred either revocably or perpetually. 5. Curata or non curate, inasmuch as there is or is not attached to the benefice the care of souls. Canon 1411, 1255. Though the following offices and position have some resemblance to the benefices, they do not in law come under the name of benefices. Constitution or erection of benefices 293. 1. Parochial vicariates which are not erected perpetually. 2. Laical chaplaincies, namely such which are not erected by competent ecclesiastical authority. 3. Coadjutor offices, with or without the right of future succession. 4. Personal pensions. 5. A temporary commenda, which consist in the concession to some person of the revenues of a church or monastery in such manner that with the death of the person the revenues fall again to the church or monastery. Canon 1412, 1256. Unless the contrary is evident, the following canons refer only to non-consistorial benefices properly so called. Those offices mentioned in the preceding canon are, therefore, not concerned in the succeeding canons unless the contrary is evident. Canons 147-195, treating of appointment to ecclesiastical offices, are to be observed also in appointment to offices with which a benefice is connected. Canon 1413, Chapter 1, Constitution or erection of benefices. 1257. Consistorial benefices can be erected by the Holy See only. Besides the Roman Pontiff, the ordinaries may erect in their respective territory non-consistorial benefices, saving the exception of Canon 394, 2, which reserves to the Holy See the erection of dignities in the cathedral chapter. Vicars general cannot erect benefices without a special mandate of their ordinary. Cardinals may erect in the church of their title benefices which have not the care of souls attached, unless the church belongs to a clerical exempt community of religious. Canon 1414, 1258. Benefices should not be erected unless their stable and sufficient endowment is assured, from which revenues accrue perpetually in the manner specified in Canon 1410. If the endowment consists in a certain sum of money, the ordinary, after consultation with the diocesan board of administration, spoken of in Canon 1520, shall take care to have the money as soon as possible invested in safe and fruitful real estate or bonds. 294. The Zircaxix Lair. Where a proper endowment cannot be had, it is not forbidden to erect parishes or quasi-parishes, if it can be prudently foreseen that the necessary revenues will be obtained from other sources. Canon 1415, 1259. Before a benefice is erected, the persons, if there be any, who are interested should be called and given a hearing. Canon 1416, 1260. If a benefactor endows a benefice, he may with the consent of the ordinary at the time of foundation attach conditions even contrary to the common law, provided they are not sinful nor incompatible with the nature of the benefice. Once the conditions have been admitted, the ordinary cannot validly suppress or change them, unless there is question of changes favorable to the Church, and the consent of founder or patron, as the case may be, is obtained. Canon 1417, 1261. The erection of benefices is to be made by legal document in which the place is to be defined where the benefice is erected, and the endowment, rights and obligations of the beneficiary are described. Canon 1418, Chapter 2. Union, transfer, division, dismembration, conversion and suppression of benefices. 1262. The union of benefices is 1. Extinctive, if out of two or more benefices one only benefice is created, or one or several are united to another in such a way that they cease to exist. 2. Equally principal, if the united benefices remain the same as they were before without subordination of one to the other. 3. Less principal, or by subjection or accession, when the various benefices remain but one or several are joined in subordination to another. Principal benefice. Canon 1419, 1263. In the extinctive union, the benefice which emerges out of the union of several benefices has all the rights and obligations of the various benefices, and, if they are incompatible, the better and more favorable rights are to be retained. In the equally principal union, each benefice conserves its nature, rights and obligations but by virtue of the effected union. Change of benefices. 295. The titles to the various benefices are conferred on one and the same cleric. In the less principal union, the accessory benefice follows the principal one, so that the cleric who obtains the principal benefice also acquires the accessory and must fulfill the obligations of both. Canon 1420, 1264. A transfer of a benefice means its change from one place to another. Division, when two or more benefices are made out of one. Dismembration, when a part of the territory or of the goods is taken from a benefice and assigned to another benefice, charitable or ecclesiastical institution. Conversion, when a benefice is changed into another kind. Suppression, when it is entirely extinguished. Canon 1421, 1265. To the Holy See is reserved the extinctive union of benefices, their suppression, dismembration, which is done by taking away goods of a benefice without erecting a new benefice, the equally or less principal union of a religious benefice with a secular one, or vice versa, also the transfer, division and dismembration of a religious benefice. Canon 1422, 1266. Local ordinaries, not, however, the vicar capitular nor the vicar general without special mandate, may for reason of necessity or great and evident utility of the Church, effect an equally or less principal union of parish churches among themselves or with a non-curate benefice, provided, however, in the latter case, that in the less principal union of a parish with a non-curate office the non-curate office is considered the accessory. The bishop cannot unite parishes with the mensa of the chapter or the bishop, with monasteries, churches of religious or other moral persons, nor with the dignities and benefices of the cathedral or collegiate church. He can, however, unite the parish with the cathedral or collegiate church situated in the territory of the parish in such way that the revenues of the parish go to the benefit of the cathedral or collegiate church itself, leaving to the pastor or parochial vicar a portion sufficient for his maintenance. A union of benefices cannot be made by the local ordinaries unless the union is made perpetual. Canon 1423, 1267. The ordinaries can never unite any benefices, either with or without the care of souls, to the detriment of those who actually are in possession if they are unwilling, nor unite a bene. 296. The New Canon Law. Fice where someone has the right of patronage with a benefice of free appointment without the consent of the patron, nor the benefices of one diocese to a benefice of another diocese, though both dioceses are united by equally principal union and governed by one and the same bishop, nor exempt benefices, or those reserved to the Holy See, with any other benefices. Canon 1424, 1268. If a parish is united by the Holy See to a religious house for the temporalities only, the religious house has only the right to the revenues of the parish, but it remains a secular parish, and the superior has the right of presenting a priest of the secular clergy to the bishop to be appointed as pastor. In the United States there are, as a rule, no such arrangements. If a parish is by apostolic indult united to a religious house plenary, the parish belongs to the religious and the superior has the right to nominate a priest of the community to act as pastor, but the bishop has the right to examine and institute him, and he is subject to the bishop as correction and visitation in affairs relative to the care of souls, as specified in Canon 631, confer also Canon 533, 1, n. 4, Canon 1425, 1269. For reason of necessity or utility of the Church, the ordinary may transfer the secular parochial benefice from one locality to another in the same parish. Other benefices he can transfer only when the churches in which they were founded have collapsed and cannot be repaired. They are to be transferred to nearby churches. In the United States other benefices besides parishes are extremely rare. Canon 1426, 1270. Division of parishes is subject to the following rules. The ordinaries can, for a just canonical cause, divide any parishes, also against the will of the rectors and without the consent of the people, by erecting a perpetual vicariate or a new parish, or by dismembering the same and giving part to another already established parish. There is only one canonical reason for dividing or dismembering a parish, namely, either too great a difficulty for the people to go to the parish church, or too numerous a congregation, whose spiritual welfare cannot be taken care of by the appointment of assistants to the pastor. The ordinary dividing the parish must assign to the new parish or perpetual vicariate an appropriate portion of goods, saving the law of Canon 1500, these, unless they can be had from change of benefices 297, other sources, are to be taken from any of the revenues of the mother church, leaving, however, a sufficient amount for the existence of the mother church. If the perpetual vicariate, or the new parish, is endowed by the revenues of the parish from which they were separated, they must show respect to the mother church in the manner to be pointed out by the ordinary. The bishop cannot, however, reserve to the mother church the exclusive right to administer the sacrament of baptism. If a parish belonging to the religious is divided, the new parish or perpetual vicariate does not belong to the religious. Likewise, when a parish in which the right of patronage exists is divided, the new parish is free from the patronage. Canon 1427, 1271. The local ordinaries should perform the union, transfer, division, dismembration of benefices by authentic document, and should before action is taken consult the chapter or diocesan consultors and persons interested. The union, transfer, division and dismembration of benefices made without the canonical reason is null and void. Against the ordinary who unites, divides, etc., benefices, recourse may be had to the Holy See in devolutivo. His orders must be obeyed in the meantime. Canon 1428, 1272. The bishop cannot impose on any kind of benefices perpetual pensions, or pensions to last for the lifetime of the pensionary, but he may, when conferring the benefice, impose for a just cause, to be stated in the very act of conferring the benefice, temporary pensions which last for the life of the person on whom the benefice is conferred. The pension must not be so high as to deprive the possessor of the benefice of proper support. The bishop cannot burden with pensions parochial benefices except in favor of the pastor or parochial vicar of that same parish when they go out of office. This pension, however, must not exceed 1/3 of the revenue of the parish, after expenditures and uncertain revenue have been deducted. Pensions imposed on benefices, either by the Roman Pontiff or by others, cease with the death of the pensionary, who cannot transfer his pension to another unless this faculty has been expressly conceded to him. Canon 1429, 1273. Benefices to which the care of souls is attached can 298. The new canon law not be turned by the bishop into non-curate benefices, nor can he convert religious benefices into secular, nor secular into religious benefices. Simple benefices, on the contrary, can be turned into curate benefices, provided there are no contrary explicit conditions of the founder. Canon 1430. Chapter 3. Conferring of benefices. 1274. Canons 1431 to 1447 which treat of the conferring of benefices have reference to the various ecclesiastical position throughout the entire church. In the United States there are practically no benefices except those of bishops and pastors. The Holy See only appoints bishops. The pastors are appointed by the bishop. Chapter 4. The right of patronage. 1275. Canons 1448 to 1471 treat of the right of patronage which denotes the privileges and duties which the law grants to Catholics who found a church, chapel, or a benefice. The principal privilege of the founder and his heirs consists in the right to choose the priest who is to be in charge of the church or benefice. If no canonical disability stands in the way, the ordinary is obliged to appoint the priest presented by the patron. While the code does not abolish the acquired rights of patrons, if they are not willing to sacrifice their rights in the interest of the church, no one can for the future validly acquire the right of patronage by building or endowing a church, chapel, etc. The bishop may, however, admit the foundation of a benefice under the condition that for the first time it may be given to the cleric who founds the benefice, or, in case of a layman, to the priest whom he designates. To encourage pious foundations, the bishop should grant to founders spiritual benefits, for example, a definite number of holy masses to be said each year for their intentions. Canons 1450 to 1451. In the United States, the right of patronage has practically been unknown, due to the fact that in most instances churches and chapels were not built or endowed by individual Catholics but by the contributions of many people. Rights and Duties of Beneficiaries 299. Chapter 5, Rights and Duties of Beneficiaries 1276. Every beneficiary, after having legally taken possession of his benefice, enjoys all the spiritual and temporal rights attached to the benefice. Canon 1472, 1277. Though the beneficiary has goods of his own from which he could live, he has the right to use the revenues of the benefice in such quantity as is necessary for his proper support. The superfluous revenues are to be used for the benefit of the poor or of charitable institutions. Canon 1473, 1278. Canons 1474 to 1483 have reference to benefices of a character different from our parochial benefices. Parishes are almost the only benefices in existence in the United States. How much of the revenue the pastor may use for his support and for his personal expenditures is regulated by the statutes of the individual dioceses, which also determine other matters relative to the temporal administration of the parishes. Chapter 6, Resignation and Exchange of Benefices 1279. The ordinary shall not admit the resignation of a benefice by a cleric in major orders, unless he knows that he has sufficient means of support from other sources. Canon 584 provides that the parochial benefice becomes vacant 1 year from the first profession, other benefices 3 years after such profession, if the beneficiary should have joined a religious community. Canon 1484, 1280. The resignation of the benefice under the title of which a cleric was ordained is invalid unless explicit mention is made that he was ordained under its title, and that with the consent of the ordinary another legitimate title of ordination has been substituted. Canon 1485, 1281. The ordinary cannot admit a resignation for the benefit of another, or under a condition which affects the conferring of the benefice or its revenues. In the case only where two clergymen contest in the ecclesiastical court the legal claim to the benefice, may one of the contestants relinquish his claim in favor of the other. 300. The New Canon Law. The mutual exchanging of two benefices cannot be made validly except for reason of the necessity or utility of the Church with the consent of the ordinary, and also of the patron if there is question of a benefice over which another has the right of patronage, and provided no injury is done to a third party. The vicar capitular cannot give this permission and the vicar general needs a special mandate of the bishop. Canon 185 requires, however, that the renunciation in order to be valid must be made by the resigning party either in writing, or orally before two witnesses, or also by proxy authorized by special mandate. The ordinary shall within 1 month either grant or deny his consent. The exchange becomes valid from the moment in which the ordinary gives his consent. If the conferring of one or both benefices is reserved to the Holy See, the ordinary cannot allow the exchange. Canon 1486, 1282. If the benefices to be exchanged are unequal, they cannot be made equal by reservation of revenue, or payment of money, or anything else having the value of money. Exchange cannot be made between more than two beneficiaries. Canon 1488. Title 26. Other non-collegiate institutes of the Church. 1283. Hospitals, orphan asylums, and other similar institutes destined for works of religion or charity, either bodily or spiritual, may be erected by the ordinary, and through his decree they obtain legal personality. The ordinary of the diocese shall not approve these institutions unless the purpose of their foundation is really useful and they be endowed sufficiently for their purpose. The rector of such an institution assumes the administration of its goods in accordance with the laws of the foundation. He has the same duties and rights as other administrators of ecclesiastical goods. Canon 1489, 1284. If a private individual is the founder of a hospital, orphan asylum, etc., he should in the document of foundation securely determine the purpose, endowment, administration and government, the use of the income, and to whom the goods are to go in case the institution is discontinued. Temporal Goods of the Church 301. There shall be made 2 copies of this document, one to be kept in the archives of the institution, the other in the episcopal curia. Canon 1490, 1285. The ordinary of the diocese has the right to visit all such institutions, though they have been made a legal person and given in charge of exempt persons. If they have no separate legal existence but are attached to a religious house, the bishop has complete jurisdiction in the case of a diocesan congregation. If attached to a congregation of papal law, the bishop has the right to watch over the religious teaching, exercises of piety, administration of the sacraments and moral conduct in these institutions. Canon 1491, 1286. Though pious institutes should be exempt from the jurisdiction and visitation of the bishop either by foundation, or prescription, or apostolic indult, the bishop has the right to demand a financial statement. Every contrary custom is disapproved. If the founder of an institution wants the administrators to be free from making financial statement to the bishop, the foundation shall not be accepted by the bishop. Canon 1492, 1287. The local ordinary shall attend to it that the pious requests of the faithful expressed in the foundation of an institution are complied with. Canon 1493, 1288. Without permission of the Holy See these institutions cannot be suppressed, united, or turned to purposes other than that for which they were intended by the founder, unless other provisions are made in the document of foundation. Canon 1494, Part 6. Temporal Goods of the Church 1289. The Catholic Church and the Apostolic See have by their very nature the right freely and independently of the civil power to acquire, retain and administrate temporal goods for the prosecution of their proper purposes. Individual churches, and other moral persons, constituted legal persons by the authority of the Church, have the right to acquire, retain and administrate temporal goods according to the sacred canons. Canon 1495, 1290. The Church has also the right independently of the civil authorities to demand of the faithful the necessary means. 302. The New Canon Law. For the conducting of divine worship, the maintenance of the clergy and of others working for the Church, and for all other purposes proper to the end for which the Church is established. Canon 1496, 1291. The temporal goods, both movable and immovable, and the temporal rights which belong either to the universal Church, or to the Apostolic See, or to another legal person in the Church, are ecclesiastical goods. These goods are called sacred, if they have been destined for divine worship by consecration or blessing; precious, if they have great value either on account of art, or history, or material. Canon 1497, 1292. In the following canons the term Church signifies not only the universal Church, or the Apostolic See, but also every legal person of the Church, unless the contrary is apparent from the context or from the very nature of the law. Canon 1498, Title 27, Acquisition of Ecclesiastical Goods. 1293. The Church may acquire temporal goods by all just means, of both the natural and positive law, by which others may acquire goods. The ownership of the goods belongs under the supreme authority of the Apostolic See to that legal person which rightfully acquired these same goods. Canon 1499, 1294. If the territory of a legal ecclesiastical person is divided so that either a part of it is united to another legal person, or a distinct legal person is constituted by the separation, the common goods which were destined for the benefit of the entire territory, and also the debts contracted for the whole territory, shall be divided with proper proportion and in all fairness by the competent ecclesiastical authority which orders the divison. Due regard shall be had for the intentions of founders and benefactors, for acquired legal rights and for special laws governing certain legal persons. Canon 1500, 1295. If a legal person ceases to exist, its goods shall belong to the immediate superior legal person, saving always the will and intentions of founders and benefactors. Lawfully ac. Acquisition of ecclesiastical goods 303. Acquired rights and the special laws which govern the extinct person. Canon 1501, 1296. The payment of the decimi and primitiae shall be governed by the special laws and laudable customs of each country. Canon 1502, 1297. Private individuals, both clerics and laymen, are forbidden to collect alms for any charitable or ecclesiastical institution or purpose without the written permission of either the apostolic see or of their own ordinary and the bishop of the place where the alms are to be collected. Canons 621-624 regulate the collection of alms by religious. Canon 1503, 1298. All churches or benefices subject to the jurisdiction of a bishop must annually pay to the bishop the cathedraticum, or a moderate tax as a token of subjection, to be determined by the bishop according to Canon 1507, 1, unless it has already been fixed by ancient custom. Canon 1504, 1299. The bishop can impose for reason of special needs of the diocese an extraordinary moderate tax on all beneficiaries, both of the secular and the religious clergy, besides the seminary assessment mentioned in Canons 1355 and 1356, and the pensions spoken of in Canon 1429. Canon 1505, 1300. Other taxes for the benefit of the diocese or a patron the bishop can impose on churches, benefices and other ecclesiastical institutions, only at the time of foundation or consecration. No tax can be imposed on mass stipends, whether given in the ordinary way or by the foundation of masses. Canon 1506, 1301. Saving the rules laid down in Canons 1056 and 1234, the taxation of various acts of so-called voluntary jurisdiction, which means the concession of dispensations and other favors, and for the execution of rescripts of the Holy See, or on occasion of the administration of the sacraments and sacramentals, may be fixed for the whole ecclesiastical province by the provincial council or in a meeting of the bishops of the province, but such regulation of taxes shall not have any force unless first approved by the Holy See. The taxes for judicial acts are laid down in Canon 1909. Canon 1507, 1302. Prescription by means of which a person may acquire rights, or free itself from obligations, is accepted by the Church in reference to ecclesiastical goods in the manner in 304 the New Canon Law, which the civil laws of the respective countries admit prescription, saving the exceptions contained in the following canons. Canon 1508, 1303, not subject to prescription are, 1. The rights and duties of the divine law, both natural and positive. 2. Rights which can be obtained only by apostolic indult. 3. Spiritual rights of which the laymen are incapable, if there is question of prescription in favor of lay people. 4. The fixed limits of the territory of ecclesiastical provinces, dioceses, parishes, vicariates and prefectures apostolic, abbeys and prelacies nullius. 5. Stipends and obligations of masses. 6. In ecclesiastical benefice without a title to the same. 7. The right of visitation and obedience in such manner that the subjects cannot be visited by any prelate and are no longer subject to any prelate. 8. The payment of the cathedraticum. Canon 1509, 1304. Sacred objects which are in the dominion of private persons can be acquired by private individuals by right of prescription, but they may not use these objects for profane purposes. If they have lost the consecration or blessing, they may be freely acquired also for profane, not, however, for indecent purposes. Sacred objects which are not in possession of private individuals can be prescribed by a legal ecclesiastical person against another legal ecclesiastical person, not, however, by private individuals. Canon 1510, 1305, Immovable and movable precious goods, rights and actions, both personal and real, belonging to the Apostolic See are prescribed by a space of 100 years. Goods and rights belonging to another ecclesiastical legal person are prescribed by a space of 30 years. Canon 1511, 1306. No prescription is valid unless it is based on good faith, not only in the beginning of possession but during the whole time required for prescription. Canon 1512, 1307. He who can either by natural or by ecclesiastical law freely dispose of his goods, may relinquish them in favor of pious institutions, either by donation or by last will. In a last will made in favor of the Church, the formalities, acquisition of ecclesiastical goods 305 of the civil law should be complied with, if possible. If they were omitted, the heirs should be admonished to fulfill the will of the testator. Canon 1513. The present canon indirectly settles the dispute as to the obligation of heirs to fulfill the last will made in favor of some ecclesiastical institution. If the last will was invalid for lack of the formalities prescribed by the civil law, the canon does not impose a strict obligation on the heirs but wants them to be admonished to fulfill the will of the testator. 1308. The will of the faithful who leave their goods by donation or last will to pious institutions should be most faithfully executed, also in reference to the manner desired by the giver and the administration and application of the goods, saving the law of Canon 1515, 3, Canon 1514, 1309. The ordinaries are the executors of all bequests made in favor of pious institutions, either by donation or last will. By virtue of this right the ordinaries have the power and obligation, also by way of visitation, to see to it that the pious intentions are complied with, and other, delegated, executors must give an account to the bishop of the exercise of their office. If there are any clauses added to the last will derogatory to this right of the bishop they are not to be considered. Canon 1515, 1310. The cleric or religious who has, either by way of donation or by last will, received goods in trust for pious purposes, must notify the ordinary and indicate to him all such goods, both movable and immovable, with the obligations attached to them. If the donor has explicitly and absolutely forbidden to refer the matter to the ordinary, the cleric or religious shall not accept the trust. The ordinary must demand that the goods received in trust are safely invested and watch over the fulfillment of the pious intentions of the testator, according to Canon 1515. If a religious is put in trust of goods left in favor of any church of the diocese, or for the benefit of residents or pious works in the diocese, the ordinary spoken of in the two preceding paragraphs of this canon is the ordinary of the diocese, otherwise the major religious superior. Canon 1516, 1311. The reduction, changing, commutation of last wills. 306. The new canon law. Wills, which is to be made only for just and necessary causes, is reserved to the Holy See, unless the founder has explicitly given this power to the local ordinary. If, however, the execution of the imposed obligations has become impossible on account of a decrease in the revenue, which was not caused by any fault of the administrators, the ordinary, after having heard the parties interested, and trying to adhere as much as possible to the will of the deceased founder, may reduce the obligation according to the laws of equity. The reduction of masses, however, is reserved exclusively to the Holy See. Canon 1517, Title 28. The administration of ecclesiastical goods. 1312. The Roman Pontiff is the supreme administrator and dispenser of all ecclesiastical goods. Canon 1518, 1313. The local ordinary has the duty to faithfully watch over the administration of all ecclesiastical goods in the territory of his jurisdiction, except those exempted from his authority. He may, however, have acquired jurisdiction even over exempt goods by legal prescription, Having due regard to the rights, legitimate customs and circumstances, the ordinary shall, within the limits of the common law, issue opportune instructions for the administration and business transactions concerning all ecclesiastical goods. Canon 1519, 1314. In every diocese the bishop shall establish a board of administrators which is to consist of the bishop as president and 2 or more qualified men, who should, as far as possible, be familiar also with the civil law relative to goods and property. The members of the board are to be appointed by the bishop after consultation with the cathedral chapter or the diocesan consultors. If by special law or by custom sufficient provision is made already for administration by a similar board, it will suffice. Persons related to the bishop by blood relationship, or affinity in the first and second degree, cannot be appointed to the office of administrator, except by indult of the Holy See. The ordinary shall not omit to consult the Board of Administrators in affairs of great importance. The vote of the board, however, is only consultative, unless the common law in some cases, Ecclesiastical Goods 307, explicitly states that it is decisive, or the document of foundation of some benefice gives such a vote to the board. The members of the board shall take an oath before the ordinary for the faithful attendance to their office. Canon 1520, 1315. Besides the diocesan board of administrators, the bishop shall appoint good and conscientious men for the administration of goods belonging to a church or charitable institution which has no administrator by law, neither by the special provision of a founder. They should be in office for 3 years, unless the circumstances of the place make other arrangements advisable. If laymen have part in the administration of ecclesiastical goods, either by legitimate title of foundation, or by the will of the bishop, the administration must be entirely transacted in the name of the church, and the ordinary has the right of visitation, of demanding an account, and of prescribing rules for the manner of administration. Canon 1521, 1316. The administrators mentioned in the preceding canon must, before entering upon their office, 1. Take an oath before the bishop or the dean of the district that they will faithfully attend to the administration. 2. Make an accurate new inventory of all immovable and movable goods of any kind, with their description and valuation, subscribed to by all the administrators. If they use an old inventory, those goods that were lost as well as those acquired since it was made must be noted or added to it. Of this inventory 1 copy is to be kept in the archives of the administration, and another in the archives of the episcopal curia. In each copy shall be noted any change which the goods of the church or institution may suffer. Canon 1522, 1317. The administrators shall fulfill their office with the same solicitude as exercised by the father of a family, and they shall therefore, 1. Watch that the ecclesiastical goods confided to their care do not get lost or suffer damage in any way. 2. Observe the rules of canon law, as well as the civil law, and the special regulations imposed either by the founder or donor and the legitimate authority. 3. Collect the revenue due to the institution, place the money safely, and spend it according to the mind of the founder and the existing laws and regulations. 308 The New Canon Law. 4. The money of a church which is over and above expenditures, and which can be usefully invested, shall, with the consent of the ordinary, be invested for the benefit of the church. 5. They shall keep the accounts of income and expenditures in good order. 6. Put in good order the documents and papers which serve as proof of the rights of the church and carefully keep them in the archives or in the safe of the church. Authentic copies of these should, as far as possible, be made and kept in the archives of the episcopal curia. Canon 1523, 1318. All administrators of ecclesiastical goods, and especially priests and religious, must pay the workmen whom they employ good and fair wages, and must see to it that at a convenient time they are free for prayer, must not in any way dissuade them from their domestic duties and thrift, and not impose on them more work than their strength can bear, nor work which does not agree with their age and sex. Canon 1524, 1319. Each year all administrators, both clerics and laymen, are bound to give a financial statement to the bishop. Custom contrary to this obligation is disapproved in law. If by special law financial statement has to be made to certain specified persons, the ordinary or his delegate must nevertheless be admitted to inspect the report, otherwise the administrators have not satisfied their duty. Canon 1525, 1320. The administrators shall not start a lawsuit in the name of the church concerning church goods unless they have previously obtained the bishop's consent in writing, or the dean's in urgent cases. The dean shall at once inform the ordinary of the case. Canon 1526, 1321. Administrators act invalidly in actions which exceed the limits of ordinary administration, unless they first obtain the bishop's consent in writing. The church is not held to the contracts made by administrators without the permission of the competent superior, except when, and in as far as, it has turned to its advantage. Canon 1527, 1322. Administrators who, even though not obliged to the administration by reason of the benefice or office, drop the office of administrator which they had explicitly or tacitly accepted and cause by their withdrawal damage to the church are held to restitution. Canon 1528. Contracts 309, Title 29, Contracts. 1323. The civil law on contracts and payments of all kinds is to be observed also by virtue of canon law, with the same effects of licitness, invalidity, etc., in contracts concerning ecclesiastical goods, unless the civil law in some of its rules is contrary to the divine law, or the canon law explicitly lays down other conditions for certain contracts. Canon 1529, 1324. For the alienation of immovable ecclesiastical goods and movable goods which can be preserved, the following is required: 1. A valuation to be made in writing by conscientious experts. 2. A just cause which consists either in urgent necessity or evident utility to the church or charitable institutions. 3. Permission of the legitimate superior without which the alienation is invalid. Other opportune precautions, which the ecclesiastical superior should demand according to the circumstances of the case, must be observed in order that no damage may come to the church. Canon 1530, 1325. The goods must not be disposed of for less than they were appraised. The sale is to be done by public auction, or, at least, to be announced publicly, unless circumstances make a different course advisable. The goods should be sold to the one who, all things considered, offers the better price. The money obtained from the sale of the goods shall be carefully placed in safe and useful investments. Canon 1531, 1326. The legitimate superior for the granting of permission to alienate church property is the Holy See of their execution. 1. Of precious goods, confer Canon 1497 as to the meaning of res preciosa. 2. Of goods which exceed in value 30,000 francs, about $6,000. If there is question of goods which do not exceed in value 1,000 francs, about $200, the ordinary may give permission after having heard the board of administrators and the persons interested, unless the matter is of very small value. If there is question of goods valued at between 1,000 and 30,000 francs, the ordinary may give permission. 310. The new canon law, provided he obtains the consent of the cathedral chapter or the diocesan consultors and the board of administration, and of those interested. If there is question of disposing of goods which can be sold in parts, it is necessary when asking for permission or consent to state what part or portion was sold before, otherwise the permission is invalid. Canon 1532, 1327. The formalities demanded by Canons 1530 to 1532 are required not only in an alienation properly so called, but also for any contract by which the condition of the church becomes worse. Canon 1533, 1328. The church has the right of personal action against him who without due formalities alienated ecclesiastical goods and against his heirs, a right of real action, if the alienation was invalid, against any possessor of illegally sold goods, The buyer has the right to sue the person who illegally sold him church goods. Action can be brought against the invalid alienation of ecclesiastical goods by the person who sold them, by his superior, or their successors in office, and by any cleric assigned to the church which suffered harm. Canon 1534, 1329. The prelates and rectors shall not dare to make donations from the movable goods of their churches except in small amounts sanctioned by legitimate custom of the place, and only for reasons of just remuneration, or piety, or Christian charity. Otherwise the donations can be recalled by their successors in office. Canon 1535, 1330. Unless the contrary is proved, it is to be presumed that donations given to rectors of churches, also to rectors belonging to religious communities, are given to the church. A donation given to the church cannot be refused by the rector or the superior without permission of the ordinary. If a donation to the church has been illegally refused, action may be instituted for restitutio in integrum, or for indemnity on account of the loss the church has suffered. A donation made to the church and lawfully accepted by the same cannot be recalled by the benefactor on account of ingratitude of the prelate or rector. Canon 1536, 1331. Sacred objects shall not be loaned for purposes repugnant to their nature. Canon 1537. Contracts 311, 1332. If the goods of a church are for good reasons to be placed under mortgage or similar obligation, or debts are to be contracted, the superior who has according to Canon 1532 the right to grant permission, shall insist that previously all parties interested are heard, and attend to it that the debts are paid as soon as possible. The ordinary should for this purpose determine how much is to be paid off annually. Canon 1538, 1333. In the sale or exchange of sacred objects the price must not in any way be raised on account of their consecration or blessing. Administrators may change notes payable to bearer into other investments at least equally safe and fruitful, without, however, any kind of barter, and with the consent of the ordinary and the diocesan board of administrators and the parties interested. Canon 1539, 1334. The immovable goods of the church must not be sold or rented to the administrators of the same church, or to persons related to them in the first and second degree of consanguinity or affinity, without special permission of the local ordinary. Canon 1540, 1335. Land belonging to the church should not be rented except by public auction, or other public announcement, and conditions are to be added to the contract concerning the guarding of the boundaries, proper cultivation of the soil, and payment of the rent, all of which should be secured by legal document. In renting ecclesiastical goods the following rules are to be observed. 1. If the value of the renting exceeds 30,000 francs and lasts over 9 years, the beneplacitum of the Holy See is required. If the renting does not extend over 9 years, the rule of Canon 1532, 3, is to be followed. 2. If the value is between 1,000 and 30,000 francs and the renting extends over 9 years, Canon 1532, 3 rules. If not above 9 years, 2 of the same canon. 3. If the value does not exceed 1,000 francs and the renting extends over 9 years, Canon 1532, 2, is to be observed. If it does not extend over 9 years, it may be done by the legitimate administrators, having first notified the bishop. Canon 1541, 1336. In a lease of ecclesiastical property the lessee cannot purchase the canonical portion of the fruits of the land, due to 312 the new canon law. The Church, without permission of the legitimate ecclesiastical superior spoken of in Canon 1532, if he buys this portion he must at least pay as much money to the Church as the portion is worth. Proper security is to be demanded of the lessee for the specified portion of the produce and other conditions. In the document itself granting the lease, in canon law for at least a period of 10 years, it should be stated that the ecclesiastical court is to be the arbitrator in disputes that may arise, and that the improvements of the property are to remain attached to the property. Canon 1542, 1337. If goods are loaned which are consumed by use in such a manner that the other becomes at once the owner and they are to be returned by goods of the same kind, a contract which theologians call mutuum, nothing can be asked by reason of the contract itself. In an ordinary loan, however, of goods which are consumed by use it is not in itself unlawful to make an agreement for a legal interest, unless the interest is too high, but agreement for higher interest than the law allows may be made if there is a just and proportionate reason for such a demand. Canon 1543, Title 30, Pious Foundations, 1338. By the name of pious foundations are meant temporal goods given to a legal ecclesiastical person in any manner, with the perpetual obligation, or an obligation of many years to say annually some masses, or perform other specified functions, or do some works of piety and charity with the revenue of the donated goods. The foundation when legitimately accepted has the nature of a bilateral contract. Duot faces, Canon 1544, 1339. It is the right of the bishop to prescribe the regulations concerning the quantity of the endowment for a less than which no pious foundation can be accepted, and the distribution of the income of the foundation. Canon 1545, 1340. The written consent of the ordinary of the diocese is required for the acceptance of such foundation by legal persons. The ordinary should not grant the consent unless he has previously ascertained that the church or institution can satisfy. Pious Foundations 313. The old foundations as well as the new one, above all he shall take care that the income from the foundation correspond to the imposed obligations, according to the custom of the respective diocese. In the accepting, constituting and administrating of the foundation the patron of a church has no rights. Canon 1546, 1341. Money and movable goods given for the endowment of a foundation are, by authority of the bishop, to be put in a safe place until they can be invested for the benefit of the foundation. The parties interested and the diocesan board of administrators are to be consulted before the bishop invests the money. The obligations attached to the foundation are to be specified individually. Canon 1547, 1342. Foundations, though made orally, shall be put in writing. One copy is to be kept in the archives of the episcopal curia, another in the archives of the place where the foundation is placed. Canon 1548, 1343. Besides the regulations of Canons 1514 to 1517 and 1525, there shall in every church a list be made of the obligations imposed by pious foundations, which the rector shall keep in a safe place. Besides the book in which the manual mass stipends are entered, another record is to be kept of perpetual or temporary foundation masses, which record is to be guarded by the rector. The application of the masses and the amount of stipends received must be noted in this book, and account is to be given to the ordinary concerning these masses. Canon 1549, 1344. If there is question of pious foundations in churches of exempt religious, though they be parish churches, the rights and duties of the local ordinary, of which Canons 1545 to 1549 treat, belong exclusively to the major superior of the religious. Canon 1550, 1345. The reduction of obligations imposed by pious foundations is exclusively reserved to the Holy See, unless the document of foundation explicitly gives to the bishop more rights. The masses, however, can never be reduced by the bishop, as Canon 1517, 2, rules. The indult to reduce foundation masses does not give power to reduce other masses due by contract, nor other offices and duties imposed by the pious foundations. 314. The New Canon Law. The general indult to reduce the obligations of pious foundations is to be understood in the sense that the person possessing the indult reduce other obligations rather than masses, unless there are reasons to prove that the indult was given for reduction of masses. Canon 1551. The Fourth Book, Canonical Trials, Part 1. Procedure in court. 1346. By the name of ecclesiastical procedure are understood the discussion and settlement before the ecclesiastical tribunal of controversies over matters in which the Church has the right to judge. The subject matter of canonical trials are: 1. The prosecution or vindication of the right of physical, or moral, persons, or to declare the actions of these persons legal. This is called judicium conscientiam. 2. Offenses, in order to inflict or declare a penalty. This is called a judicium criminal. Canon 1552. 1347. The Church by her own exclusive right judges. 1. The cases which refer to spiritual matters, or to temporal matters annexed to spiritual. 2. The violation of ecclesiastical laws and all matters in which sin may be committed, in as far as the definition of guilt and the infliction of ecclesiastical punishment for the sins is concerned. 3. All cases of persons who enjoy the privilege of the ecclesiastical forum, in accordance with Canons 120, 614 and 680, in those cases in which the civil authority is competent as well as the Church, and which are called matters of mixed forum, there holds the right of prevention, which means that whoever first calls the case to its tribunal, has the right to judge the case. Canon 1553. 1348. The person who takes a case of the mixed forum to the secular court after it had been started by the ecclesiastical judge, can be punished, not however with censures, and he is deprived of the right to act in the ecclesiastical forum against the same person in the same or connected matter. Canon 1554. 1349. The tribunal of the Congregation of the Holy Office proceeds according to its own manner and arrangement and retains its own proper custom, and also the inferior tribunals must. 315. 316. The new canon law. Follow the rules given by the Holy Office in cases which belong to that congregation. The other tribunals must observe the laws of the following canons. In the trial for the dismissal of religious, the laws of Canons 654-668 are to be followed. Canon 1555, Section 1. Trials in general. 1350. Canons 1556-1924 treat of the details of economical trials of all kinds, and before various tribunals of the Church. Section 2. Special rules to be observed in certain specified trials. Title 18. Manner of avoiding canonical trial. Chapter 1. Transaction. 1351. As it is very desirable that canonical trials between the faithful be avoided, the judge shall exhort the parties who apply to him for settlement by process of law of a controversy over some private affair, to come to an agreement. If there is some hope that they may come to an understanding, the judge can issue this invitation either before the parties are called to court, or when they appear in court for the first time, or, finally, at any stage of the trial where he thinks the invitation to be more efficacious and opportune. It is as a rule more appropriate for the dignity of the judge not in person to invite the parties to amicable settlement, but rather to commit this to some priest, especially to one of the synodal judges. Canon 1925, 1352. In this transaction, or friendly settlement, the rules of the civil law of the place where the transaction takes place, should be observed, except in cases where the civil law is contrary either to the divine or the ecclesiastical law, and the following canons shall also be observed. Canon 1926, Compromise by Arbitration 317, 1353. The transaction cannot validly be made either in criminal or contentious cases in which there is question of dissolving the marriage bond, or question of matters pertaining to benefices if the very title to the benefice is the subject of the dispute, or of spiritual matters, if payment with temporal goods intervened, unless the legitimate authority gives permission for settlement. If the dispute concerns temporal goods of the Church, or goods which though annexed to spiritual objects can nevertheless be considered apart from their spiritual aspect, transaction can take place, provided the formalities prescribed by law for the alienation of ecclesiastical goods are observed where the subject matter necessitates this. Canon 1927, 1354. The effect of a transaction which has been successfully brought to conclusion is called compositio, adjustment, or concordia, agreement, the expenditures entailed in the transaction shall be equally divided between the parties, unless the contrary has been explicitly decreed. Canon 1928. Chapter 2. Compromise by arbitration. 1355. In order to avoid judicial trials, the parties may enter into an agreement by which the controversy is committed to the judgment of one or several men, who shall adjust the question either according to the rules of law, or discuss and settle it without the formalities of law according to the rules of equity. In the first case they are called arbitri, in the other arbitratores. Canon 1929, 1356. The rules of Canons 1926 and 1927 must be applied also to the compromise of arbitration. Canon 1930, 1357. In ecclesiastical cases, laymen and those who are under excommunication or infamy of law, after a condemnatory or declaratory sentence, cannot validly exercise the office of arbiters. Religious shall not accept the office of arbiters without permission of their superior. Canon 1931, 1358. If the parties do not wish to consent either to the transaction, nor to settlement by arbitri or arbitrators, the controversy must be decided by a formal trial outlined in the first section of the fourth book of the Code. Canon 1932, 318. The New Canon Law, Title 19, Criminal Trials. 1359. Offenses which fall under criminal procedure are the public offenses. The offenses which are to be punished by penal sanctions, contained in Canons 2168 to 2194, are excepted from the prostra of criminal trials. In offenses of the mixed forum the ordinaries should not, as a rule, proceed against the offender if he is a lay person and public justice has been sufficiently satisfied by punishment inflicted by the civil authority. Penances, penal remedies, excommunication, suspension, interdict, can be inflicted also outside the ecclesiastical court by the way of precept, provided the offense is certain. Canon 1933. Chapter 1. Accusation and Denunciation. 1360. The action of accusation of an offender is exclusively reserved to the promoter of justice. Canon 1934, 1361. Any of the faithful have at all times the right to denounce the offense of another for the purpose of asking for satisfaction, or for reparation of damages, or also for the sake of justice and the reparation of scandal and sin. The obligation of denunciation becomes imperative if one is obliged to it by law or by special legitimate precept, or by the very law of nature on account of danger to faith and morals or on account of any other public evil. Canon 1935, 1362. The denunciation must be made in writing and signed by the denouncing party, or orally, before the ordinary of the diocese, or the chancellor of the curia, the dean, the pator, but if made orally, it shall be put in writing and immediately forwarded to the ordinary. Canon 1936, 1363. The person who denounces an offense must aid the promoter of justice in the obtaining of proofs of the offense. Canon 1937, 1364. In cases of injuries and defamation the criminal trial cannot be instituted against the offender unless denunciation or complaint has first been made by the injured party. Inquisition 319. If, however, there is question of grave injury or defamation committed against a cleric or religious, especially one in dignity, or by a cleric or religious against another, criminal action can be instituted also ex officio without denunciation or complaint. Canon 1938. Chapter 2. Inquisition. 1365. If the offense is neither notorious nor altogether certain, but has become known from rumor and public talk, or by denunciation, or by complaint of damages, or by a general investigation made by the ordinary, or for any other reason, a special investigation, called in law inquisition, must be made before summoning the supposed offender to court, in order to ascertain whether and what reason there is in die imputation. This rule must be observed whether there is question of inflicting a punitive penalty or a censure, or of issuing a declaration of a penalty or censure into which one had fallen. Canon 1939, 1366. Though the inquisition or investigation may be made by the ordinary himself, it should by general rule be committed to one of the synodal judges, unless the same ordinary wishes for a special reason to commit it to someone else. Canon 1940, 1367. The inquisitor shall not be delegated for all cases universally but for one case only at a time. The inquisitor is held to the same obligations as the ordinary judges, and first of all he must take the oath to observe secrecy and to fulfill his office faithfully and to abstain from acceptation of presents, according to Canon 1621 to 1624. These canons demand that all officers taking part in a canonical trial must take the oath tendered either by the bishop or the judge who appointed them to act in the case. Furthermore, these canons insist on the obligation of secrecy for all those concerned in the case, and on the prohibition of accepting presents on occasion of any acts connected with the trial. The inquisitor cannot act as judge in the same case. Canon 1941, 1368. It is left to the good judgment of the ordinary to 320. The new canon law decide when there are sufficient reasons to institute the investigation. No consideration is to be given to denunciations which come from a pronounced enemy, or a violent unworthy person, or by an anonymous letter that is void of such adjuncts and elements as would tend to make the accusation somewhat probable. Canon 1942, 1369. The investigation must always be conducted secretly and handled with the utmost care, in order that the rumor of the offense may not spread and that no one's good reputation may be endangered. Canon 1943, 1370. For obtaining the purpose of the investigation the inquisitor may call some persons whom he believes to have knowledge of the affair, and ask them under oath of telling the truth and of keeping the matter secret. In the examination of these persons the rules for the examination of witnesses, as given in Canons 1770 to 1781, should be followed by the inquisitor as far as possible, and insofar as the nature of the Inquisition permits. Canon 1944, 1371. The inquisitor before closing the Inquisition may seek the advice of the promoter of justice whenever he meets with some difficulty, and communicate to him the acts of the Inquisition. Canon 1945, 1372. When the Inquisition is brought to a close the inquisitor shall refer to the ordinary all results, together with his own opinion in the case. The ordinary, or by his special mandate the appointed judge of the curia, called the officialis, shall 1. Give orders to make a statement of the fact which is to be kept in the secret archives of the curia, if the investigation proved that the denunciation was lacking solid foundation. 2. If there are indications of the offense, but insufficient to bring accusatory action against the person, the acts shall be kept in the secret archives and the suspected individual shall be watched in the meantime. It is left to the good judgment of the bishop to ask the suspect concerning the affair and to admonish him, if the suspicion is based on grave reasons. 3. Finally, if there are certain or at least probable and sufficient reasons at hand to institute the accusation, the guilty party shall be summoned to appear, and further proceedings shall be instituted according to the following canons. Canon 1946, Reprimand of the Delinquent 321, Chapter 3, Reprimand of the Delinquent, 1373. If the guilty person confesses the fault, the ordinary shall employ the judicial reprimand, if it can take place, instead of the criminal trial. Canon 1947, 1374. The judicial reprimand cannot be employed, 1. In offences to which is attached the excommunication reserved to the Holy See specialimo or specialimo due, or the privation of the benefice, the penalty of infamy, deposition or degradation. 2. When there is question of issuing a declaratory sentence of a punitive penalty or of a censure into which one has fallen. 3. When the ordinary believes that the reprimand would not suffice for the reparation of scandal and the satisfaction of justice. Canon 1948, 1375. The reprimand may be employed once or twice, not, however, a third time against the same offender. Wherefore, if after the second reprimand the offender commits again the same crime, the criminal procedure must be started, or continued, if previously begun, according to Canon 1954 and the following. Canon 1949, 1376. Within the limits of Canons 1947 and 1948, the ordinary may make use of the reprimand not only before the formal trial has commenced, but also after its commencement in the course of the trial, up to the conclusion of the case. In that case the trial is suspended, unless it has to be continued because the reprimand produced no result. Canon 1950, 1377. The reprimand may also be employed when complaint is made for damages caused by the offense. In that case the ordinary may with the consent of the parties examine into and decide the question of damage by the rules of equity. If the ordinary, however, judges that the question of damage cannot easily be decided by the rules of equity, he may issue the reprimand for the purpose of repairing the scandal and bringing about the amendment of the offender, and order the question of damage to be settled by ordinary process of the canonical trial. Canon 1951, 1378. The judicial reprimand must, besides salutary admonitions, contain, as a rule, certain opportune remedies, or 322. The new canon law, prescription of penances or of pious deeds, such as are apartment to publicly repair the violation of justice, or the scandal. The salutary remedies, penances, pious works, to be imposed on the offender should be milder and easier than those which could or should have been inflicted on him by the sentence of condemnation in the criminal trial. Canon 1952, 1379. The reprimand is considered to have been employed uselessly if the offender does not accept, or accepts but does not comply with the remedies, penances and pious works, imposed on him. Canon 1953. Chapter 4. Construction of the criminal trial and summons of the offender. 1380. If the judicial reprimand is either insufficient for the reparation of scandal and the restoration of justice, or cannot be employed because the offender denies the offense, or has been applied uselessly, the bishop, or the official judge by special mandate of the bishop, shall command the acts of the Inquisition to be given to the promoter of justice. Canon 1954, 1381. The promoter of justice shall at once draw up the indictment and present the same to the judge, according to the laws of canonical procedure laid down in the first section of the fourth book of the Code. Canon 1955, 1382. In more serious offenses, where the ordinary judges that the accused party would scandalize the faithful by the exercise of the sacred ministry, or some spiritual or religious ecclesiastical office, or by publicly receiving Holy Communion, he may after consultation with the promoter of justice prohibit the accused party from the exercise of the sacred ministry, or those offices, or the public reception of Holy Communion, as is permitted under these circumstances by Canon 2222. 2. Canon 1956, 1383. Likewise, if the judge fears that the accused party may intimidate the witnesses or bribe them, or impede the course of justice in any other way, he may, after consultation with the promoter of justice, command by decree that the offender leave the town or parish, or retire to a specified place and remain there under special surveillance. Canon 1957, Matrimonial Cases 323, 1384. The decrees spoken of in Canons 1956 and 1957 cannot be issued until after the accused party has been summoned and has appeared in court, or has become contumacious. They may be issued not only after his first appearance in court in answer to the summons, but also later on in the course of the trial. Against these decrees the law does not allow the accused party to raise objection. Canon 1958, 1385. For the rest of the procedure in criminal cases, the general laws on canonical procedure, contained in the first section of the fourth book of the Code, are to be followed. In the inflicting of penalties the laws of the fifth book of the Code are to be adhered to. Canon 1959, Title 20, Matrimonial Cases. Chapter 1, Competent Forum, 1386. Matrimonial cases between baptized people belong by proper and exclusive right to the ecclesiastical judge. Canon 1960, 1387. Cases concerning only civil sequences of marriage belong to the civil magistrates, as stated in Canon 1016, if they constitute the principal action in the case. If, However, civil consequences are incidental or accessory questions in the case. They may be examined and decided also by the ecclesiastical judge by his own authority. Canon 1962, 1388, Matrimonial Cases of Kings, etc., mentioned in Canon 1557, 1, n. 1, shall be judged exclusively by the S. Congregation, or the tribunal, or special committee, which the Supreme Pontiff shall in each individual case delegate. The cases of dispensation of the matrimonium ratum et non consummatum are reserved to the S. Congregation of the Sacraments. The cases which have reference to the privilegium Panglinum are reserved to the S. Congregation of the Holy Office. Canon 1963, 1389, wherefore no inferior judge can institute the canonical trial in cases of dispensation of the matrimonium ratum unless the Holy See has first granted faculty. 324 The New Canon Law. If, however, a competent judge has by his own authority instituted trial for nullity of marriage for reason of impotence, and it should happen that, while impotence could not be proved, there appeared proof of matrimonium non consummatum, all the acts of the case shall be forwarded to the S. Congregation of the Sacraments, which may use the proofs for issuing sentence on the matrimonium ratum et non consummatum. Canon 1963, 1390. In all other matrimonial cases that judge is competent who is the lawful judge in the place or diocese in which the marriage was contracted, or in which the party brought to court has a domicile or quasi-domicile. If one of the married parties is a non-Catholic, the domicile or quasi-domicile of the Catholic party is to be considered. Canon 1964, 1391. If the court is asked to declare marriage invalid for want of consent, the judge should first of all try by opportune admonitions to induce the party, whose consent is said to have been deficient, to renew the consent. If the essential form of the contract was wanting, or marriage was made invalid by a deriment impediment of a kind from which the Church can and usually does dispense, the judge shall endeavor to induce the parties to renew the consent in the legal form, or to ask for a dispensation. Canon 1965, Chapter 2. Constitution of the Tribunal. 1392, by law of Canon 1576, 1, n. 1. All marriage cases in which there is question of the marriage bond itself must be decided by a board of 3 judges. In the Inquisition for a dispensation of a matrimonium ratum et non consummatum there is but one judge to institute the procedure. Canon 1966, 1393. The defensor vinculi matrimonialis must be summoned in cases of nullity of marriage as well as in the proceedings for collecting proof of the non-consummation of marriage, and of reasons for the dispensation. Canon 1967, 1394. It is the duty of the defensor vinculi, 1. To be present at the examination of the parties, the witnesses and the experts, to present to the judge a list of questions enclosed in sealed envelope, to be opened by the judge in pro. Constitution of the Tribunal 325. Pose to the parties or to the witnesses in the very act of the examination, to suggest to the judge new questions arising from the examination. 2. To examine the points proposed by the parties and to contradict them so far as may be necessary, to examine the documents exhibited by the parties. 3. To write and allege arguments against the nullity of marriage and in favor of its validity or its consummation, to bring out all proofs that he thinks useful for maintaining the validity of the marriage in question. Canon 1968, 1395. The defensor vinculi has the right, 1. Always and at any stage of the trial to inspect the acts of the case, even those not yet made public, to demand more time for drawing up his written defense, the time to be allotted according to the good judgment of the judge. 2. To be informed of all proofs and allegations in such manner that he may use the right to contradict. 3. To ask that other witnesses be introduced or that the same be examined over again, even after the trial has been finished or published, and to make other observations. 4. To demand that other acts which he suggests be drawn up, unless the court objects by unanimous vote. Canon 1969, Chapter 3. Right to accuse a marriage and to ask the dispensation from the matrimonium ratum. 1396. The Board of Judges cannot take cognizance of, nor decide, any marriage case, unless the regular accusation or legally made petition has proceeded. Canon 1970, 1397. The following persons are capable of making accusation against a marriage. 1. The married parties in all cases of separation and nullity, unless they themselves were the cause of the impediment. 2. The promoter of justice in impediments which are of their nature public. All others, though blood relations, have no right to accuse the marriage but only to denounce its invalidity to the ordinary or the promoter of justice. Canon 1971, 1398. The marriage which was not accused during the lifetime of both parties cannot be accused after the death of either. 326. The New Canon Law, party, or of both, but is presumed valid in law in such manner that against this presumption no proof is admitted, except where the question arises incidentally. Canon 1972, 1399. The married parties alone have the right to ask for a dispensation of a matrimonium radum et non consummatum. Canon 1973. Chapter 4, Proofs. Article 1. Witnesses. 1400. Relations by blood or marriage who by law of Canon 1757, 3, n. 3, in any degree in the direct, and in the first degree of the collateral, line, are excluded as witnesses in other cases, may act as witnesses in marriage cases of their relations. Canon 1974, 1401. In cases of impotence or non-consummation of marriage, unless the impotence or non-consummation is known with certainty from other sources, each of the married couple must produce witnesses, who are called septimi mantis, from relations of blood or by marriage, or if such cannot be had, neighbors of good reputation, or otherwise well-informed persons, who can swear to the probity of the married couple and especially as to their veracity concerning the matter of the controversy. The judge may also introduce other witnesses ex officio, and this he may, according to Canon 1759, 3, do in all cases that concern the public welfare. The testimony of the septimi mantis is an argument of credibility which adds force to the depositions of the married couple. It has not, however, the force of full proof, unless it is supported by other evidence and arguments. Canon 1975, Article 2, Bodily Inspection. 1402. In the cases of impotence and non-consummation of marriage, bodily inspection of both, or of one, of the married parties must be made by experts, unless this appears evidently useless on account of circumstances. Canon 1976, 1403. The experts are to be chosen by the judge after consultation with the defense or vinculi, and, besides the general regulations of Canons 1792 to 1805 concerning experts, the following canons shall be observed. Canon 1977, End of Trial and Sentence 327, 1404. Those who have privately inspected the married couple concerning the fact on which the petition for declaration of nullity or non-consummation is based, shall not be admitted to the office of experts. They may, however, be introduced as witnesses. Canon 1978, 1405. For the inspection of the man 2 skilled physicians shall be appointed ex officio, that is to say, by the judge and not by choice of the parties. For the inspection of the woman 2 midwives who have a legal certificate to practice obstetrics shall be named ex officio, unless the woman should prefer 2 physicians for the inspection, or the ordinary should think their testimony to be necessary. The doctors are likewise to be appointed ex officio. The bodily inspection of the woman must be done with the entire observance of Christian modesty and in the presence always of an honorable matron to be designated ex officio. Canon 1979, 1406. The inspection of the woman by the midwives or experts must be done by each of them separately. Each of the physicians or midwives shall make a separate report within the space of time fixed by the judge. The judge may subject the report of the midwives to the examination of an expert physician, if he should think this advisable. Canon 1980, 1407. After the report has been handed to the judge, the experts, midwives and matron, shall be separately questioned by the judge according to points prepared previously by the defense or vinculi, to which they shall answer under oath. Canon 1981, 1408. Also, in cases of want of consent for reason of insanity, the judgment of experts is required, who shall, if necessary, examine with scientific precision the sick person and those of his actions which give reason to suspect insanity. Moreover, experts who have visited the sick person before the case came to court shall be heard as witnesses. Canon 1982. Chapter 5. Publication of the trial, conclusion of the case, and sentence. 1409. After the publication of the trial, the parties may, with the permission of the judge, introduce new witnesses to testify on the various articles of the case. 328. The new canon law. If, however, the same witnesses who have been questioned on the same points before, are again to be examined on those points, it may be done only before the former testimony of witnesses has been made public, and provided there has been no underhand agreement or bribe, the defense or vinculi has the right to oppose with timely exceptions. Canon 1983, 1410. The defense or vinculi has the right to demand that he have the last word in arguing, petitioning and answering, in writing as well as in the oral defense. Wherefore the tribunal shall not proceed to a definite sentence before having asked the defense or vinculi and received the answer that he has nothing more to say or to inquire concerning the case. If, however, the defense or vinculi does not make any further statement before the date set for the final sentence, it is presumed that he has nothing more to add to the defense of the case. Canon 1984, 1411. In cases which refer to the dispensation from the matrimonium ratum at non-consummation, the judge who draws up the case shall neither publish the acts of the case, nor proceed to a sentence on the non-consummation of the marriage and the reasons for a dispensation, but shall forward all the acts of the case together with the opinion of the bishop and of the defense or vinculi to the Holy See. Canon 1985. Chapter 6. Appeals. 1412. The defense or vinculi must within the time fixed by law appeal to a higher tribunal from the first sentence which declared a marriage null and void. If he neglects to fulfill this office, he shall be forced to do so by the authority of the judge. Canon 1986, 1413. After the second sentence has confirmed the nullity of the marriage, the parties are free to marry again after 10 days from the publication of the second sentence, provided the defense or vinculi of the Court of Appeal has not within that time appealed the case to a third tribunal. Canon 1987, 1414. After the marriage has been annulled, the ordinary shall see to it that mention of the annulment is made in the max semicolon. Cases accepted from trial. 329. Riage and baptismal records where the marriage had been entered. Canon 1988, 1415. As the sentence in matrimonial cases never becomes a res judicata, the cases can be opened again if new arguments come to light, which arguments must, however, be of great weight. According to Canon 1903, a res judicata is an absolutely final settlement of a case so that no appeal is accepted against it, and such a case can be opened only by obtaining the restitutio in integrum, which cannot be granted unless the injustice of the sentence has become evident by revelation of facts unknown before. Canon 1989, Chapter 7. Cases accepted from the foregoing rules. 1416. When it is known from sure and authentic document, which cannot be contradicted or objected to, that a marriage was made invalid by the impediments of disparity of cult, sacred orders, solemn vow of chastity, marriage bond, ligamen, consanguinity, affinity and spiritual relationship, and it is likewise absolutely certain that no dispensation from these impediments was obtained. In these cases the formalities mentioned thus far may be omitted, and the ordinary can declare the nullity of marriage after having summoned the parties and having given the defense or vinculi opportunity to examine into the case. Canon 1990, 1417. Against the declaration of nullity the defense or vinculi may appeal to the higher court if for good reasons he believes that the impediments given in the preceding canon are not certain, or that probably dispensation from them was obtained before marriage. If he appeals, the acts of the case are to be sent to the higher court, which should be reminded of the fact that this is a case accepted from the ordinary rules of canonical trial. Canon 1991, 1418. The judge of the second instance shall, with the cooperation of the defensor vinculi, examine whether the first sentence should be confirmed, or whether the case should be decided in the regular form of canonical procedure. If his decision is in favor of a regular trial, he shall return the case for trial to the judge of the first instance. Canon 1992, 330. The New Canon Law. Title 21, Cases against Sacred Ordination, 1419. Cases in which the obligations arising from sacred orders, or the validity itself of the sacred ordination, are attacked, the petition must be sent to the S. Congregation of the Sacraments, or if the ordination is attacked on account of a substantial defect of the sacred rite, to the S. Congregation of the Holy Office. The S. Congregation must decide whether the case is to be settled by judicial procedure in court, or in the disciplinary way. If the case is to be settled by legal procedure, the S. Congregation remands the case to the tribunal of the diocese, which was the proper diocese of the cleric at the time of the ordination, or, if the ordination is attacked on account of a substantial defect in the sacred rite, to the tribunal of the diocese in which the ordination took place. In case of appeal from the first sentence, the general rules for the court of the second instance shall be observed. Canon 1594, treating of the court of second instance. Rules. 1. From the tribunal of a suffragan bishop, appeal is to be made to the archbishop. 2. From cases judged in the first instance by an archiepiscopal court, appeal is to be made to a bishop of another diocese, which the archbishop may once and for all choose with the approval of the Holy See. 3. From cases judged in the first instance by an archbishop who has no suffragans, or a bishop who is under the immediate jurisdiction of the Holy See, appeal is to be made to the archbishop chosen in the manner prescribed by Canon 285. 4. In exempt religious orders or congregations, the Superior General constitutes the court of the second instance for cases judged by the provincial. In cases judged by the abbot of a monastery, appeal may be made to the supreme head of the monastic congregation to which the abbey belongs. If the case is to be decided in the disciplinary form, the S. Congregation itself settles the question, after a previous informative process instituted by the tribunal of the respective diocese. Canon 1993, 1420. The validity of the sacred ordination may be attacked by the cleric as well as the ordinary to whom the cleric is subject, or the ordinary in whose diocese the ordination took place. Only a cleric who believes that he did not contract the obli. Penal Sanctions 331. Gallons arising from sacred orders can petition for declaration of nullity of these obligations. Canon 1994, 1421. All the rules laid down by the canons in the first section of the fourth book of the Code, as well as the laws under the special title of matrimonial trials, must with due distinction also be observed in cases against sacred ordination. Canon 1995, 1422. The defensor vinculi of sacred ordination has the same rights and duties as the defensor matrimonii. Canon 1996, 1423. Though action be instituted only over the obligations of sacred orders, and not against the validity of the ordination, the cleric must nevertheless be forbidden ad cautelam to exercise the sacred orders. Canon 1997, 1424. In order that a cleric may be free from the obligations arising from ordination, two conformable sentences are necessary. In reference to appeal in these cases, the laws of Canons 1986 to 1989 on appeals of marriage cases shall be observed. Canon 1998, Part 2, Cases of beatification of the servants of God and canonization of the blessed, 1425, Canons 1999 to 2141. The interesting details of procedure in the cases of beatification and canonization of the servants of God contained in this section of the Code are setting forth the particulars of the proceeding, both as to the preparatory part which the diocesan curia has in the trial, as also the final judgment by the Sacred Congregation of Rites. Part 3. The manner of procedure in certain affairs or in the application of penal sanctions. 1426. In the judicial proceedings spoken of below, A notary shall always be employed who shall draw up the documents which have to be subscribed by all concerned, and which must be kept in the archives. Canon 2142, 332. The New Canon Law, 1427. Whenever monitions are prescribed, these must be made either orally, in the presence of the Chancellor or another official of the Curia, or of 2 witnesses, or by letter in the manner prescribed by Canon 1719. This canon rules that in case the written summons cannot be handed by a courier to the person called to court, on account of great distance or for other reasons, it may be transmitted by order of the judge through the public mail, provided the letter is registered and a return receipt signed by the party is secured, or in any other way which, according to the laws and conditions of countries, is considered safest. The fact of the giving of the monition and an authentic copy of its contents is to be preserved in the acts of the case. He who prevents the monition from reaching himself is considered as though he received it. Canon 2143, 1428. The examiners and consultors and the notary must at the beginning of the proceedings take the oath to keep secrecy concerning all they will learn in virtue of their office, and especially about the secret documents, discussions held in the meeting, and the number and motives of the votes. If they do not obey this law, they may not only be removed from office, but may also be punished by the ordinary with fitting penalties, according to the requirements of law, and besides they shall be obliged to repair any damage that may have been caused by their action. Canon 2144, 1429. In these trials the summary form is to be followed, but it is not forbidden to have 2 or 3 witnesses testify who may be summoned either ex officio or at the request of the party, unless the ordinary, after consultation with the parochial consuitors or examiners, should come to the conclusion that the witnesses are proposed by the parties to unnecessarily delay the case. The witnesses and experts shall not be admitted to testify except they take the oath. Canon 2145, 1430. From the definite sentence there is but one remedy, which consists in recourse to the Holy See. In that case all the acts of the process are to be forwarded to the Holy See. Pending such recourse the ordinary cannot validly confer permanently upon another the parish or benefice of which a cleric was deprived. Canon 2146. Removal of pastors. 333. Title 27. Manner of procedure in the removal of irremovable pastors. 1431. The pastor of an irremovable parish can be removed for a reason which makes his ministry harmful or inefficient, even apart from grave guilt on the part of the pastor. The principal causes for removal are as follows. 1. Ignorance, or habitual infirmity either bodily or mental, which render the pastor incapable to properly attend to the duties of his office. If in the bishop's judgment the spiritual welfare of the parish cannot be taken care of by appointment of a parochial vicar, confer Canon 475. 2. Hatred by the people, though unjust and not universal, provided it be such as to impede the useful ministry of the pastor, and can be foreseen not to cease within a short time. 3. Loss of good reputation among virtuous and prudent men, whether this arises from levity of conduct of the pastor, or from a former offense which has recently been detected, and which is exempt from penalty on account of prescription, or from the conduct of servants and blood relations with whom the pastors lived, unless by their removal the good reputation of the pastor can be restored. 4. A probable secret crime of which the pastor has been accused, from which the ordinary may prudently judge that in future great scandal may come to the faithful. 5. Inefficient administration of the temporal goods with great damage to the church or benefice, whenever the evil cannot be remedied either by depriving the pastor of the administration or in any other manner, though otherwise the pastor does usefully exercise the spiritual ministry. Canon 2147, 1432. Whenever the ordinary learns that according to his judgment a pastor has fallen into any of the cases of the foregoing canon, the ordinary himself shall consult 2 of the diocesan examiners and discuss with them the truth and gravity of the case, and after this invite the pastor, either in writing or orally, to tender resignation of his parish within a specified period of time, unless there is question of a pastor mentally afflicted. The invitation to resign must contain the reason which 334 The new canon law prompts the ordinary to take this step, and the arguments on which the charge is based, otherwise the proceeding is invalid. Canon 2148, 1433. If the pastor does not resign within the specified time, nor ask for delay, nor attack the reasons of the charge made against him, and the ordinary has made sure that the invitation was properly issued and actually received by the pastor, and that the latter had no legal excuse for delaying an answer, the ordinary shall at once remove him from the parish, without being held to the law of Canon 2154, if there is no certainty concerning the 2 points, namely, that the pastor has received the invitation, and that by his own fault he neglected to answer. The ordinary shall either repeat the invitation to resign or prolong the time in which reply must be made. Canon 2149, 1434. If the pastor resigns his parish, the ordinary shall declare the parish vacant. The pastor may, instead of the reason stated by the ordinary, give another, less disagreeable and grave motive why he resigns, provided it be true and lawful. For instance, in order to comply with the wishes of the ordinary, the resignation may be made not only purely and simply, but also under condition, provided the condition can be and AC to Ali is accepted by the ordinary. The resignation to be valid must be made in writing or orally in presence of 2 witnesses, as demanded by Canon 186, Canon 2150, 1435. The pastor who wishes to attack the reason for removal mentioned in the invitation, may ask for delay to furnish proofs which respite the ordinary may grant according to his own good judgment, provided it does not become detrimental to the spiritual welfare of the faithful. Canon 2151, 1436. The ordinary must discuss, approve or reject the reasons urged by the pastor against the invitation with the examiners mentioned in Canon 2148, 1, in order that the proceeding may be valid. The decision, whether in the affirmative or negative, is to be made known to the pastor by a decree. Canon 2152, 1437. The pastor may within 10 days object to the decree of removal to the same ordinary, who, in order to act validly, must consult 2 of the parochial consultors and examine, ap. Removal of pastors 335, prove or reject the new arguments as well as those advanced by him in the first trial. He must make his decision within 10 days from the appeal. The pastor may, with the permission of the ordinary, who must ask the advice of the parochial consultors on the matter, introduce witnesses whom he can prove he was unable to produce in the first trial. The decision is to be made known to the pastor by a decree. Canon 2153, 1438. After a pastor has been removed, the ordinary shall consult the diocesan examiners or the parochial consultors who took part in deciding the removal. What is to be done concerning the pastor? According to the circumstances of the case, he may either be transferred to another parish, or assigned to some other office or benefice, if he is capable and deserving of such office, or be pensioned. All other things being equal, the pastor who resigns is to be more favored in the provision made for him than the pastor who is removed. Canon 2154, 1439. The question of providing for the removed pastor may be settled by the ordinary, either in the decree of removal or afterwards, but it should be done as soon as possible. Canon 2155, 1440. The priest who is removed from a parish must as soon as possible vacate the parochial residence and turn over to the new pastor, or to the economist appointed by the bishop, all goods belonging to the parish. If, however, the pastor should be sick and cannot be removed without inconvenience, the ordinary shall relinquish to him even the exclusive use of the house, for so long as he is in that condition. Canon 2156, Title 28, Manner of Procedure in Depriving Removable Pastors of their Parish. 1441. The movable pastor may be removed from his parish for a good and serious reason according to the law of Canon 2147, 336. The new canon law. In reference to pastors belonging to religious communities, the law of Canon 454, 5. Shall be observed. Canon 2157, 1442. If the ordinary believes that there is present one of these reasons for removal, he shall paternally admonish and exhort the pastor to resign, indicating to him the reason why his parochial ministry is harmful to the faithful, or at least inefficient. Canon 2158, 1443. If he does not answer within the specified days, the law of Canon 2149 is to be enforced. If the pastor refuses to resign, he shall give his reasons in writing, which the ordinary must consider with 2 of the diocesan examiners, in order to act validly. Canon 2159, 1444. If the ordinary, after having heard the examiners, does not judge the pastor's reasons legitimate, he shall repeat the admonition to resign, threatening removal if the pastor should not of his own accord resign the parish within a suitable period of time to be fixed by the bishop. Canon 2160, 1445. The specified period of time having elapsed, which may also be prolonged according to the good judgment of the bishop, he shall issue the decree of removal. The ordinary shall provide for the removed pastor according to the rules of Canons 2154 to 2156. Canon 2161, Title 29, Manner of Procedure and the Transfer of Pastors, 1446. If the good of souls necessitates the transfer to another parish of a pastor who administers his parish satisfactorily, the ordinary shall invite and persuade the pastor to consent to the change for the love of God and the welfare of souls. Canon 2162, 1447. The ordinary cannot transfer an irremovable pastor against his will, unless he has obtained special faculties from the Holy See. A movable pastor, however, may also against his will be transferred, if the parish to which he is to be transferred is not too much inferior to his present parish, provided the following canons are observed. Canon 2163, 1448. If the pastor does not yield to the invitation in Procedure against Clerics 337, suasion of the ordinary to accept another parish, he shall explain his reasons in writing. Canon 2164, 1449. If the ordinary, notwithstanding the reasons alleged by the pastor, should nevertheless desire to make the change, he must, in order to act validly, consult 2 of the parochial consuitors on the reasons advanced by the pastor, and discuss with them the circumstances of the parish in which the pastor is stationed at present, and the parish to which he is to be transferred, and explain the reasons which make the transfer of the pastor either useful or necessary. Canon 2165, 1450. If the ordinary, after having heard the parochial consultors, should still want to make the change, he shall repeat the exhortations and admonish the pastor to heed the desire of his superior. Canon 2166, 1451. If after all this the pastor still refuses to consent to the transfer, and the ordinary still believes that the change should be made, he shall command the pastor to go to the other parish within a specified time, and indicate to him in writing that the present parish which he occupies shall be considered vacant ipso facto q.t. the expiration of the specified period of time. If this period has elapsed without result, he shall declare the parish vacant. Canon 2167, Title 30, Manner of Procedure against Clerics not observing the law of residence, 1452. The pastor, canon, or other cleric, who neglect the law of residence to which they are bound by reason of their benefice shall be admonished by the ordinary, and in the meantime, if there is question of a pastor, the bishop shall at the expense of the pastor provide that the welfare of souls does not suffer harm. In the monition the ordinary shall remind such offenders of the penalties which clerics incur who do not keep residence, and that according to the law of Canon 188, n. 8, the benefice shall become vacant ipso facto if they do not obey the admonition. The bishop shall specify the period of time in which they must return to their residence. Canon 2168, 1453. If the cleric does not resume his residence within the specified period of time, nor give reasons for his absence, He 338 The new canon law shall declare the parish or other benefice vacant in the manner prescribed by Canon 2149, Canon 2169, 1454, if the cleric resumes his residence, and if his absence had been illegitimate, the ordinary shall not only deprive him of the income of the benefice for the time of his absence, which he forfeits eo ipso in virtue of Canon 2381, but may, if the case calls for it, punish him with other penalties, in addition, according to the measure of his guilt. Canon 2170, 1455, if the cleric does not resume his residence, but gives reasons for his absence, the ordinary together with 2 of the diocesan examiners shall consider the matter, and, if necessary, investigate whether the reasons given are legitimate. Canon 2171, 1456, if after consultation with the examiners the ordinary judges that the reasons are not legitimate, he shall again give the cleric a specified period of time in which he is to return, saving always the privation of the income for the time of illegal absence. Canon 2172, 1457, if a movable pastor does not return within the prescribed time, the ordinary can at once proceed with the privation of the parish. If he returns, the ordinary shall give him a command in writing not to again leave the parish without his permission under penalty of privation of the parish to be incurred ipso facto. Canon 2173, 1458, if the cleric who has an irremovable benefice does not resume his residence, but offers new reasons for his absence, the ordinary shall examine them together with the same examiners in the manner specified in Canon 2171. If the bishop and the examiners do not think the reasons to be legitimate, the ordinary shall without consideration of any further arguments command the cleric to return within the time first specified, or within a new term set by the bishop, under penalty of privation of the benefice to be incurred ipso facto. If he does not return, the ordinary shall declare him deprived of his benefice. If he returns, the ordinary shall give him the precept mentioned in Canon 2173, Canon 2174, 1459. In neither case shall the ordinary declare the benefice vacant until after he has discussed with the examiners the reasons for absenting himself offered by the cleric, and has made procedure against clerics 339, certain that the cleric could have asked the written permission of the bishop for leave of absence. Canon 2175, Title 31, Manner of Procedure against Clerics Living in Concubinage, 1460. The cleric who, contrary to the law of Canon 133, keeps under his roof, or in any manner frequents, a woman of suspicious character shall be admonished by the ordinary to send her away, or not to frequent her, threatening the penalties which Canon 2359 decrees against clerics living in concubinage. Canon 2176, 1461, if the cleric does neither obey the precepts nor answer, the ordinary after having ascertained that the cleric could have done so, shall, 1. Suspend him ad divinis, 2. If he is a pastor, deprive him at once of his parish in addition to the suspension. 3. Deprive the cleric who holds a benefice without the care of souls, of 1/2 of the income of the benefice, if within 2 months from the suspension he did not amend, after 3 more months of all the income of the benefice, after another 3 months of the benefice itself. Canon 2177, 1462. If the cleric does not obey, but adduces reasons of excuse, the ordinary shall consult 2 of the examiners on those points. Canon 2178, 1463. If the ordinary after consultation with the examiners does not believe the proffered reasons to be legitimate, he shall as soon as possible inform the cleric of his judgment, and give him a formal precept to obey within a short time to be fixed by the bishop. Canon 2179, 1464. The ordinary can allowance coerce a movable pastor who does not obey, by inflicting punishment according to Canon 2177, if there is question of a cleric who holds an irremovable benefice, and who does not obey the bishop's orders in this matter, but offers new reasons for his conduct, the bishop shall subject these new allegations to the examination of the diocesan examiners according to the form of Canon 2178, Canon 2180, 1465. If also these reasons are not recognized as legitimate, the ordinary shall again command the cleric to obey within a suitable period of time. If this period has elapsed without the desired effect, he shall proceed according to the law of Canon 2177, Canon 2181, 340 the UC 4.0.v, Title 32, Manner of Procedure against a Pastor who is negligent in the fulfillment of the pastoral duties. 1466. A pastor who seriously neglects or violates the parochial duties imposed by Canons 467. 1. 468, 1, 1330-1332, and 1344, shall be admonished by the bishop, who shall remind him of the strict obligation of conscience by which he is bound, and of the penalties which the law decrees against these offenses. Canon 2182, 1467. If the pastor does not amend, and the bishop after having consulted on the matter two of the diocesan examiners, and having given the pastor opportunity to defend himself, should have found proof that the above-mentioned parochial duties have again and again been neglected or violated for a considerable length of time, and in important matters, without any just reason, he shall rebuke the pastor and impose on him an appropriate penalty in proportion to his offense. Canon 2183, 1468. If both the rebuke and the punishment brought no fruit, the ordinary, after having proved according to the norm of Canon 21s3, the culpable perseverance in the neglect or violation of his pastoral duties in matters of importance, he can at once deprive the movable pastor of his parish. The immovable pastor, however, shall be deprived of the income from the benefice either in whole or in part in proportion to the gravity of the guilt. The income of which the pastor was deprived is to be distributed to the poor by the ordinary. Canon 2184, 1469. If the irremovable pastor persist in his sinful carelessness, and such has been proved in the manner prescribed by the foregoing canons, the bishop can remove also the irremovable pastor. Canon 2185, Title 33, Manner of Procedure for Infliction of the Suspension ex informata conscientia. 1470. The ordinaries may punish their subject clerics of forum jcc sitia either by a complete or a partial suspension. The ordinary is not allowed to make use of this extraordinary means of procedure except in a case where he could not. Infliction of suspension 341. Without great inconvenience proceed against a subject in the ordinary course of law. Canon 2186, 1471. In order to issue this suspension neither the form of a judicial trial is required nor canonical monitions. It suffices that the ordinary in compliance with the following canons issue a decree in which he simply declares that he inflicts the suspension. Canon 2187, 1472. This decree is to be given in writing, unless the circumstances demand otherwise, in which document, besides day, month, and year in which it is issued, shall be indicated the following. 1. It shall be explicitly stated that the suspension is inflicted c.r. informata conscientia, that is to say, for reasons known to the ordinary. 2. The time of duration of the penalty shall be indicated. The ordinary should abstain from inflicting a perpetual suspension. It may, however, be inflicted also as a censure, provided that in such case the cleric is advised of the reason why the suspension is inflicted on him. 3. The acts which are forbidden, if it is not a total, but only a partial suspension, must be clearly specified. Canon 2188, 1473. If the cleric is suspended from an office for which someone else has to be substituted, as for instance, the priest who takes the suspended pastor's place in the care of souls, the substitute shall receive such compensation from the revenue of the benefice as the ordinary shall by his own good judgment specify. The cleric who thinks that the substitute receives too much of the revenue of the benefice, to the detriment to his own income, may apply for a reduction to the immediate superior who would be the judge of appeal in the regular canonical trial. Canon 2189, 1474. The ordinary who inflicts a suspension ex inflammato conscientia must have by previous investigations collected such proofs that give him certainty that the cleric did actually commit an offense serious enough to be punished with such a penalty. Canon 2190, 1475. An occult offense, as described in Canon 2197, n. 4, furnishes a just and legitimate cause to inflict the suspension ex inflammato conscientia. A notorious offense cannot be punished by suspension ex inflammato conscientia. 342. The New Canon Law. If a public offense is to be punished by suspension ex inflammato conscientia, it is necessary that one of the following circumstances occur. 1. If conscientious and serious-minded witnesses do indeed make known to the ordinary an offense which was committed, but cannot in any way be induced to testify in court to the crime, and there is no other way open to convict the offender in a judicial trial. 2. If the cleric himself, by threats, and the use of other means, prevents the canonical trial from starting, or, if started, from progressing. 3. If an impediment to the prosecution of the canonical trial or to the issue of the sentence arises from adverse civil laws, or from fear of great scandal. Canon 2191, 1476. The suspension ex inflammato conscientia is valid if of several offenses one only is occult. Canon 2192, 1477. It is left to the prudent judgment of the ordinary to make known or to conceal to the cleric the cause or offense for which the suspension is inflicted, but if he thinks it well to make known the reason, he should do so with pastoral solicitude and charity, so that the penalty accompanied with paternal admonition may serve not only for the satisfaction of the guilt, but also bring about the amendment of the offender, and serve to eliminate the occasion of sin. Canon 2193, 1478. If the cleric has recourse to the Holy See against the suspension inflicted on him, the ordinary must forward to the Holy See the proofs from which it is made certain that the cleric has really committed an offense which can be punished by this extraordinary penalty. Canon 2194, the Fifth Book, Offenses and Penalties, Part 1. Offenses. Title 1. Nature and Division of Offenses. Percentes. 1479. By the generic name of delictum there is in ecclesiastical law meant an external and morally sinful violation of the law to which is attached a canonical sanction or penalty, at least indeterminately. What is said concerning the violation of a law applies equally to the violation of precepts to which a penalty has been attached, unless the contrary is apparent from the circumstances. Canon 2195, 1480. The nature of an offense is to be judged from the subject matter of the law. The greater or lesser culpability depends not only on the gravity of the law which is violated, but also on the degree of sinfulness of the action and the harm caused. Canon 2196, 1481. An offense is called 1. Public, if it actually has been divulged or circumstances are such that it easily can and must become public. 2. Notorious, by notoriety of the law, after the sentence of a competent judge has become a res judicata, that is to say, a sentence from which there is no appeal, or after a confession made in court in presence of the judge. 3. Notorious by notoriety of fact, if the offense is publicly known and has been committed under such circumstances that it cannot be kept secret by any artifice, nor can be excused by any subterfuge of law. 4. Occult, which is not public. Occult materialiter, if the crime itself is not known. Occult formaliter, if the person to whom it is to be imputed is not known. Canon 2197, 1482. An offense which solely violates a law of the Church. 343, 344. The New Canon Law is by its very nature subject only to punishment by the ecclesiastical authority, which may at times ask the assistance of the civil power when it judges such help necessary or opportune. An offense which violates solely a law of the civil authority is punished by the civil authority by its own right, saving the exception of Canon 120, though also the Church is competent to judge it by reason of the sin. The offense which violates the law of either society, can be punished by both. Canon 2198. Title II. Imputability of an offense, causes which aggravate or diminish it, and juridical effects of an offense. CFC/MR 1483. The imputability or responsibility of an offense depends on the evil intention of the delinquent, or on the amount of guilt in his ignorance of the law which he broke, or in the omission of due diligence. Wherefore all causes which increase, diminish or take away, deliberate evil will and sinfulness, do also eo ipso increase, diminish or take away, imputability or responsibility. Canon 2199, 1484. By the term dons is understood here the deliberate will to violate the law, to which is opposed, on the part of the mind, defect of knowledge, and, on the part of the will, the want of liberty. Whenever the law is violated by external action, the deliberate will is presumed in the external forum, until the contrary is proved. Canon 2200, 1485. Incapable of committing an offense are those who do not enjoy the use of reason. Habitually insane persons, though they have at times lucid moments, or seem to be sane in certain ways of reasoning and acting, are nevertheless presumed incapable of an offense. An offense committed in voluntary drunkenness is somewhat responsible, but in a lesser degree than if the same offense is committed by a person fully in control of his senses, unless drunkenness was sought deliberately for the purpose of committing the crime, or to excuse it. If the law has been violated in involuntary drunkenness, there is no responsibility at all if the intoxication deprived the person altogether of the use of reason. Responsibility is diminished if the use of reason was only partially. Effects of an offense 345. Impaired. The same is to be said of other, similar disturbances of the mind. Debility of mind diminishes the responsibility of an offense but does not take it away altogether. Canon 2201, 1486. The violation of a law of which one was ignorant is not put to one's account if the ignorance was inculpable. Otherwise the responsibility is more or less diminished in proportion to the amount of the sinfulness of the ignorance. Ignorance of the penalty only attached to the violation of the law does not take away the responsibility for the offense, but diminishes it somewhat. What is said of ignorance holds good also in reference to inadvertence and error. Canon 2202, cf. Canon 2229, 1487. If a person violates a law by the omission of due diligence, the responsibility is diminished in a degree to be measured by the good judgment of the ecclesiastical judge ac according to the circumstances of the case. If the offender foresaw the occurrence and nevertheless neglected to use such precautions as any prudent man would have used, the guilt is next to willful violation of the law. An accidental case which could not be foreseen, or, if foreseen, could not be avoided, is free from all responsibility. Canon 2203, 1488. Minor age, unless the contrary is apparent, diminishes the responsibility, all the more so the nearer it approaches infancy. Canon 2204, 1489. Physical violence which robs a person of all freedom of action excludes all idea of crime. Grave fear, even relatively such, necessity and also great inconvenience, excuse as a rule from all guilt, if there is question of purely ecclesiastical laws. If, however, the act is intrinsically evil, or involves contempt of faith or of ecclesiastical authority, or the harm of souls, the circumstances spoken of in the preceding paragraph do indeed diminish the responsibility but do not take it away. The case of legitimate self-defense against an unjust aggressor, with due precaution not to injure the aggressor more than necessary for self-protection, excuses from all guilt, otherwise the responsibility is only diminished, as is the case also where provocation entices a person to do wrong. Canon 2205, 346. The New Canon Law, 1490. Passion, when voluntarily and deliberately excited or nourished, does rather increase the responsibility. Otherwise it diminishes the guilt more or less in proportion to the vehemence of the passion. It may also take away all responsibility if the passion rises suddenly and with such intensity as to exclude reflection and consent of the will or to impede free consent. Canon 2206, 1491. Besides other aggravating circumstances, the guilt is increased, 1. By the greater dignity of the person who commits an offense, or against whom the crime is committed, 2. By the abuse of authority or of an office for the commission of an offense. Canon 2207, 1492. A residuus in the terminology of law denotes a person who again commits an offense of the same kind for which he had been condemned previously, and under such circumstances and at such a time that his obstinacy and evil intention may with good reasons be conjectured from his actions. He who offends several times, though in various kinds of violations, increases his responsibility. Canon 2208, 1493. Those who agree to cooperate in the same offense by united physical action are all held guilty in the same degree, unless the circumstances increase or diminish the culpability of one or the other. In an offense which of its very nature requires an accomplice, both parties are held equally guilty, unless the circumstances prove he contrary, not only the one who orders the commission of an offense, and who is therefore the principal author of the crime, but also all who induce another or help him in any way to commit the crime, are ceteris paribus contracting the same guilt as the executor of the misdeed himself, if the deed would not have been committed without their cooperation. If their cooperation, however, only facilitated the misdeed which would have been committed even without their help, it is less sinful. He who ceased to cooperate in the crime by timely withdrawal from all participation is freed from all responsibility, though, for reasons of his own, the executor of the misdeed perpetrated the crime. If he did not completely withdraw his influence, his retraction diminishes but does not take away responsibility altogether. Attempted crime 347. He who cooperates in a crime merely by neglect of his duty is held responsible to a degree proportionate to his obligation of preventing the crime. Praise of the accomplishment of a crime, participation in its fruits, receiving or concealing the delinquent, and other actions following after the crime has been fully completed, may constitute new crimes, namely if these actions are punished in law by penalties, but, unless they had made an agreement with the offender about these actions before he committed the crime, they do not import responsibility for the crime. Canon 2209, 1494. From the commission of a crime follows, 1. The penal action, either for the declaration or the infliction of the penalty and the petition for satisfaction. 2. The civil action, for reparation of damages, if the crime caused losses to anyone. Both actions are to be instituted in court according to the rules of Canons 1552 to 1959. The same judge who handles the criminal cause may also, at the instance of the party that suffered damages, examine into and give sentence in the civil action. Canon 2210, 1495. All persons who cooperate in a crime in the manner described in Canon 2209, 1-3, are individually held to pay the expenses and repair the damages done to other persons by the crime, though the judge should have condemned them only to a portion of the expenses and damages. If, therefore, some of the cooperators cannot, or do not, contribute their share, the others are held for all expenses and damages. Canon 2211. Title 3, Attempted Crime, 1496. He who places an action, or omits an action, which of its very nature leads to the execution of a crime, but does not complete the act either because he changed his mind or was not successful in the execution of the crime on account of insufficient or inadequate means, is said to be guilty of attempted crime. If all actions were placed or omitted which naturally lead to the execution of a crime and would have sufficed to perpetrate it, but, on account of other causes that interfered against the will of the intended criminal, he did not accomplish the crime, it is properly called frustrated crime. 348. The New Canon Law. The person who induces another to commit a crime, but does not succeed, is nearly as wicked as a person guilty of attempted crime. Attempted crime that is punished in law with a special penalty, constitutes a real crime. Canon 2212, 1497. Attempted crime is sinful to a greater or lesser degree in proportion to its greater or lesser proximity to the accomplishment of the crime, though always less sinful than a committed crime. Frustrated crime is more sinful than merely attempted crime. He who of his own accord desisted from the execution of a crime which he had started to commit is free from all responsibility if no damage was caused nor scandal given. Canon 2213. The canon speaks, of course, of a responsibility in the external forum or the courts of law, and not of the interior sinful acts of the will, which might in such case be a very serious sin of internal consent, and of will to do a forbidden action. Part 2. Penalties. Section 1. Penalties in general. 1498. It is the innate and proper right of the Church, independently of any human authority, to punish her guilty subjects, with both spiritual and temporal penalties. The admonition of the Council of Trent, Session 13, de ref. Cap. 1, to the bishops and other ordinaries is here repeated, from which it is evident that the Church does not favor the hasty and rash use of extreme penalties and censures, but reminds the bishops to consider their subjects as children and brethren, and to try as long as possible, by patience and kindness, to influence them to strive after virtue and to desist from vice. Canon 2214, Title 4, Definition, Species, Interpretation and Application of Penalties. 1499. An ecclesiastical penalty is the privation of some good, inflicted by the legitimate authority on the delinquent for application of penalties. 349. His correction and for punishment of the offense. Canon 2215. 1500. There are three kinds of penalties in the Church. 1. The so-called corrective punishments or censures. 2. Punitive penalties. 3. Penal remedies and penances. Canon 2216. 1501. A penalty is called 1. Determined, when the precise nature of it is specified in a law or precept. Undetermined, if the law, in either preceptive or facultative terms, leaves the determination of the penalty to the good judgment of judge or superior. 2. Lati sententiae, if a specified penalty is attached to a law or a precept in such a manner that it is incurred by the very commission of the crime. Frendi sententiae, if the judge or superior is instructed to inflict a certain penalty. 3. A jury, if the penalty is specified in the law itself, as either lati or frendi sententiae. Ab homine, if a penalty is inflicted by means of a special precept or condemnatory sentence of a judge, though the punishment is prescribed in law. Wherefore a penalty frendi sententiae attached to a law is a jury tantum before the condemnatory sentence. After the sentence it is both a jury and ab homine, but is considered as ab homine. A penalty is always understood to be frendi sententiae, unless the law explicitly states that it is lati sententiae, or that it is incurred ipso facto, or ipso juri, or if other similar terms are employed. Canon 2217, 1502. In the infliction of penalties the punishment must be in just proportion to the offense, having due regard to the amount of responsibility, scandal and damage, wherefore attention is to be paid not only to the subject matter of the law and its gravity, but also to the age, knowledge, education, sex, state of life, and the condition of mind, of the delinquent, to the dignity of the person against whom the crime is committed, or who committed the offense, to the purpose intended, the place and time and where and when the offense was committed, whether the offender acted under the impulse of passion or out of grave fear, whether he repented of his misdeed and tried himself to prevent its evil consequences, and other similar circumstances. Circumstances which excuse from all sin, and also those excusing from mortal sin, do likewise excuse from incurring any penalty whether lati or frendi sententiae. The excuse holds. 350. The new canon law. Also in the external forum, if the mitigating circumstances can be proved, mutual injury is considered a compensation, so that neither party can ask for reparation, unless one party deserves condemnation on account of having done greater injury to the other, in which case the penalty is to be milder than in a case where there was no mutual injury. Canon 2218, 1503. In penalties the milder interpretation is to be applied. If it is doubtful whether a penalty inflicted by a superior, is just, the punishment must nevertheless be accepted, both for the internal and the external forum, except in cases of appeal in suspensivo. Penalties are not to be extended from person to person, or from case to case, though there is the same or even a greater reason, unless several persons participated in a crime in a manner that each one's cooperation was necessary to accomplish the crime. Cf. Canons 2231 and 2209, 1-3, Canon 2219, Title V. Superiors having coercive power, 1504. Superiors who have the power to make laws or impose precepts, can also attach penalties to the law or precept. Persons who possess judicial power only, can do no more than apply the penalties legally prescribed, in the manner demanded by law. The Vicar General without a special mandate has no power to inflict penalties. Canon 2220, 1505. Those who have legislative power can, within the limits of their jurisdiction, attach a penalty or increase the punishment fixed by law, not only in their own and their predecessors' laws, but also, for reason of peculiar circumstances, in the divine as well as the ecclesiastical laws of a higher superior in force in the territory of the inferior authority. Canon 2221, cf. Exception to this law in reference to papal censures in Canon 2247, 1506. Though the law may not have any sanction attached to it, the lawful ecclesiastical superior can punish the transgression of the law with some just penalty, even without first threatening with punishment, if perhaps scandal was given or superiors having coercive power. 351. The special gravity of the transgression calls for it, otherwise the offender cannot be punished except he has been first admonished and been threatened with the penalty of either lapse or friendcur sententis in case of transgression, but nevertheless violated the law. In a case where the perpetration of an offense is only probable, or while the crime is certain it is doubtful whether the penal action against that crime has been prescribed by lapse of time, the legitimate superior has not only the right, but also the duty not to promote a cleric of whose fitness he is not certain, and for the sake of avoiding scandal, to prohibit a cleric from the exercise of the sacred ministry, or also to remove him from office, according to the norms of law. But all this has not the nature of a penalty in this case. Canon 2222, 1507. In the application of the penalty, the judge cannot augment the penalty specified in law, unless extraordinary aggravating circumstances demand it. If the law in stating a penalty franz sententis uses optional terms, it is left to the good judgment and conscience of the judge to inflict it, or, if the penalty is specified, to mitigate it. If the law uses terms importing a precept, the penalty must ordinarily be inflicted, but it is left to the conscience and good judgment of the judge, or the superior, 1. To defer the application of the penalty to a more opportune time, if by hasty punishment of the offender greater evils can be foreseen to follow. 2. To abstain from inflicting the penalty if the offender has amended entirely, and has repaired the scandal, or has been, or will be, sufficiently punished by the penalties decreed by the law of the civil authority. 3. To mitigate the specified penalty, or in its place to employ one of the penal remedies, or to impose some penance, if there is a circumstance which notably diminishes the guilt, or, though the offender has either amended or has been punished by civil authority, the judge or the superior do nevertheless think it proper to impose some mild punishment. As a rule, it is left to the good judgment of the superior to declare a penalty lapse sententis, but, either at the instance of the party interested, or when the public weal demands it, the declaratory sentence must be issued. Canon 2223, 1508. Generally speaking, there are as many penalties as there are offenses. 352. The New Canon Law. If, however, on account of the great number of offenses there would be too great an accumulation of penalties to be inflicted, it is left to the good judgment of the judge either to impose the severest of the penalties, together with some penance or penal remedy, or to moderate the penalties within the limits of equity and with due regard to the number and gravity of the offenses. If there is a penalty fixed for the attempted crime as well as for the consummated crime, and the crime has been accomplished, the penalty for consummated crime only should be imposed. Canon 2224, 1509. If the declaration or infliction of the penalty is pronounced by judicial sentence, the laws of the canons in reference to the pronouncement of judicial sentences are to be observed. If, however, the penalty of either lapse or frenda sententia is inflicted by way of special precept, the declaration or infliction of the penalty should ordinarily be done either in writing or in the presence of two witnesses. Canon 2193 is also to be observed. Canon 2225, Title VI, Persons subject to the coercive power. 1510, persons held to a law or precept to which a penalty is attached, are subject to the penalty, unless they are explicitly accepted. Though a more recent penal law abrogates a former law, the milder of the two penalties is to be imposed in the case where the offense had already been committed when the more recent law was enacted. If the more recent law abolishes either the former law itself or only the penalty attached to it, the penalty ceases immediately though the law had been violated while the penalty was still in force. A censure, however, which had been incurred does not cease with the change of the law, but requires absolution. The penalty binds the offender everywhere, and also after the superior inflicting the same has passed out of office, unless the contrary is explicitly stated. Canon 2226, 1511. The Roman pontiff only can declare a penalty against, or inflict it on, the persons mentioned in Canon 1557, subjects to the coercive power 353, 1, namely, the supreme heads of nations and their children, cardinals, legates of the Holy See and bishops in criminal cases. Cardinals do not incur penalties unless they are explicitly mentioned, and the same applies to bishops in reference to suspensions and interdicts lot less than z sententia. Canon 2227, 1512. The penalty attached to a law is not incurred unless the offense committed is complete in its kind, according to the proper meaning of the terms of the law. Canon 2228, 1513. Affected ignorance of either the law, or of its penalty only, does not excuse from any penalties lat sententis, though the law contains the terms mentioned in the following paragraph. If the law has these words, prasum serit, alges fuerit, scienter, studios, temerary, consulto egerit, and other similar terms which demand full knowledge and deliberation, any diminution of responsibility, either on the part of the intellect or on the part of the will, exempt from the penalties lat sententis. If the law does not have these terms, 1. The ignorantia crassival supina of the law, or of the penalty only, does not exempt from any penalty later sententis. If it is not crassa or supina, it excuses from the so-called corrective penalties or censures, not, however, from the punitive penalties lat sententis, cf. Canon 2202, 2. Drunkenness, omission of due diligence, debility of mind, impulse of passion, to a degree that diminishes the responsibility, but not enough to excuse from mortal sin, do not exempt from incurring penalties lati sententiae. 3. Grave fear does not by any means excuse from penalties lati sententiae, if the offense tends to contempt of the faith, or of the ecclesiastical authority, or to public injury of the spiritual welfare of the faithful, though the offender is excused from the penalty by reason of ignorance which was not crassa or supina, he may nevertheless, if the case demands it, be punished with some other appropriate penalty or penance. Canon 2229, 1514. Children who have not attained the age of puberty are excused from the penalties lati sententiae, and they should be punished with disciplinary chastisement rather than by censures and other more serious, punitive penalties. Adults who, 354 The new canon law, induced a child to break a law, or who cooperated with one in the offense in the manner described in Canon 2209, 1-3, shall incur the penalty fixed by law. Canon 2230, 1515. If several persons concurred in the perpetration of a crime, though the law speaks of only one person, all the cooperators mentioned in Canon 2209, 1-3, shall be held to the same penalty, unless the law explicitly states the contrary. Other cooperators, however, shall not incur the same penalty, but shall be punished by some other just penalty, according to the good judgment of the superior, unless the law provides a special penalty for them. Canon 2231, 1516. The penalty lati sententiae, whether corrective or punitive, ipso facto binds the offender who is conscious of his offense, both in the external and internal forum. Before a declaratory sentence has been issued against the offender, he is excused from the observance of the penalty whenever he cannot observe it without loss of good repute, and in the external forum observance of the penalty cannot be demanded of the offender by anyone unless the offense is notorious. It is left to the good judgment of the superior to issue the declaration that an offender has incurred the penalty specified in law, if the public welfare demands the declaration, or the offender is accused by the party who suffered from the offense. The superior or judge are obliged to issue the declaration. By the declaratory sentence the penalty takes effect from the very moment in which the offense was committed. Canon 2232, 1517. No penalty can be inflicted unless it is certain that the offense was committed, and that legitimate prescription has not entered against it. Though this be certain, a censure should not be inflicted on the offender at once, but he should be reprimanded and admonished to recede from his obstinacy, in the form prescribed by Canon 2242. 3. If the case in the good judgment of the superior or the judge allows delay, and an appropriate space of time should be fixed for his repentance, if he remains obstinate, a censure may be inflicted. Canon 2233, 1518. He who has committed several offenses shall not only be punished more severely, but may also, if the judge thinks, pardon of penalties 355, this necessary, be subjected to surveillance or other penal remedy. Canon 2234, 1519. Frustrated and attempted crime, unless punished in law as distinct offenses, may be punished with some suitable penalty in proportion to the amount of guilt. Canon 2213, 3, explains the case in which no penalty is to be inflicted on attempted crime. Canon 2235, Title 7, Pardon of Penalties, 1520. The pardon from penalties, either by absolution when there is question of censures, or by dispensation if they are punitive punishments, can be granted only by him who imposed the penalty or his competent superior, or successor, or a person with delegated faculty. He who can grant exemption from the law, can also pardon from the penalty attached to the law. The judge who, in virtue of his office applies a penalty which has been established by the superior, cannot pardon from the penalty after he has imposed it. Canon 2236, 1521. In public cases the ordinary can remit the penalties lati sententiae of the common law with the exception, 1. Of cases brought to court for trial, 2. Of censures reserved to the Holy See, 3. Of penalties importing inhability to benefices, offices, dignities, positions in the Church, active and passive vote, and privation of them, perpetual suspension, infamy of law, privation of the right of patronage and of a privilege or favor which had been conceded by the Apostolic See. In occult cases, besides the faculties given under certain circumstances to every priest by Canons 2254 and 2290, the ordinary can pardon from the penalties lati sententiae of the common law, and delegate to others the same power. He may not, however, absolve from a censure reserved to the Holy See speciamo or specially modo. Canon 2237, 1522. A pardon from penalty which has been extorted by violence or grave fear is invalid by law. Canon 2238, 1523. A pardon from penalties may be granted to one who is present as well as absent. The pardon may be absolute or conditional, for the external forum or for the internal only. If 356 the new canon law, granted in the external forum, it is valid also in the internal, but the pardon in the internal forum does not per se hold in the external forum. Though a penalty may be remitted orally, it is nevertheless proper to grant pardon in writing, if the penalty was inflicted by written order. Canon 2239, 1524. In reference to the prescription of penal actions, Canon 1703 is to be observed, which canon ordains that, with the exception of cases subject to the jurisdiction of the Holy Office, the time for instituting criminal action against an offender is limited to 3 years unless there is question, 1. Of injuries, which action expires within 1 year, 2. Of offenses against the 6th and 7th commandments of the Decalogue, which expire within 5 years, 3. Of simony and homicide which expire after 10 years, Canon 2240. Section 2. Penalties in particular. Title 8. Corrective penalties or censures. Chapter 1. Censures in general. 1525. A censure is a penalty by which a subject, by baptism, of the Church is deprived of some spiritual benefits, or of benefits connected with matters spiritual, because of obstinate violation of some law of the Church, until such time as he repents and obtains absolution. Censures, and especially excommunication, incurred by the very commission of a crime, liti sententiae, should be inflicted rarely and with great prudence. Canon 2241. 1526. Only those external criminal actions that are mortal sins, complete, and committed with obstinacy, should be punished by censures. A censure may be visited also on delinquents whose identity is unknown. When there is question of censures frendi sententiae, a person is considered contumacious who does not desist from the censures in general. 357. Crime, or refuses to do penance and to repair the injury done, or the scandal given, by the crime, after having received the canonical admonitions described in Canon 2233. 2. A censure liti sententiae is incurred by the very transgression of the law or precept to which the censure is attached, unless the guilty person is excused from the penalty by a reason admitted in law. A person is considered to have ceased to be contumacious when he has sincerely repented of his crime, and has made content satisfaction for the injury and scandal caused, or has at least earnestly promised to do so. Judgment as to the sincerity of the repentance, or the sufficiency of the satisfaction, or the sincerity of the promise, rests with the one from whom absolution is asked. Canon 2242. 1527. Censures inflicted by a sentence in court import their execution as soon as they have been pronounced, and an appeal in devolutivo only is granted. Likewise from censures inflicted by way of precept appeal in devolutivo only is permitted. In both cases, therefore, the censured cleric must conform to the censure during the time in which he has recourse to a higher superior. Appeal or recourse from the judicial sentence, or from a precept which threatens censures liti sententiae, but which have not yet been contracted, does not suspend either the sentence or precept, nor the censures, if there is question of matters in which the law does not admit appeal or recourse with suspensive effect. If the law grants appeal in suspensivo, the censures threatened by the court, or the precept of the superior, are suspended, but the obligation remains to observe what has been commanded by the court or the precept, unless the offender interposes appeal or recourse not only from the penalty but from the very sentence or precept. Canon 2243. 1528. Censures may be multiplied in one and the same subject, not only such of different species but also of the same species. Censures liti sententiae are multiplied in the following manner. 1. If various crimes, to each of which a censure is attached, are committed, either by the same or by distinct actions. 2. If the same crime to which a censure is attached is committed repeatedly, in such manner that there are several distinct crimes. 3. If the same crime is punished with different censures by several superiors, and is committed once or repeatedly. A censure inflicted ab hominem is multiplied if there are 358. The new canon law. All precepts, or several sentences, or various distinct parts to the same precept or sentence, to each of which a censure is attached. Canon 2244. 1529. Some censures are reserved and others are not. A censure inflicted ab hominem, that is, by precept of a superior or by sentence in an ecclesiastical court, is reserved to the one imposing the censure or giving the sentence, or to his superior, his successor in office, or his delegate. Among the censures reserved a jury, that is by law. Some are reserved to the ordinary, others to the Holy See. Those reserved to the Holy See are subdivided into three classes: simpliciter, specially, and specialiter modo reserved. A censure incurred by the very fact of committing a crime, liti sententiae, is not reserved, unless the law or the precept explicitly states that it is. In case of doubt concerning the law itself, dubium juris, as well as in a doubt about the fact, dubium facti, the reservation does not hold. Canon 2245, 1530. A censure should not be reserved unless the peculiar gravity of the crime, and the necessity of maintaining ecclesiastical discipline and the morals of the faithful, demand the reservation. Reservation is to be interpreted strictly. The reservation of a censure which prevents the reception of the sacraments, as, for instance, excommunication, implies the reservation of the sin to which the censure is attached. If a person, however, is excused from the censure, or has been absolved from it outside confession, by a superior having jurisdiction in the external forum, the reservation of the sin ceases altogether. Canon 2246, 1531. If the censure is reserved to the Holy See, the ordinary cannot attach to the same crime another censure, reserved to himself. Reservation of a censure in some particular territory does not have any force outside the limits of that territory, even if the person who incurred the censure goes outside the territory precisely for the purpose of obtaining absolution. The censure ab hominem, however, is reserved everywhere, so that the censured person cannot be absolved anywhere without due faculties. If the confessor, in ignorance of the reservation, has censures in general 359, solved a penitent from the censure and the sin, the absolution from the censure is valid except in the case of censures reserved to the Holy See specialiter modo, and of censures imposed by a precept of a superior, or by a sentence in an ecclesiastical court. Canon 2247, 1532. Any censure once contracted cannot be removed except by legitimate absolution. Absolution should not be denied whenever the offender ceases to be obstinate, as explained in Canon 2242, 3. The one who absolves from the censure may, if the case demands it, impose an appropriate punitive penalty, or a penance, for the crime which had been committed. If a censure has been removed by absolution, it does not revive except in a case where the penance or other obligation that had been imposed under express condition of relapse into the censure, has not been performed. Canon 2248, 1533. If a person has incurred several censures, he may be absolved from one while the others remain. He who asks for absolution must indicate all cases from which he wants to be absolved, otherwise the absolution is valid only for the case he mentioned. If, however, the absolution was general, even though the petition referred to one particular case only, it is valid also for those cases which were concealed in good faith, with the exception of censures reserved to the Holy See specialiter modo, but it does not avail for those concealed in bad faith. Canon 2249, 1534. In a censure that does not forbid the reception of the sacraments, as, for example, suspension, the person, if otherwise well disposed, can be absolved from the sin while the censure remains. If there is question, however, of a censure which forbids the reception of the sacraments, the censured person cannot be absolved from the sins until he has first been absolved from the censure. The absolution from censure in the sacramental forum is included in the usual form prescribed in the ritualistic books for the absolution from sins. In the non-sacramental forum, absolution from a censure may be given in any form, but for the absolution from excommunication it is appropriate to use, as a rule, the formula contained in those same books. Canon 2250, 360. The New Canon Law, 1535. If the absolution from a censure is given in the external forum, it holds good for both the external and the internal forum. If it was given in the internal forum, the person who obtained such absolution may, if scandal is removed, conduct himself also in actions of the external forum as absolved, but, unless the absolution is proved in the external forum or lawfully presumed, The censure may be urged by the superior having jurisdiction in the external forum until absolution has been granted in the external forum, and the censured person must obey. Canon 2251, 1536. In danger of death any priest can absolve from all censures, but in two of these, namely, those reserved to the Holy See specially modo, and those imposed by precept or by sentence in an ecclesiastical court, the person after recovery is bound to have recourse for the imposition of a penance to the penitentiary, or to the bishop, or someone else having faculties to absolve from censures reserved to the Holy See specialissimo modo, and, in case of censures by precept or sentence, to the authority that imposed the precept or gave the sentence. If the convalescent neglects this obligation he falls again under the same censure. Canon 2252, 1537. Outside the case of danger of death the power to absolve from censures is regulated as follows. 1. From a censure which is not reserved, every priest may absolve in the sacramental forum. Outside sacramental confine the power to absolve is limited to those persons who have jurisdiction over the offender in the external forum. 2. From a censure ab homine may absolve he who imposed the censure, his superior and his successor in office, and he may give this absolution even if the offender has since transferred his domicile or quasi-domicile outside the territory of jurisdiction of the one who inflicted the censure. 3. From a censure reserved a jury can absolve he who ordained the censure, or he to whom it is reserved, and their successors in office, their competent superiors, or their delegates. Wherefore, from a censure reserved to the bishop or ordinary, any superior having ordinary jurisdiction in the external forum can absolve his subjects, and the local ordinary can absolve within his territory also the transients. From a censure reserved to the Holy See can absolve the Holy See and others who have obtained from that authority the faculty to absolve, which is, censures in general 361, called general if given for censures reserved to the Holy See simpliciter, special if given for cases reserved specially modo, and most special if for cases reserved specialissimo modo. The special concession for more urgent cases is explained in the following canon. Canon 2253, 1538. In cases where the censurati sententiae, into which one has fallen, cannot be suffered without great danger of scandal or loss of good reputation, or when it is hard for the penitent to remain in sin until the faculty to absolve can be obtained from the superior, any confessor can in sacramental confession absolve from any censure, no matter in what manner it is reserved, but he must impose the obligation on the penitent to have recourse within 1 month to the penitentiary, or to a bishop, or another person having faculties from the Holy See for the mandata. 1e. A penance that will be imposed on him. The recourse may be made either personally by the penitent, or, at least, by letter sent through the confessor without mentioning the name of the penitent, which recourse is obligatory when it is possible without great inconvenience. The penitent is not forbidden, after having received absolution in the manner just described, and even after recourse has been made by letter, to go to confession to another confessor who has delegated faculty to absolve, and having again confessed at least the sin to which the censure is attached obtain absolution. After this absolution the confessor shall give the mandata and the penitent shall not be obliged to the other mandata which will be issued by the superior in answer to the recourse. If in some extraordinary case this recourse should be, morally speaking, impossible, the confessor may absolve without the obligation of recourse and impose, in addition to the ordinary appropriate penance, a special satisfaction for the censure, which he shall demand to be performed within a specified period of time. If the penitent neglects within the specified period of time to perform the penance and satisfaction imposed for the censure, he shall again fall into it. Canon 2254, Chapter 2, Censures in particular, 1539. There are 3 censures: 1. Excommunication, 2. Interdict, 3. Suspension. 362 The New Canon Law. Excommunication can fall only on a physical person, and therefore, if it is sometimes imposed on a moral body or community, it is understood to affect only the individuals who operated in the offense. Both interdict and suspension may be imposed also on a community as a legal person. Excommunication and interdict affect also lay persons. Suspension is a penalty for clerics only. An interdict may affect also a place. An excommunication is always a censure. Interdict and suspension may be either censures or punitive penalties, but in case of doubt they are considered censures. Canon 2255, 1540. In the following canons it is to be observed that 1. By the term of divine offices are meant the functions of the power of orders, which by the institution of Christ or of the Church are ordained for divine worship and may be exercised only by the clergy. 2. By the term of legal ecclesiastical actions are understood the office of administrator of ecclesiastical goods, to act as judge, auditor, relator, defensor lincidi, promoter of justice and of faith, notary, chancellor, cursor, operator, lawyer and procurator in ecclesiastical cases, the office of godparents or sponsors in the sacraments of baptism and confirmation, the right to vote in ecclesiastical elections, the exercise of the rights of patronage. Canon 2256, Article 1 Excommunication, 1541. Excommunication is a censure by which a person is excluded from communion with the faithful, with the effects enumerated in the following canons and which cannot be separated one from the other. Excommunication is also called anathema, especially when inflicted with the formalities described in the Pontificale Romanum. Canon 2257, 1542. The excommunicated persons may be either excommunicati vitandi, or tolerati. No one is considered a vitandus unless he has been excommunicated by name by the Holy See, has been publicly denounced as such, and explicitly declared a vitandus in the decree or canonical sentence. He who lays violent hands on the Roman pontiff becomes by this very deed an excommunicatus vitandus, according to Canon 2343, 1, n. 1. Canon 2258. Excommunication 363, 1543. Every excommunicated person is deprived of the right to assist at divine offices, but he may be present at sermons. If an excommunicatus toleratus passively assists at divine services, he need not be expelled, but a vitandus must be removed. If this cannot be done, the divine services must be stopped if it can be done without great inconvenience. From active participation in divine services must even be excluded the excommunicatus toleratus whose excommunication is publicly known or who has been excommunicated in an ecclesiastical court by a declaratory or condemnatory sentence. Canon 2259, 1544. Every excommunicated person is forbidden to receive the sacraments. After a declaratory or condemnatory sentence he cannot even make proper use of the sacramentals of the Church. In reference to ecclesiastical burial, the law of Canon 1240, 1, n. 2, shall be observed, which forbids to give such burial to persons excommunicated and interdicted by a declaratory or condemnatory sentence in an ecclesiastical court. Canon 2260, 1545. An excommunicated priest is forbidden to celebrate Holy Mass and to administer the sacraments and sacramentals, with the following exceptions. The faithful may, saving the exceptions in the following paragraph, ask for any good reason an excommunicated priest for the sacraments and sacramentals, above all when there are no other ministers, in which case the excommunicated priest who is asked to administer the sacraments may do so, and he is not obliged to inquire for the reason why he was requested from an excommunicatus vitandus as well as from another excommunicated priest whose excommunication was pronounced in the ecclesiastical court by either condemnatory or declaratory sentence. The faithful may only in danger of death ask for sacramental absolution, in accordance with Canons 882 and 2252, and also, if there are no other ministers present, for the other sacraments and sacramentals. Canon 2261, 1546. An excommunicated person is deprived of the indulgences, suffrages and public prayers of the Church. But it is not forbidden, 1. That the faithful pray for him privately, 2. That the priests privately apply Holy Mass for him, provided scandal is avoided, for an excommunicatus vitae. 364 The new canon law. This holy mass may be applied for his conversion only. Canon 2262, 1547. An excommunicated person is excluded from legal ecclesiastical actions within the limits specified in the various places in law. He cannot act in ecclesiastical courts except in as far as Canon 1654 permits, which canon ordains that an excommunicatus vitandis, or one whose excommunication has been inflicted by condemnatory or declaratory sentence, shall personally be allowed to act in court only for the purpose to attack the justice and legitimacy of the excommunication. By proxy they may act to avert any other spiritual damage. In all other cases they are forbidden to act. All other excommunicated persons are generally allowed to act in court. Canon 2263, 1548. Acts of jurisdiction, both of the external and the internal forum, exercised by an excommunicated person are unlawful, if the excommunication has been pronounced by condemnatory or declaratory sentence. These acts of jurisdiction are invalid, saving the exception of Canon 2261, 3, namely if asked to administer the sacraments in danger of death. Otherwise they are valid and even licit, namely when requested by the faithful in accordance with the regulations of Canon 2261, 2, Canon 2264, 1549. Every excommunicated person, 1, is forbidden to exercise the rights of election, presentation, nomination, 2, cannot acquire dignities, offices, benefices, ecclesiastical pensions, nor any other offices in the Church, 3, cannot be promoted to orders. An act done against the rule of NN 1 and 2, is not invalid, unless the acting party be an excommunicatus vitandis, or was excommunicated by condemnatory or declaratory sentence. If such sentence has been pronounced, the excommunicated person cannot, moreover, validly obtain any papal favor, unless mention is made of the excommunication in the Pontifical Rescript. Canon 2265, 1550. After a condemnatory or declaratory sentence, the excommunicated person remains deprived of the fruits of the dignity, office, benefice, pension, position, which he has in the Church. The excommunicatus vitandis is deprived of the very dignity, office, benefice, pension, position. Canon 2266. Interdict 365, 1551. The faithful are obliged to avoid intercourse even in secular affairs with an excommunicatus vitandis, except husband or wife, parents, children, servants, subjects, and in general all who have a reasonable cause for dealing with such excommunicated persons. Canon 2267, Article 2. Interdict 1552. The interdict is a censure by which the faithful, though remaining in communion with the Church, are forbidden those sacred functions which are enumerated in the following canons. The prohibition is made either directly, by a personal interdict which prohibits to the same persons the use of the specified spiritual benefits, or indirectly, by a local interdict which forbids the administration or reception of some sacraments and sacramentals in certain places. Canon 2268, 1553. A general interdict, either local for the territory of a diocese or a country, or personal, for the people of the diocese or country, can be issued by the Holy See only, or at its command. The bishop may issue a general interdict for a parish or its people, and a particular interdict both local and personal. The personal interdict follows the persons wherever they go. The local interdict does not bind outside the interdicted place, but in that place all persons, also outsiders and those exempt, unless they have a special privilege, are obliged to observe the interdict. Canon 2269, 1554. The local interdict, whether general or particular, does not forbid the administration of the sacraments and sacramentals to the dying, but it prohibits in that place any divine services or sacred rites, with the exceptions mentioned in 2 of this canon and in canons 2271 and 2272, on Christmas, Easter, Pentecost, Corpus Christi, and the Assumption of the Blessed Virgin Mary, the local interdict is suspended and only the conferring of orders and the solemn blessing of marriage are forbidden. Canon 2270, 1555. If the interdict is a local general one and the decree does not explicitly state the contrary, the following rules govern. 1. The clerics, provided they are not themselves personally interdicted, are allowed to hold privately and behind closed doors. 366 The New Canon Law. Divine services and sacred functions in any church or oratory, but in silence and without ringing of church bells. 2. In the cathedral and in parochial churches and in any kind of a church which is the only one in a town, and in these churches only, one Holy Mass is allowed to be celebrated. Furthermore, there is allowed the keeping of the Blessed Sacrament, the administration of baptism, of Eucharist, penance, marriage without the nuptial blessing, funerals without any solemnity, blessing of the baptismal water and of the holy oils, preaching of the Word of God. In these functions, however, singing and display in sacred utensils and vestments, ringing of church bells, playing of the organ and of other musical instruments is forbidden. The Holy Viaticum shall be privately brought to the sick. Canon 2271, 1556. In a local particular interdict, if a certain altar or a shrine is interdicted in a church, no divine services and sacred functions can be held at such. If the cemetery is interdicted, the bodies of the faithful may be buried there but without any ecclesiastical rite. If the interdict was issued against a certain church or oratory, 1. If the church is a capitular one and the chapter is not interdicted, the rule of Canon 2271, n. 1, holds good, unless the decree of the interdict demands that the conventual Mass and the canonical hours be kept in another church or oratory. 2. If it is a parochial church, the law of Canon 2271, n. 2, shall be observed, unless the decree of the interdict substitutes another church for parochial functions for the time of the interdict. Canon 2272, 1557. If a city is placed under an interdict, also the suburbs are interdicted, not excepting exempt places, and the cathedral itself. If a church is interdicted, the adjoining chapels are also under the interdict, not, however, the cemetery. If a shrine in a church is interdicted, the whole church is not interdicted, and if the cemetery is interdicted, the church, though adjoining it, is not under the interdict but all oratories in the cemetery are interdicted with the cemetery. Canon 2273, 1558. If a community or college has committed a crime, the interdict can be placed either on the guilty parties individuali, or on the community as such, or on both, the community and the guilty individuals. Suspension 36. If the first is done, the rule of Canon 2275 is to be followed. If the second kind of interdict is imposed, the community or college cannot exercise any spiritual right proper to the community as such. If the third kind of interdict is issued, it has the combined effects. Canon 2274, 1559. Personally interdicted persons, 1. are not allowed to celebrate divine offices nor to assist at them, with the exception of sermons. If they assist passively they need not to be expelled, but if the interdict was imposed by a condemnatory or a declaratory sentence, or is otherwise notorious, they must be kept from active assistance which imports any participation in the celebration of divine offices. 2. They are forbidden to consecrate and to administer or receive the sacraments and sacramentals, in the manner specified in Canons 2260, 1, and 2261, 3. Interdicted persons are also subject to the restrictions of Canon 2265, 4. They are deprived of ecclesiastical burial, if the interdict has been imposed by condemnatory or declaratory sentence, as stated in Canon 1240, 1, n. 2, Canon 2275, 1560. The person who is under a local interdict, or under an interdict of a community or college, without having personally given any cause for the same may, if otherwise free from censure, and properly disposed may receive without absolution from the interdict or any other satisfaction the sacraments in accordance with the foregoing canons. Canon 2276, 1561. The interdict ab ingressu ecclesiae means the prohibition to celebrate divine offices in a church, or to assist at them, or to be buried from the church. If, however, such person assists, he need not be expelled, nor must his body be removed if he was buried in a church. Canon 2277, Article 3, Suspension, 1562. Suspension is a censure by which a cleric is deprived of the rights of his office, or benefice, or of both conjointly. The effects of suspension may also be separated one from the other, but unless the contrary is evident from other sources. 8. Suspension imposed in general includes all the effects enumerated in the canons of this article. Suspension from office or from 368. The new canon law. Benefice, however, imports only all the effects of either species. Canon 2278, 1563. Suspension from office simply, without any additional limitation, forbids not only any act of the power of orders and jurisdiction, but also of mere administration proper to an office, with the exception only of the administration of the goods of one's own benefice. Suspension 1. From jurisdiction. Ab jurisdiction, in general, forbids every act of the power of jurisdiction, in either form, and of both, ordinary and delegated jurisdiction. 2. Ad divinis forbids every act of the power of orders which one possesses, either by sacred ordination or by privilege. 3. From orders. Ab ordinibus, forbids any act of the power of orders received by ordination. 4. From sacred orders. A sacris ordinibus, forbids the exercise of the powers of major orders. 5. From the exercise of a certain definite order. A certo et definito ordine excrescendo, forbids any act of the specified order. The person suspended is, moreover, forbidden to confer the same order, and to receive a higher order, and if he should have received such an order while under suspension, he is forbidden to exercise the same. 6. From the conferring of a certain specified order. A certo et definito ordine conferendo, forbids the conferring of the order specified, not, however, of an inferior or superior order. 7. From a certain specified ministry. A certo et definito ministerio, for instance the hearing of confessions, or from a certain specified office, for instance a position to which the care of souls is attached, forbids every act of that ministry, or office. 8. From the pontifical order. Ab ordine pontificali, forbids the exercise of every act of the powers of the order of bishops. 9. From the pontificals. A pontificalibus, forbids the exercise of pontifical functions, which, according to Canon 337, 2, are those pontifical ceremonies at which the rubrics require the bishop to use mitre and crozier. Canon 2279, 1564. Suspension from the benefice. A beneficial, deprives of the revenue of the benefices with the exception of dwelling in the residence belonging to the benefice, but that suspension does not take away the right of administration of the goods of the. Suspension 369. Benefice, unless the decree, or sentence, of suspension does explicitly deprive the one so suspended of the right of administration, and give it to another person. If the beneficiary in spite of the suspension does take the revenue of the benefice, he is obliged to make restitution, and he can be forced by canonical penalties to make restitution, if necessary. Canon 2280, 1565. If suspension in general is inflicted, or a suspension from office or benefice, it affects all offices or benefices which the person suspended holds in the diocese of the superior who issued the suspension, unless the contrary is made evident by the wording of the suspension. Canon 2281, 1566. The local ordinary cannot suspend a cleric from a specified office or benefice which he holds in another diocese, but a suspension litisententiae, inflicted by the common law, affects all offices or benefices no matter in what diocese they are held by the one suspended. Canon 2282, 1567. The actions forbidden to an excommunicated person by Canon 2265 are forbidden also to suspended persons. Canon 2283, 1568. If a censure of suspension was incurred forbidding the administration of the sacraments and sacramentals, the rule of Canon 2261 is to be observed. If a censure of suspension was incurred forbidding acts of jurisdiction either in the internal or external forum, such an act if nevertheless performed is invalid, as for instance sacramental absolution, if the suspension was inflicted by a condemnatory or declaratory sentence of an ecclesiastical court, or the superior inflicting the suspension declared explicitly that he thereby revokes the very power of jurisdiction, otherwise the act is only illicit, and if the faithful request his ministry, as specified in Canon 2261, 2. The act is even licit. Canon 2284, 1569. If a community or college of clerics committed a crime, suspension may be inflicted either against the individual delinquents, or on the community as such, or on both, delinquents and community. If the delinquent individuals are suspended, the canons of this article are to be observed. If the community as such is suspended, the community is. 370. The new canon law, forbidden to exercise the spiritual rights proper to the community as a legal body. If both, individual delinquents and community, are suspended, the suspension has the combined effects so that not only the guilty individuals suffer, but also the community in those rights which require the action of the community as such. Canon 2285, Title 9, Punitive Penalties, 1570. Punitive penalties are those which directly tend toward the expiation of crime, so that their remission does not depend on the cessation of obstinacy of the delinquent. Canon 2286, 1571. From the infliction of punitive penalties the law grants appeal or recourse in suspensive, that is to say, the penalties are not taking effect pending the appeal unless the law in some case explicitly provides otherwise. Canon 2287, 1572. With the exception of the penalties of degradation, deposition, privation of office or benefice, and of cases where the reparation of scandal demands punishment of the delinquent, it is left to the prudence of the judge to suspend the execution of an ordinary penalty inflicted by condemnatory sentence, if the delinquent has committed an offense for the first time after a laudable life, under condition, however, that the guilty party if he commit another offense within the next 3 years, either of the same or of a different kind, shall incur the penalty of both the past offense and the new crime. Canon 2288, 1573. A punitive penalty ceases either by completion of the term of penance, or by dispensation granted by him who has legitimate power to dispense, according to Canon 2236, Canon 2289, 1574. In more urgent, occult cases, if the delinquent would have to betray himself, with resulting loss of his good reputation and danger of scandal, by observing the punitive penalty lati sentential which he incurred, any confessor may in the sacramental forum suspend the obligation of performing the penalty, but he must impose the obligation to have recourse within 1 month by letter and through the confessor, if this can be done without great inconvenience, to the penitentiary, or to the common punitive penalties. 371. Bishop if he has faculties, and to accept their orders, the name of the delinquent is not to be mentioned. If in some extraordinary case this recourse is not possible, the confessor himself can grant that dispensation, according to Canon 2254, 3, Canon 2290. Chapter 1, Common Punitive Penalties, 1575. Punitive penalties, which may affect all the faithful in proportion to the gravity of the offenses, are the following. 1. A local interdict, or an interdict on a community or college, either perpetually or for a definite period of time, or ad beneplacitum superioris, that is to say, as long as the superior does not lift the interdict. 2. An interdict from entering a church, ab ingressuicul siae, either perpetually, or for a fixed space of time, or at the will of the superior. 3. Penal transfer, or suppression, of an episcopal see or a parish. 4. Infamy of law. 5. Privation of ecclesiastical burial, according to Canon 1240. 1. 6. Privation of the sacramentals. 7. Privation or suspension for a time of a pension which one receives from a church or from ecclesiastical goods, or of any other ecclesiastical right or privilege. 8. Prohibition to exercise legal ecclesiastical actions. 9. Inability to receive in the church ecclesiastical favors or positions which do not require the clerical state, or to receive academical degrees conferred by ecclesiastical authority. 10. Privation for a time of the position, faculty or favor which one has already received. 11. Privation of the right of precedence, of active or passive vote, or of the right to wear titles, insignia and dress of honor conceded by the Church to distinguished clerics or laymen. 1-2. Money fines. Canon 2291, 1576. The penal suppression, or transfer, of an episcopal see is reserved to the Roman pontiff. That of a parish can be decided by the ordinary only with the advice of the chapter, or of the diocesan consultors. Canon 2292, 372. The New Canon Law, 1577. Infamy is divided into infamy of law and of fact. Infamy of law is that which is specified in certain cases by the common law. Infamy of fact is incurred when a person has lost his good reputation with good and seriously minded Catholics, on account of some crime which he committed, or wicked conduct, the judgment of which belongs to the ordinary. Neither kind of infamy will affect the person's blood relations or relations by marriage, except in the case where the pastor keeps in his house relations who lead a scandalous life whom he is bound to eject from his house, and if he does not do so after having been warned by the bishop, he may be deprived of his parish. Cf. Canon 2147, 2, n. 3. Canon 2293, 1578. He who suffers from infamy of law is not only irregular, as stated in Canon 984, n. 5, but is, moreover, incapable of acquiring ecclesiastical benefices, pensions, offices and dignities, and of performing legal ecclesiastical actions, of exercising any ecclesiastical right or office, and, finally, he must be kept from the exercise of the ministry and sacred functions. He who suffers from infamy of fact must be excluded from receiving any orders, according to Canon 987, n. 7, from dignities, benefices, ecclesiastical offices, and also from the exercise of the sacred ministry and from legal ecclesiastical actions. Canon 2294, 1579. Infamy of law ceases only by dispensation granted by the Holy See. Infamy of fact ceases when the good reputation has been re-established with good and seriously minded Catholics, considering all circumstances, and especially amendment of the guilty party made long ago. The bishop is to judge concerning the cessation of infamy of fact. Canon 2295, 1580. If there is question of things for the acquisition of which the common law makes a person capable, the penalty of inhability can be inflicted by the apostolic see alone. Thus, for instance, the deriment impediments in marriage, or irregularities for reception of orders, can be established by no authority inferior to the Holy See. Rights which have already been acquired are not lost by a supervening inhability, unless the penalty of privation is added to this inhability by the law. Canon 2296, 1581. Money fines inflicted by the common law, of which special punitive penalties 373. The same law does not specify what it is to be done with the money, and other fines imposed or to be imposed by particular laws are to be employed by the local ordinaries for pious purposes, not, however, for the benefit of the episcopal mensa or for that of the chapter. Canon 2297, Chapter 2, Punitive Penalties Special to the Clergy, 1582. Punitive penalties inflicted on clerics only are the following. 1. Prohibition to exercise the sacred ministry except in one specified church. 2. Suspension, forever or for a definite length of time, or at the discretion, ad beneplacitum, of the superior. 3. Transfer for punishment from an office or benefice held by the cleric to another, inferior 1. 4. Privation of some right connected with the benefice or office. 5. Inhability either for all or some dignities, offices, benefices and other positions proper to the clergy. 6. Penal privation of the benefice or office, with or without a pension. 7. Prohibition to stay in a certain place or territory. 8. Command to stay in a certain place or territory. 9. Privation of the ecclesiastical garb for a time. 10. Deposition. 11. Perpetual privation of the ecclesiastical garb. 12. Degradation. Canon 2298, 1583. If a cleric obtains an irremovable benefice, he can be deprived of the same only in the cases expressed by law. If he has a removable benefice, he may be deprived of it also for other, reasonable causes. Clerics who possess a benefice, office, dignity, may be forbidden for some time the exercise of merely some ministry connected with their position, for instance, to preach, to hear funds, etc. The cleric cannot be deprived of the benefice or pension under the title of which he was ordained unless other provision is made for his proper support. If he does not amend and lead a 374 the new canon law live in keeping with the clerical state, then, according to Canons 2303 and 2304, the Church may expel him from the ranks of a clergy, without being responsible for his maintenance. Canon 2299, 1584. If a cleric gives great scandal, and does not amend after being admonished, and the scandal cannot be removed in any other way, he may in the meantime be deprived of the right to wear the ecclesiastical garb. This privation, while it lasts, imports the prohibition to exercise any functions of the ecclesiastical ministry, and the privation of the clerical privileges. Canon 2300, 1585. The ordinary cannot command a cleric to stay in a specified place outside his own diocese unless he obtains the consent of the ordinary of that place, or there is question of a house of penance or correction destined not only for the clergy of one diocese but also for externs, or of a religious exempt house where the consent of the superior of the house suffices. Canon 2301, 1586. The command, as well as the prohibition, to stay in a specified place, and the placing of a cleric in a house of penance or in a religious house, especially if this is to last for a long period of time, shall be imposed only in more serious cases, in which according to the good judgment of the ordinary these penalties are necessary for the correction of the cleric and for the reparation of the scandal he has given. Canon 2302, 1587. Deposition imports the suspension from office as well as the inability for promotion to any offices, dignities, benefices, pensions, positions in the Church, as also the privation from those which the guilty cleric actually has, though he was ordained under their title. The obligations arising from ordination, as for instance the obligation of the divine office, celibacy, etc., for those in major orders, and also the clerical privileges remain to the deposed clerics. If the cleric loses by the penalty of deposition the benefice or office which served as a title for his ordination, and should not have any other revenue for decent maintenance, the ordinary should out of charity provide for him in the best possible way, in order that the deposed cleric may not be forced to go begging to the disgrace of the clerical state. The penalty of deposition cannot be inflicted except in the cases expressed in law. Canon 2303. Penal remedies 375, 1588. If the deposed cleric does not show any signs of amendment, and especially if he continues to give scandal and does not change his evil ways after being admonished, the ordinary may deprive him forever of the right to wear the ecclesiastical garb. This privation imports the loss of the clerical privileges and cessation of the obligation of the ordinary to provide maintenance for him as referred to in Canon 2303, 2, Canon 2304, 1589. Degradation includes deposition, perpetual privation of the ecclesiastical garb, and reduction of the cleric to the state of the laity. The penalty of degradation can be inflicted only for a crime to which the law attaches such a penalty, or if the cleric who has already been deposed and deprived of the clerical garb, has continued for a year to give great scandal. The degradation is either verbal, or by edict, 1e, inflicted by sentence only, which, however, has all its juridical effect immediately without any execution, or real, if the formalities prescribed in the Pontificalia Romanum are observed. Canon 2305, Title X, Penal Remedies and Penances. Chapter 1, Penal Remedies, 1590. Penal remedies are, 1. Monition, 2. Correction, 3. Precept, 4. Surveillance. Canon 2306, 1591. The ordinary shall admonish a person who stays in proximate occasion of committing an offense, or against whom there is a grave suspicion of having committed an offense. After inquisition by the ordinary has proceeded, the monition may be tendered either by the ordinary in person, or by another person delegated by him. Canon 2307, 1592. If by the conduct of some person scandal or grave disturbance of order arises, reproof is to be given by the Ord. 376. The New Canon Law. Nary or his delegate, which may also be done by letter. The reprimand is to be accommodated to the peculiar circumstances of the person, as well as to the fact in question. Canon 2308, 1593. The monition as well as the reprimand may be either public or secret. The public reprimand or monition is to be given either before a notary of the ecclesiastical curia, or before 2 witnesses, or by letter, in such a way that the receipt of the letter as well as of its contents can be proved by some document. If sent by letter, the notary should make an exact copy of the letter which was mailed, and which he should keep for future reference, and proof of the contents of the monition, and proof of receipt of the letter and the form of the return receipt of the registered letter is also to be kept. A public reprimand can be given only to a guilty party who has been convicted of the offense or has confessed to it. It is judicial, if given by the judge in court, or by the ordinary before the criminal trial commences. The judicial reprimand either takes the place of punishment, or is given to increase the punishment, especially when there is question of a recidivus. If the monition and reprimand were given secretly, proof of the same must nevertheless be had by some document, which is to be preserved in the secret archives of the curia. The reprimand as well as the monition may be given either once or repeatedly, according to the prudent judgment of the superior. Canon 2309, 1594. If monitions and reprimands have been given without producing results, or if no effect can be hoped to be secured by them, a precept should be issued in which is to be accurately indicated what the person in question is to do and to avoid, together with the threat of the penalty in case of transgression. Canon 2310, 1595. If the gravity of the case demands it, and especially if there is question of a person who is in danger of relapsing into the same crime, the ordinary may subject him to surveillance. Surveillance may also be prescribed for the purpose of increasing the punishment, especially against recidivi. Canon 2311, Penalties for Individual Crimes. 377. Chapter 2, Penances. 1596. Penances and the external phonem are imposed in order that a delinquent may either escape the penalty which might be imposed on him if a canonical trial were to be instituted against him, or also that a delinquent may obtain absolution or dispensation from a penalty which he has contracted. Thus, for instance, when a priest applies for faculty to absolve a penitent from a censure which he has incurred, the Holy See or the bishop imposes a penance which must be fulfilled by the penitent who asks for absolution from the censure. For an occult offense or transgression no public penance should ever be imposed. The penances are to be modified not so much in proportion to the gravity of the offense as rather to the contrition of the penitent, taking into account the condition of the person and the circumstances of the offense. Canon 2312, 1597. The principal penances are the precepts: 1. To recite specified prayers, 2. To undertake a pious pilgrimage or other works of piety, 3. To observe a special fast, 4. To give alms for pious purposes. 5. To make a retreat in a pious institution or a religious house for some days. The ordinary may add to penances the penal remedies of monitions and reprimand. Canon 2313, Part 3. Penalties for individual crimes. 1598. Canons 2314 to 2414 deal with the penalties inflicted by the Code on various, specified crimes. Some of these penalties are incurred by the very fact of committing the crime, ipso facto, or liti sententiae. Others are to be imposed by the competent authority, frendi sententiae, in case the offense is brought to the notice of the ecclesiastical superior. Penalties, frendi sententiae, are of the nature of a precept to the ecclesiastical judge to impose the specified penalty if the party is proved guilty in court. 378. The New Canon Law, Chapter 1. Penalties incurred ipso facto, liti sententiae. 1. Excommunications reserved to the Holy See specialists. Simo modo. 1599. 1. Such excommunication is visited upon him who desecrates the consecrated particles, or carries them off for an evil purpose, or keeps them for that end. Canon 2320. 2. On him who lays violent hands on the Roman pontiff. Such a person becomes ipso facto an excommunicatus vitandis. Canon 2343. 3. On the priest who absolves, or makes believe to absolve, his accomplice in a sin against the sixth commandment. Even in danger of death the priest cannot without incurring excommunication absolve his accomplice so long as another priest can be had without great danger of betraying the priest and giving scandal, except in case the sick person refuses to confess to another priest. The excommunication is incurred also when the penitent does not mention the sin of complicity, if the guilty confessor directly or indirectly induced the penitent not to confess the sin. Canon 2367. 4. A confessor who presumes to violate directly the seal of confession. Canon 2369. 2. Excommunications reserved to the Holy See specially. Modo befall. 1600. 1. All apostates from the Christian faith, and all heretics and schismatics. Canon 2314. 2. Publishers of books written by apostates, heretics, and schismatics, who advance the cause of apostasy, heresy, or schism, also those who defend such books, and others condemned by name through apostolic letters. Finally those who, knowing of the censure, read or keep such books without due permission. Canon 2318. 3. Those who are not ordained priests and pretend to celebrate Holy Mass or hear confessions. Canon 2322. Excommunications reserved. 379. 4. All persons of whatever station or dignity, even that of the Cardinalate, who appeal from the laws, decrees, or commands of the reigning Roman Pontiff to a general council of the Church. Canon 2332. 5. Those who have recourse to the civil authorities in order to impede the letters or documents of the Holy See or of its legates, preventing either directly or indirectly their promulgation or execution, as also those who on account of these letters or documents injure or terrify the authors of the same, or others on account of them. Canon 2333. 6. Those who publish laws, orders, and decrees against the liberty and the rights of the Church, as also those who, either directly or indirectly, impede the exercise of ecclesiastical jurisdiction both of the internal and external forum by having for this purpose recourse to any lay authority. Canon 2334. 7. Those who dare without due permission of the Church to cite before the civil court a cardinal, papal legate, or major official of the Roman Curia on matters arising from their office, or their own ordinary. Canon 2341. 8. Those who lay violent hands on a cardinal or a legate of the Pope, or on patriarchs, archbishops, and bishops, even though merely titular. Canon 2343. 9. Those who usurp or retain, by themselves or through others, goods and rights belonging to the See of Rome. Canon 2345. 10. Those who circulate false letters under the name of the Holy See, or falsify papal letters, decrees, rescripts, or knowingly use such letters. Canon 2360, 11. Those who wrongfully denounce to a superior either by themselves or through others, a confessor of the crime of solicitation, Canon 2363, 3. Excommunications reserved to the Holy See simply. Cider Befall, 1601. 1. Profiteers from indulgences, Canon 2327, 2. Those who joined the sect of the Masons, or other societies of the same nature that scheme against the Church or civil authority, Canon 2335, 3. Those who without due faculties presume to absolve, 380 The New Canon Law, from an excommunication reserved either specialist 3 imo or speciale modo to the Holy See, Canon 2338, 4. Those who aid or abet anyone in a crime for which he was declared excommunicatus vitandus, clerics who knowingly, and of their own accord, participate with such a one in divinis, and who admit him to divine services, Canon 2338, 5. Those who bring into the civil court a bishop, not of their own diocese, or a titular bishop, an abbot, a prelate nullius, or any of the supreme superiors of religious communities approved by Rome, Canon 2341, 6. Persons of either sex who enter without due permission the enclosure of nuns of solemn vows, and those who admit them to such place. Likewise women who enter the enclosure of religious men of solemn vows, as also superiors and others who admit them. Finally, nuns of papal enclosure who go outside of it without due permission, Canon 2342, 7. Those who retain unjustly church property of any kind, either by themselves or through others, or who thwart those who have a right to the income from church goods. Only after having made full restitution can they apply to the Holy See for absolution, Canon 2346, 8. Those who fight a duel, or who make, or accept, a challenge thereto, or who give any aid to it, or favor it, in any way, as also those who purposely go to see the duel, who permit it, or do not stop it in as far as they can, Canon 2351, 9. Clerics and major orders and religious of solemn vows who attempt to contract a civil marriage, as also all persons attempting to contract it with them, Canon 2388, 10. Those who are guilty of simony in the conferring of an office, benefice, and ecclesiastical dignity, Canon 2392, 1. 11. The vicar capitular as well as any of the members of the cathedral chapter, as also others outside the episcopal curia, who steal, destroy, conceal, or substantially alter any document belonging to the episcopal curia, Canon 2405, 4. Excommunications reserved to the ordinary are, those of 1602. 1. Catholics who marry before a non-Catholic minute sister, Canon 2319, 2. Catholics who contract marriage with the explicit or excommunications not reserved 381, implicit understanding that either all or some of their children are to be brought up as non-Catholics, Canon 2319, 3. Catholics who knowingly present their children to a non-Catholic minister for baptism, Canon 2319, 4. Catholic parents, or those who take the place of the parents, who knowingly have their children brought up or instructed in a non-Catholic persuasion, Canon 2319, 5. Those who prepare bogus relics, or who knowingly sell, distribute or expose them for public veneration, Canon 2326, 6. Those who lay violent hands on a cleric or a religious, Canon 2343, 7. Those who procure abortion, not accepting the mother, if abortion has actually taken place, Canon 2350, 8. Religious of non-exempt communities who apostatize from their religious life. Apostates of exempt orders incur excommunication reserved to the major superiors of the respective order, Canon 2385, 9. Religious of simple perpetual vows, both in orders and congregations, who contract marriage without dispensation, and the persons thus contracting with them, Canon 2388. V. Excommunications not reserved are those of 1603. 1. Authors and publishers who without due permit sign publish books of the Bible, or annotations and commentaries on the same. Canon 2318. 2. Those who dare to demand, or force, the Church to give ecclesiastical burial to infidels, apostates, and others excluded from ecclesiastical burial. Canon 2339. 3. Those who alienate church property and knowingly fail to obtain the beneplacitum of the Holy See, if the goods are of great value, namely, worth more than $6,000. All those implicated in such transaction by giving, receiving, or consenting, fall under the censure. Canon 2347. 4. Those who force another in any way to enter the clerical life, or a religious community, or to take vows, whether solemn or simple, temporary or perpetual. Canon 2352. 5. The faithful who neglect to denounce within 1 month the priest guilty of solicitation in confession. Canon 2368. 2. 382. The New Canon Law, vi. Interdicts incurred ipso facto. 1604. 1. An interdict reserved specially modo to the Holy See is incurred by any university, college, chapter, and other community of whatsoever kind, that appeals from the orders and decrees of the reigning sovereign pontiff to a general council of the Church. Canon 2332. 2. Those who knowingly celebrate, or make another celebrate, divine offices in places that are interdicted, as also those who admit excommunicated, or suspended, or interdicted clerics after their censure has been pronounced by condemnatory or declaratory sentence in court, incur an interdictabun gratuicus reserved to the authority whose law or command was violated. Canon 2338. 3. Those who are the cause of a local interdict, or of an interdict on a college or community, incur a personal interdict. Canon 2338. 4. Though there is no mention made of the reservation of this interdict, it is understood that in case an authority inflicts an interdict on an individual or a community, no one can free such person from the punishment except the one who imposed the penalty, or his successor in office, or the higher authority. 4. An interdictabun gratuicus, i.e. reserved to the ordinary, falls on those who of their own accord give ecclesiastical burial to persons not entitled thereto by law. Canon 2339. 7. Suspensions incurred ipso facto. 1605. 1. Suspensions reserved to the Holy See are incurred as follows. A consecrating bishop and his assistants, whether bishops or priests, who consecrate a bishop without leave from the Holy See are ipso facto suspended, as also the consecrated bishop, until the Holy See shall absolve them. Canon 2370. B. Clerics promoted by simony to orders, and those administering or receiving any other sacrament through simony, are ipso facto suspended. Canon 2371. C. Those who presumptuously receive orders from one who is publicly excommunicated, suspended or interdicted, or from a notorious apostate, heretic, schismatic, incur suspension a divinis, reserved to the Holy See. Canon 2372. D. Suspension from conferring orders for a year is in. Suspensions incurred ipso facto 383. Incurred by 1. Those who ordain a non-subject without proper demissorial letters. 2. Those who ordain a subject without testimonial letters, if after the age of puberty the ordinandus lived in another diocese for 6 months, or, in case of soldiers, for 3 months. 3. Those who ordain one to major orders without a proper canonical title. 4. Those who ordain religious when they have no right to be ordained outside the diocese in which the monastery of the candidates is situated. Canon 2373. E. A religious in major orders whose profession is null and void on account of deceit on his part is ipso facto suspended until the Holy See dispense him. Canon 2387. 2. Suspensions reserved to the ordinary. 1606. A. Clerics who without due permission from the ordinary sue in a civil court a priest, cleric or religious, incur suspension from office. Canon 2341. B. Religious who become fugitives, see Canon 644. 3. Incur suspension reserved to their own superior. Canon 2386. 3. Suspensions not reserved. 1607. A. Priests who hear confessions without proper jurisdiction are ipso facto suspended ad divinis. Those who presumptuously absolve from reserved sins are ipso facto suspended from the hearing of confessions. Canon 2366. B. Those who are ordained without demissorial letters, or with false ones, or before the canonical age, or by skipping some orders intentionally, are ipso facto suspended from the orders thus received. Canon 2374. C. Suspension ad divinis is incurred by those clerics who resign in office, benefice, or ecclesiastical dignity, into the hands of lay persons. Canon 2400. D. An abitur prelate nullius, who without necessity puts off his consecration for over 3 months after receiving the papal letters, ipso facto incurs suspension from jurisdiction. Canon 2402. E. A vicar capitular who gives demissorial letters contrary to Canon 958. 1. 3. Incurs ipso facto suspension ad divinis. Canon 2409. F. Religious superiors, who, in violation of Canons 967, send their subjects for ordination to a strange bishop, are ipso facto suspended for 1 month from the celebration of Mass. Canon 2410. 384. The New Canon Law. 8. Infamy of law incurred ipso facto. 1608. 1. Catholics who formally join a non-Catholic sect, or publicly adhere to it. Canon 2314. 3. 2. Desecrators of consecrated hosts. Canon 2320. 3. Persons who dishonor the memory of the dead by theft or other crimes committed on the bodies or the graves of the deceased. Canon 2328. 4. Those who lay violent hands on the Roman pontiff, cardinals, or papal legates. Canon 2343. 1. 5. Those who fight a duel, and their official witnesses. Canon 2351. 2. 6. Those who attempt a so-called civil marriage while their lawful husband or wife is living. Canon 2356. 7. Laypersons lawfully condemned for crimes of impurity with minors under 16 years of age, or for attack on women, sodomy, bawdry, incest. Canon 2357. 9. Loss of salary is incurred ipso facto by 1609. 1. Clerics who possess an office or benefice which requires residence, for instance a parish, ipso facto forfeit the right to the revenue or salary of their benefice or office, in proportion to the time during which they illegitimately absented themselves, and they are obliged to turn it over to the ordinary who is to use the money for the benefit of a church, or pious institution, or as alms for the poor. Canon 2381. 1. 2. Persons who neglect to make the profession of faith required by Canon 1406 in the appointment to certain offices and benefices forfeit the right to the revenue or salary of the benefice or office for the time that without a legal excuse for such delay they neglected to make the profession. Canon 2403. X. Loss of office or benefice incurred ipso facto by 1610. 1. Voters in elections by a college or community of clerics or religious, in which lay persons interfere with the rights and the freedom of the Church, if the voters solicited, or of their own accord admitted, such interference, are ipso facto deprived of the right to vote in that election, and the person thus elected, who knowingly consents to his election, becomes ipso facto in penalties. Frendi Sentential 385. Capable of acquiring the office or benefice in question. Canon 2390. 2. Those who have been elected, nominated or presented to an ecclesiastical benefice, office, dignity, and assume possession or administration before they have received the necessary letters of confirmation or appointment become ipso facto incapable hat office or benefice. The chapter or community who admits them before they have shown the letters of confirmation or appointment are ipso facto suspended ad beneplacitum s. Sedis from the right of election, nomination, presentation, Canon 2394, 3. He who knowingly accepts the appointment to an office, benefice, or dignity, which is not vacant by law, and allows himself to be put in possession of the same, becomes ipso facto incapable of obtaining the said office or benefice when it becomes actually vacant. Canon 2395, 4. Clerics who have obtained peaceful possession of another office or benefice which is incompatible with the former, and presume to keep possession of both against the ruling of Canons 156 and 1439, are ipso facto deprived of both. Canon 2396, 5. He who has been promoted to an episcopal see and neglects to be consecrated within 3 months, as required by Canon 333, loses the revenue of the episcopal see, which is to be applied to the benefit of the cathedral church, and if he delays his consecration for 3 more months he is ipso facto deprived of the bishopric. Canon 2398. Chapter 2. Penalties. Frendi sententiae. 1. Excommunication. 1611. Laypersons who are unfaithful in the handling of mass stipends may be excommunicated by the ordinary if their offense has been very serious. Canon 2324. 2. Interdict Frendi sententiae. 1612. 1. By interdictavam grossu ecclesiae are to be punished those who desecrate a church or cemetery by homicide or by copious spilling of blood by sinful action, by using the church or cemetery for impious or indecent purposes, by burial of an inch. 386 The New Canon Law. Fidel or of a person excommunicated by an ecclesiastical court. Canon 2329. 2. Bigamists who, in violation of the rights of their lawful partner, live in concubinage with another party, are after having been admonished without avail to be punished with personal interdict or with excommunication. Canon 2356. 3. Persons who violate the graves by theft, or abuse the bodies of the deceased for an evil purpose are to be punished with personal interdict. Canon 2328. 3. Suspensions Frendi sententiae. 1613. 1. Clerics suspected of heresy are to be suspended ad divinis. Canon 2315. 2. Clerics who knowingly teach or defend, either publicly or privately, a doctrine that has been condemned by the Holy See or by a general council, even though not as heretical, are to be suspended from preaching, hearing of confessions, and any office of teaching. Canon 2317. 3. Priests who against the law of Canon 806, 1, and 808 say Holy Mass twice the same day without permission, or who celebrate without keeping the Eucharistic fast, are to be suspended by the ordinary for a time to be determined by him. Canon 2321. 4. Clerics who trade with mass stipends, or do not fulfill the obligation of the stipend, or unjustly retain part of the stipend when having the Mass said by another, are to be punished severely by the ordinary, and if the transgression is very serious they may be punished with suspension and privation of office or benefice. Canon 2324. 5. A pastor who incites the people by word or writing to impede the exercise of jurisdiction of his ordinary, may, if the case is serious, be suspended. With the same penalty the ordinary shall punish a priest who excites the people in any manner to impede the entrance into the parish of a priest lawfully appointed as its pastor or administrator. Canon 2337. 6. Clerics who violate the enclosure of nuns of solemn vows, besides incurring excommunication reserved to the Holy See simplici modo, are to be suspended for a time by the bishop. Canon 2342. 1. Suspensions 387. 7. Secular or religious clerics in sacred orders, who live in concubinage and do not amend after having been admonished, are to be suspended ad divinis, and to be deprived of the revenue of their office or benefice, by summary trial as outlined in Canons 2176 to 2181, Canons 2359. 1. If they have committed acts of impurity with persons under 16 years of age, adultery, attack on women, bestiality, sodomy, bawdry, incest with blood relations or relations by marriage in the first degree, they are to be suspended, punished with infamy of law, and deprived of any office, benefice, dignity, and in more serious cases they are to be deposed. Canon 2359, 2-8. Priests who dare to give confirmation without having this faculty either by law or by indult of the Holy See, are to be suspended. If they knowingly exceed the limits of their faculty or indult, they are ipso facto deprived of the faculty of conferring this sacrament. Canon 2365, 9. Priests who commit the crime of solicitation in confession, as described in Canon 904, are to be suspended from the celebration of Holy Mass and the hearing of confessions, and if the gravity of the guilt demands it, they shall be declared incapable of hearing confessions, and be deprived of every benefice, office, dignity, active and passive vote, and declared incapable of ever acquiring these. In more serious cases they shall be degraded. Canon 2368, 1-10. Confessors who indirectly violate the seal of confession are to be punished with the penalties mentioned in the preceding paragraph. Canon 2369, 1-11. Clerics and major orders who fail in grave matters to observe the rites and ceremonies prescribed by the Church in the sacred ministry, shall after previous admonition be suspended. Canon 2378, 12. Clerics who do not wear the ecclesiastical garb, and, in countries where it is the custom, the tonsure, and have been admonished without result, shall, if in major orders, be suspended from their order unless they amend within 1 month. Clerics in minor orders ipso facto forfeit the clerical state if they do not heed the admonition of the ordinary. Canon 2379, 13. Clerics and major orders who abandon the office or work committed to them by their own ordinary without his permission, shall be suspended ad divinis for a time. Canon 2399, 388. The New Canon Law. 14. If a cleric after legitimate privation of, or removal from, an office or benefice does not relinquish the same, he shall after previous admonition be forced to obey by suspension ad divinis, and even by deposition if necessary. Canon 2401, 4. Degradation. 1614. 1. Clerics who formally join, or publicly adhere to, a non-Catholic sect are to be degraded, if they do not amend after having been admonished. Canon 2314, 3. 2. Clerics who lay violent hands on the Roman Pontiff are to be degraded. Canon 2343, 1, 3. Clerics guilty of voluntary homicide are to be degraded. Canon 2354, 2, 4. Clerics in minor orders guilty of very serious crimes against the sixth commandment, for instance fornication with minors under 16 years of age, sodomy, incest, may be deprived of the clerical state. Canon 2358. V. Deposition is incurred by 1615. 1. Clerics who desecrate the consecrated particles. Canon 2320. 2. Clerics who violate the graves of the dead by theft, or abuse the bodies of the deceased for any evil purpose. Canon 2328. 3. Clerics guilty of procuring abortion. Canon 2350. Vi. Suspicion of heresy falls on 1616. 1. Persons who knowingly and of their own accord help to propagate heresy in any manner, or who take an active part in the divine worship of non-Catholics, as forbidden by Canon 1258, Canon 2316. 2. Persons who contract marriage with the understanding that all or some of their children are to be raised as non-Catholics, parents who have their children baptized by a non-Catholic minister, and parents and guardians who have their charges instructed in a non-Catholic sect. Canon 2319. 3. Persons who desecrate consecrated particles. Canon 2320. 4. Persons of any state or dignity who appeal from the prohibition from legal actions. 389. Laws, decrees, orders of the Roman Pontiff to a General Council. Canon 2332. 5. Persons who continue obstinately in the censure of excommunication for 1 year, Canon 2340, 1, 6. All persons, not excluding those in the episcopal dignity, who knowingly, through simony, ordain others, or are ordained, and minister or receive the sacraments, Canon 2371. Canon 2315 provides that persons suspected of heresy are to be admonished to remove the cause of the suspicion, and if they fail to do so they are, if laymen, to be deprived of the right to legal actions, while a cleric, after a second admonition, is to be suspended ad divinis. All who, by law, are suspected of heresy are, after having been admonished and punished in the aforesaid manner, considered heretics, and become liable to the penalties for heresy if they do not amend within 6 months after the first punishment. 7. Prohibition from legal actions is to be inflicted on 1617. 1. Persons suspected to heresy, Canon 2315. 2. Persons who have attempted the crime of suicide, Canon 2350. 1, 3. Men guilty of rape, even though there be the intention of marrying the woman, or who elope with a girl of minor age without the knowledge or against the protest of parents or guardians, are ipso facto deprived of the right to legal actions, Canon 2353, 4. Lay persons, who have been lawfully condemned for the crime of homicide, of rape against those not of the age of puberty, of real slavery or selling of a human individual for any evil purpose, usury, robbery, theft of very large amounts, incendiarism or other serious destruction of property, grave mutilation, wounding, violence, are ipso facto deprived of the right to legal actions, and of any position they may have in the Church, Canon 2354, 5. Persons who have committed public adultery, who live in public concubinage, or have been lawfully condemned for other crimes of impurity, are to be forbidden the right to legal actions until they have given true signs of repentance, Canon 2357, 2, 6. Catholics who contract a mixed marriage, though validly, without a dispensation of the Church are ipso facto 390 the new canon law, deprived of the right to legal actions and of the sacramentals until they are dispensed by the ordinary, Canon 2375, 7. Religious who apostatize from their religious life, are in addition to incurring excommunication, ipso facto deprived of the right to legal actions and of active and passive vote, Canon 2385, cf. Canon 2256 which specifies the actions forbidden by this prohibition. 8. Various other penalties. Frendi Sententiae, 1618. 1. Privation of benefice, dignity, office, pension, or any other ecclesiastical position, and infamy of law is to be inflicted on apostates, heretics, schismatics, if after repeated admonition they do not amend. Canon 2314, 2. Laymen who pretend to hear confessions, or to say Holy Mass, are to be deprived of any position they hold in the Church, or any ecclesiastical pension. Canon 2322, 3. Clerics conspiring against the authority of the Roman Pontiff, his legates, or their own ordinary, and against their lawful orders, are to be punished with censures and deprived of dignities, offices, benefices. Religious shall be deprived of active and passive vote, and of the office they hold. Canon 2331, 2, 4. Clerics who have recourse to any lay authority to obstruct the exercise of ecclesiastical jurisdiction of either the internal or the external forum, or who join the Masons or any other society of the same nature, shall, in addition to the excommunication incurred in virtue of Canons 2334 and 2335, be punished by suspension or privation of their benefice, office, dignity, pension, or any other position in the Church. Religious who are guilty of these offenses shall be deprived of every office and of active and passive vote. Clerics and religious who join the Masons or any other similar society must, moreover, be denounced to the Holy Office. Canon 2336, 1, 5. If a cleric continues for 6 months in the censure of suspension, he shall be admonished to amend, and if 1 month from the admonition has elapsed without result he shall be deprived of his benefice or office. Canon 2346. Clerics who lay violent hands on a cardinal or papal legate are to be deprived of benefices, offices, dignities, pensions, or any other position they hold in the Church. Canon 2343. 7. Clerics who usurp or retain by themselves, or through various penalties. 391. Others, goods and rights of the See of Rome, besides incurring ipso facto excommunication reserved to the Holy See specially modo, are to be deprived of benefices, offices, pensions, and to be declared incapable of ever acquiring them. Canon 2345. 8. Clerics who unjustly appropriate to themselves church goods of any kind, or consent that others steal them, besides incurring ipso facto excommunication reserved to the Holy See simplici modo, are to be deprived by their ordinary of any benefice, and declared incapable of ever obtaining a benefice, and to be suspended for a time. Canon 2346. 9. If a religious superior or a procurator alienates without the formalities required by Canons 534, 1, and 1532, ecclesiastical goods worth more than $200 and less than $6,000, he shall be punished with privation of his office and with inability to acquire other offices. The ordinary and other clerics who have an office, benefice, or position in the Church shall pay double the amount to the Church or institution which they injured. Other clerics shall be suspended for a time. Canon 2347. 10. Clerics guilty of attempted suicide shall be suspended for a time, and removed from benefices and offices to which the care of souls either in the internal or external forum is attached. Canon 2350. 11. Clerics guilty of homicide, rape on persons under the age of puberty, selling of human beings into slavery or for any other evil purpose, robbery, theft in very large amounts, incendiarism or other serious damage to property, of grave mutilation, wounding or violence, are to be punished with penances, censures and privation of offices, benefices, dignities, according to the amount of guilt. Canon 2354. 12. Clerics who falsify letters, decrees, or rescripts, of the Holy See, or knowingly make use of bogus letters, besides incurring ipso facto excommunication reserved to the Holy See specially modo, are to be deprived of their benefice, office, dignity, pension. Religious are to be deposed from office and deprived of active and passive vote. Canon 2360. 13. Priests who do not attend the diocesan conferences are to be punished by the ordinary according to his judgment. Religious priests, who do not have the care of souls, but are approved for confession, are to be suspended from hearing. Con. 392. The new canon law fends of seculars if they, in violation of Canon 131, do not appear at the conferences. Canon 2377. 14. Clerics bound to residence in virtue of the office, benefice, or dignity which they hold, may be deprived of them in the manner laid down in Canons 2118 to 2175, if they seriously neglect the obligation of residence. Canon 2381. 15. He who, in violation of Canon 1406, neglects by his own fault to make the profession of faith before taking posses sign of the office or benefice, shall, if he, in spite of the admonition by the ordinary nevertheless continues in his negligence, be punished with privation of the office or benefice. Canon 2403. 16. Those who are obliged in virtue of their office to write or to keep the records of the various ecclesiastical curias or of parishes, are to be punished with privation of office, if they falsify, adulterate, destroy, or hide the records. Those who refuse to show the records to persons entitled to inspect them, or to transmit a copy of the records to those who legitimately ask for it, are to be punished with privation of office or suspension from office, or with money fines, according to the discretion of the ordinary. Canon 2406. 17. Those who demand fees for concessions of dispensations, etc., above the ordinary and legitimate charges as sanctioned by Canon 1507, are to be punished with heavy money fines, and if they again fail in the same matter they are to be suspended or even removed from office, besides having the obligation of making restitution of the money which they thus unlawfully received. Canon 2408, 18. Superiors of religious, both of men and women, who interfere with the canonical visitation by intimidating, or otherwise inducing, their subjects not to tell the truth, or who molest them for having spoken freely to the visitor, are to be declared by the visitor incapable of holding office, and to be deprived of the office they actually hold. Canon 2413, 19. Superioresses who interfere with the liberty the Code grants in the matter of the confessions of the sisters, Canons 518-530, are to be admonished by the ordinary, and, if they fail again, to be removed from office, of which proceeding the ordinary shall notify the Congregation of the Religious. Canon 2414, Index of Subjects. The numbers refer to paragraphs. Abbot to be called to a General Council 154, in charge of a monastery must obtain abbatial blessing from the bishop within 3 months. 470. Is suspended from jurisdiction if he neglects to receive the blessing. 1607. D. Nullius, what the term signifies. 206. His rights and duties. 207-209. Jurisdiction over the religious. 346. Nullus, if consecrated bishop, has the same rights as a bishop in reference to ordinations. 800. Abortion punished with excommunicati and ipso facto reserved to the ordinary. 1602. 7. Irregularity incurred by. 828. 4. Abrogation, how laws are repealed. General Laws 6, Particular Law 22-23, Customs 30. Of favors granted by Rescript 47, absence from diocese forbidden to clerics without leave of the bishop. 119. 310. Absolution, priests presuming to absolve from excommunications reserved to the Holy See. Specialissimo and specially modo incur excommunication reserved. Simpliciter 1601. 3. Those who absolve from reserved sins without faculties are ipso facto suspended from the hearing of confessions, and those who hear confessions without jurisdiction are ipso facto suspended. Ad Divinis 1607. A. Abstinence, law of, what it forbids. 1093. Abstinence days. 1095. Who is bound by the law of abstinence. 1097. Accomplice in sins of impurity cannot be validly absolved by the guilty priest except in danger of death. 727. Priest absolving his incurs ipso facto excommunication reserved to the Holy See. Specialissimo modo 1599. 3. Acta Apostolici Citis, the official organ of the Holy See. 9. Actions of legal persons. 78. Legal, what the term signifies. 1540. Prohibition from for certain offences. 1617. Acts of plenary and provincial councils to be approved by the Holy See. 197. Administration of the goods of religious. 382. Of ecclesiastical goods. 1025-1030. Roman Pontiff Supreme Administrator. 1312. Bishop for his diocese. 1313. Board of Diocesan Administrators. 1314. Charitable Institutions. 1315-1316. Their duties. 1317. Financial Statement. 1319. Administrator Apostolic appointed by the Holy See. 199. Taking posse scion of his office. 200. Rights and duties. 201-205. By special faculty appointed by another bishop or archbishop. 276. Admission into a religious community. 383. To services in church must be free of charge. 1024. Adoption, legal, impediment of marriage. 923. Adultery, reason for separation of married people. 972 and 973. Adults, baptism of in danger of death. 595. Formula of baptism for by permission of the bishop. 598. Advena, what the term signifies. 68. Affinity, what constitutes. 74. Impediment of marriage. 920. Age, 7 years of required to become subject to the laws of the 393, 394. The New Canon Law. Church 12, Major 65 and 66, Minor 66, Domicile of minors 70, Impediment of in marriage 910, Agent, clerics must not act as for property and goods of others 115. Agreements, special between Count Tries and the Holy See remain in force 3. Alienation of ecclesiastical goods 1324 to 1329, without the beneplicitum of the Holy See punished with excommunication if the goods are of great value 1603. 3. All Souls, indult to say 3 holy masses on day 649, all altars of churches privileged on that day 760. ALMS. Mendicant orders living as such have the right to collect alms in their own diocese 466, to beg in another diocese they need the permission of the bishop 467. 469. Altars, various kinds 1040, material 1041, consecration 1042, loss of consecration 1043, title of 1044. Bodies must not be buried under or near the 1045. Apostate from religious life, definition of 489 and 490. Apostolic See, what is meant by the term 7, appeal in marriage cases 1412 to 1415, in removal of pastors to be made to the Holy See 1430, from censures 1527, from punitive penalties 1571, from Pope to General Council by any person punished with excommunication 1600, 4. Interdict incurred by university or community guilty of this offense 1604, 1. Application of Holy Mass by the pastor for the parish 311, by the bishop for the diocese 220. For what persons Holy Mass may be applied 652. Appointment to ecclesiastical offices to be done in writing 126, of bishops subject to consistorial congregation 168, exclusive right of the Holy See 213. Bishop who is appointed must be consecrated within 3 months 214. Approval of religious organizations 333. 3. Arbitration. Settlement of dispute by 1355 to 1358. Archbishop to be called to a general council 154. His rights and privileges in reference to his suffragans 191. Convokes provincial council 195. His duty to report to the Holy See a suffragan who neglects to give confirmation 628. ARCH confraternities. Definition of 563. What confraternities they can affiliate 564, what indulgences are communicated by due affiliation 565, conditions for valid affiliation 566, archives of the diocese, how to be kept 256, permission to take out documents 259, secret how to be kept 260, right of the faithful to ask for copy of documents of diocesan or parochial 261, arts unbecoming to the clergy forbidden them 114, assistance to the pastor 320-322, associations, what societies are forbidden to the faithful 529, bishop asks consent for erection of 531, persons eligible for membership. Religious need permission of superior 538, when inscribing of name is essential for validity 539, privation of membership 541, rights of societies 542, chaplain and prefect 543 J suppression 544, various kinds 545, precedents 546, attempted crime. How far its guilt extends 1496 and 1497. Auxiliary Bishop 231. Bail. Clerics forbidden to furnish bail for anyone without permission of Bishop 113. Bans of marriage to be announced by the proper pastors of both par. Index of subjects 395. Ties 865 and 866. When and how many times 867. Mixed marriages as a rule not to be announced 869, faculty of bishop to dispense with the 871, Marriage of conscience can be allowed only by the ordinary 947. Baptism makes one subject to the laws of the Church 64. Definition of solemn and private 580. Minute Sister 581. Subject 588. Of fetus 589. Abandoned infants 592. Infants of infidels 593. Of Protestants and apostates 594. Blessing of baptismal font reserved to pastor 307. 7. Baptism of adults in danger of death 595. Of mentally affected persons 597. Rites and ceremonies. Bishop may allow formula of infant baptism for adults 598. Child to be baptized in right of the parents 599. In solemn baptism use of baptismal water obligatory 600. Manner of baptizing 601. Private and danger of death 602. Name of saint to be given 604. Sponsors should be employed in solemn and in private 605. In conditional 606. Conditions for valid sponsorship 608. For illicit sponsorship 609. Extent of spiritual relationship 611. Duties of sponsors 612. Time and place may be given any day 615. Conditions under which solemn baptism may be given in private houses 619. Recording and proof. Pastors must keep baptismal record. How illegitimate children are to be registered 620. One witness sufficient to prove 622. In baptismal record note to be made of ordination to subdiaconship 854, and of solemn religious profession 421. Catholics who have their children baptized by non-Catholic minister are ipso facto excommunicated 1602. 3. Beatification, cases of subject to S. Congregation of Rites 173, process of 1425. Bells, blessing of church 1012. Benefice, definition of 1252. Endowment or revenue 1253. Various kinds 1254, authority to erect 1257, conditions made by a benefactor in the erection of 1260, uniting of several 1262, what benefices the bishop cannot unite 1267, to unite a parish with a religious by full right requires permission of the Holy See 1268. Transfer of benefice 1269, division of parishes 1270 and 1271, pension imposed on 1272, resignation of 1279, beneplacidum of Holy See necessary, to give a parish to a religious order, or a college 297, to reduce an irremovable parish to a removable 299. For the founding of a house of exempt religious 342, for contracting of debts by religious if sum is over $6,000 379, bequest in favor of the Church 1307, Bible, publishing the notations and commentaries without permission punished with excommunication 1603, 1. Bination of Holy Mass not allowed except by papal indult or permission of local ordinary, who can grant it only for Sundays and holy days of obligation and never for more than 2 Masses a day 649. Birthplace, what is considered one's birthplace 67. Bishop, dispensations and other favors refused by cannot validly be granted by Vicar General 41. What papal rescripts of favors and dispensations have to be shown to the 43. Can grant dispensation from the common law when recourse to Rome is difficult 58. From particular laws 59, residential to be called to a general council 154, source of jurisdiction 210, requisites for candidates for episcopate 396. The new canon law, Pate 212, can exercise jurisdiction after taking canonical possession 215, privileges of all 230, proper to residential 230, 2. What is to be done when is hindered in the exercise of his jurisdiction 274, during vacancy 275 and 276, not held to ecclesiastical law and prohibition of books 1244, can dispense others from this law in individual cases. 1245. Do not incur suspensions and interdicts liti sententiae unless they are explicitly mentioned. 1511. Blessing, apostolic, may be given by any priest assisting the dying. 313. Blessing of baptismal water and of houses reserved to pastor. 307. 6 and 7. Blessing of baptismal water in case of necessity. 600. Blessing of sacred utensils who has the faculty. 1147. Books, matter of prohibition of subject to holy office. 167. What Catholics may not publish without ecclesiastical approval and who is to give approval. 1228. Clergy must submit also writings on secular topics. 1229. On indulgences need papal imprimatur. 1231. Reprints of liturgical. 1233. Translations of the Holy Scriptures. 1234. Duty of the censor. 1236. How imprimatur is to be printed. 1237. Right of the Church to prohibit. 1238. Forbidden by law. 1242. Cardinals and bishops not bound by ecclesiastical law. Forbidden. 1244. Power of the bishop to dispense. 1245. Dispensation of the Holy See. 1246. 1248. Breviary. See divine office. Burial, ecclesiastical, bodies of the faithful to be buried in consecrated ground. Cremation forbidden. 1046. What is meant by 1047? Persons to be denied. 1083 and 1084. Those who give to persons not entitled are ipso facto under interdict ab ingresso ecclesiae. 1604. 4. See also funeral, business or gainful occupations not to be conducted by clerics or by others in their name. 118. Camera Apostolica, its rights and duties. 182. Canonization, cases of subject to s. Congregation of Rites. 173. Process of 1425. Cardinals are to be called to a general council. 154. Creation and privileges of 161. Do not incur penal ties unless explicitly mentioned. Cases, civil and criminal of clerics must be judged in the ecclesiastical court. Permission needed to bring suit to civil court. 97. Cassock, see garb. Catechetical instruction, duty of pastor. 1172 to 1176. Cathedradicum, by whom to be paid. 1298. Cathedral chapter, when it has the right to elect a vicar. Capitular. 276 and 277. Celebrant, see Mass. Celebrate, unknown priests who wish to say Mass in a church must exhibit. 647. Cemeteries to be blessed. 1048. What to be done if state laws do not allow. Catholic. 1049. Exempt religious may have of their own. 1051. Part to be reserved few the clergy and infants. 1052. Permission of bishop needed to transfer bodies. From 1057. Right of the faithful to choose for their burial. 1066. Censorship, see books. Censures, when persons under may or may not receive dispensations and favors. 36. Definition of 1525. What offense is to be punished with. 1526. Appeal from 1527. How they are multiplied. 1528. Reserved and non-reserved. 1529. Index of subjects. 397. 1531. Absolution in ordinary circumstances. 1532. 1535. 1537. In danger of death. 1536. In urgent cases. 1538. Three kinds of 1539 and 1540. General Principles of Excommunicati in 1541 to 1551. Of Interdict 1552 1561. Of Suspension 1562 to 1569. See each censure under its own heading. Cessation of Delegated Jurisdiction. 138. Of ordinary jurisdiction 139. Chancellor, his appointment and office in the diocese 253. Chaplain, military 296. Of church societies and confraternities 543. Of institutions 309, 324, 374. Charity, obligation of the religious to support a needy woman for some time after she has been dispensed from religious vows 488. Children under 7 years of age not subject to purely ecclesiastical laws 12, 65. Conditions under which they are to be admitted to Holy Communion 697. Under age of puberty do not fall under censures Litisentkanchai 1514. Christmas, indult to say 3 Holy Masses 649, and to take stipend for each 667, indult to say 3 Masses at midnight in religious and pious institutions and to give Holy Communion 664. Church, Catholic, has independent right to choose men for ranks of the clergy 86. What is meant in law by the term church 1004. Churches cannot be built without consent of local ordinary 1005. Blessing of cornerstone reserved to ordinary or major religious superior 1006. Must be blessed before services can be held in 1008. Consecration 1009. Titular feast 1010 and 1011. Loss of consecration and blessing 1013, 1015. Reconciliation of desecrated 1019 and 1020, what is forbidden in 1021, right of refuge 1022, admission to services must be free of charge 1024, church goods and their administration 1025 to 1030, those who celebrate an interdicted or admit publicly censured clerics to officiate incur the interdict ab ingressu ecclesiae 1604, 2, clergy. By divine right distinct from the laity 84, clerics are called those who have first tonsure, various degrees 85, must belong either to a diocese or a religious community 88, rights and privileges 95-99, in major orders cannot validly contract marriage 108, 915, must say the divine office in, outward appearance 112, forbidden to indulge in games of chance, to go to saloons 114, forbidden without bishop's consent to go bail for any person 113, not allowed to practice medicine and surgery, not to run for public offices 115, must keep away from improper theatricals, shows, dances 116, not conduct secular business 118, must keep residence 118 and 119. Punishment for breaking the law of residence 1452 to 1459, how are reduced to the lay state 142 and 143. Closed season for marriage 951. Coadjutor bishops 231-236. College, superior of a not to hear confessions of pupils 734. Common law, sea law, communication of privileges, general principle 49. Between religious orders abolished 458. Communicatio in divine services of non-Catholics, see heresy. Communion, regulation for holy of religious merely directive 44 QGA priest ordinary minister of, deacon with bishopess or pastoress permission for grave reason 688, before and after private mass 689, devotional of the sick not reserved to pastor 692. Holy Viaticum is parochial rite 693, in case of 398. The new canon law, necessity priest can give to the sick hosts consecrated by a rite different from his 694, admittance of adults 696, of children 697, who is not to be admitted 698, confession necessary, if in mortal sin and there is a possibility 699. Only once a day may be received 700, Eucharistic fast and dispensation for certain cases of illness 701, Easter obligatory 702, frequent, urged 706, obligation to receive in danger of death 707, may be received in any rite even for Easter duty 709, during Mass priest must not go out of sight of altar to give 711. May be given wherever Holy Mass is allowed to be said 712, may be given every day except Good Friday, and on Holy Saturday only during the Mass or immediately after it. 710. Competency, controversy relative to the competency of the congregations and offices of the Roman Curia, how to be decided. 165. Compromise by arbitration. 1355. Concordats between the Holy See and nations remain in force. 3. Concubinage, manner of procedure against clerics living in 1460. 1465. Condition under which rescripts are valid. 39. Marriage impediment of, attached to the consent. 935. Conferences, diocesan, must be attended by all pastors and assistants both secular and religious. 107. Conference of bishops of a province to be held every 5 years. 198. Confession, duty of the clergy to go frequently to. 101. Required as a condition for indulgences. 774. Confession of religious, in clerical orders and congregations, confessors to be appointed for each house, superior not to hear confessions of his subjects. 363. Subjects also of exempt orders may lawfully confess to any approved priest of the diocese for the sake of peace of conscience. 364. 2. In houses of sisters, a confessor to be appointed, a special confessor not to be refused when asked for by a sister. 365. An extraordinary confessor for each house, other priests to be given faculties to hear the sisters so that they can be called when a sister wants a special confessor. 366. In any church, public or semi-public oratory, the sisters may confess to any priest approved in the diocese. 367. At the time of serious illness any approved priest may be called by the sister. 368. Otherwise special approval is necessary to validly hear confession in a convent. 719. Regulations regarding the appointment of ordinary and extraordinary confessor. 369. 372. 3. In local religious organizations of men, an ordinary and extraordinary to be appointed. 373. If the order is exempt, the superior designates the confessor. 374. Manifestation of conscience not to be demanded by superior. 375. Religious shall confess once a week. 440. 3. Persons not ordained priests presuming to hear confessions are excommunicated. 1600. 3. Priests who hear without jurisdiction are ipso facto suspended ad divinis. 1607. A. Confirmation, how to be given. 623. Holy chrism must be blessed by a bishop, anointing not to be done with instrument. 624. Bishop in his diocese may also confirm non-subjects. 626. Obligation of bishop to administer. 628. Conditions for valid and licit. 629. Obligation to receive. 630. Age. 631. Sponsor to be employed should not present more than 2 candidates. 636 and 637. Conditions for valid sponsorship. 638. Conditions for licit sponsorship. 639. Spiritual relationship, index of subjects. 399. And duties. 640. Record and proof of. 641. 643. Priest who attempts to give without papal indult is to be suspended. 1613. 8. Confraternities, definition of 552, must be erected by formal decree. 553. Only one of the same kind in one place, though bishops may allow several in large cities. Certain confraternities to be established in every parish. 556. Forbidden to be erected in churches and chapels of religious women. 557. Special permission of bishop needed for wearing habit of in sacred functions. 558. Bishop has right to confirm or annul the election of officers by the. 560. Administration of their goods. 562. Congregations, Roman, 166. 177. Congregations, religious, of papal law, definition of. 333. 31. Right of visitation by the bishop of clerical and local. 357. 2 and 3. 5. Procurator General in Rome. 362. How far they are subject to the bishop in financial affairs. 380. How far they are exempt from the jurisdiction of the bishop. 463. Need permission of the Holy See to go in quest of alms. 467. Consanguinity. How degrees are figured. 73. Impediment of for marriage. 919. Conscience. Questions of decided by S. Penitentiary. 178. Marriage of 947. 950. Consecrations can be performed by bishop or by priest with papal indult. 990. Are invalid unless given in the prescribed form. 991. Of a bishop without the permission of the Holy See punished with suspension. 1605. A. Consent. Rules for actions in which the of others is required. 82. Consent. Matrimonial. Marriage affected by. 924. What knowledge is necessary for valid. 925. J. Impediment of error. 926. 928. If essential qualities of marriage are positively excluded is invalid. 929. Impediment of fear or force. 930. Consent to be given in words if parties are able to speak. 931. By proxy. 932. Condition attached. 935. Supposed to persevere even if marriage is invalid by some impediment. 936. Constitutions. Changes in the of diocesan religious congregations. 340. Consultors, diocesan, to be appointed in dioceses where there is no cathedral. Chapter 268. Nomination by the bishop. 269. 271. Their number. 270. Duration of office. 271. Take the place of the cathedral chapter and have the same rights and government of the diocese as the chapter. 272. Removal of consultors. 273. Consultors, parochial, their appointment and number. 262. New appointments. 263. Duration of office. 264. Removal from office. 265. Duties. 266. In the same case one person cannot act as both examiner and parochial consultor. 267. Contracts. How far error in affects the transaction. 81. Civil law on to be followed in ecclesiastical matters. 1323. Conditions prescribed for concerning immovable goods. 1324. What superior can give permission. 1326 and 1327. Donations by rector from church goods. How far allowed. 1329. Sale of church goods. How to be conducted. 1333 and J. 3345. Leasing of church property. 1335 and 1336. Loan from church goods. 1337. Cornerstone, blessing of, reserved to local ordinary for non-exempt churches, to religious superior for exempt churches. 1006. Council, general, cannot be held except by authority of Roman Pontiff. 153. Persons to be called to. 154 and 155. Provincial and national sub. 400. The new canon law. Object to approval by S. Congregation of the Council. 170. Holy See appoints a legate to plenary. 192. Persons to be called to plenary. 193. Provincial to be held every 20 years. 194. Archbishop convokes provincial. 195. Persons to be called to provincial. 196. Court, ecclesiastical, matters subject to trial by. 1347. Persons forcing into the civil a cardinal, papal legate, their own ordinary, incur excommunication. Specially modo reserved to the Holy See. 1600. 7. Bishops, abbots, supreme superiors of religious orders, excommunication reserved. Simpliciter. 1601. 5. Clerics who without permission sue a cleric or religious and civil are ipso facto suspended from office. 1606. A. Crime, impediment of marriage. 918. Curia, diocesan, persons constituting. 244. Persons to be nominated in writing, must take oath. 245 and 246. Customs, immemorial, remain unless explicitly rejected by the Code. Ordinary contrary to laws of the Code are abolished. 5. To become law need consent of legislator. 25. Who can introduce. 26. Conditions for contra. Jew. 27. Prater. Jew. 28. Abrogation of 30. Danger. Laws passed to safeguard against common of sin oblige also those for whom by exception there is no danger. 21. In of death any priest may absolve from all sin and censure. 725. Dat area apostolica. Rights and duties of this office. 181. Day, means in law a period of 24 consecutive hours. 32. Dean, appointed by bishop. 290. Removable at will of bishop. 291. His duty of inspection, in illness or death of pastor. 292. In reference to conferences. 293. Report to the bishop. 294. Seal of the deanery. 295. Deaneries. Diocese to be divided into districts by bishop. 148. Debts. Clergy must not delay to pay their 99. Religious forbidden to contract over $6,000 without permission of the Holy See. 379. Who is liable for contracted by religious. 381. Decimi. 1296. Defensor vinculi. His rights in marriage cases. 1393 to 1395. 1410. Duty to appeal. 1412. Degradation, by penalty of cleric is reduced to the lay state. 142. How the penalty is to be inflicted. 1589. Crimes for which is to be inflicted. 1614. Degrees of consanguinity how to be figured. 73. Of affinity. 74. Academical and ecclesiastical institutions of learning subject to S. Congregation of Seminary and University Studies. 176. Delegate Apostolic, his rights and duties. 187. Expiration of office. 188. Privileges. 189. Delegate in the execution of rescripts of dispensations and other favors. 46. Who acts beyond his commission acts invalidly. 134. What has power when several are appointed for the same affair. 136 and 137. Delegated jurisdiction, when and how ordinary jurisdiction can be delegated. 130. Insulatum and collegialiter. 136. How it ceases. 138. Power of orders cannot be delegated. 141. Departure from religious life permitted at expiration of temporary vows. 482. Deposition of a cleric. 1587 and 1588. Crimes for which it is to be inflicted. 1618. Deputy, clerics not allowed to seek office of without permission of bishop. 115. Index of subjects. 401. Desecration of a church by certain crimes. 1015. Demissorial letters of secular clergy. 801. 806. Of religious. 807. 810. Clerics ordained without or ipse facto suspended. 1607. B. Diocesan religious congregations. What are 333? 3. Conditions under which bishop can erect. 337. Cannot be suppressed except by the Holy See. 338. Bishop can demand financial statement. 380. Diocese, erection of reserved to the Holy See. 146. 168. Division of into parishes. 147. Dismissal of novices. 416. Crimes by which a religious is dismissed ipso facto. 491. Of religious and temporary vows in any order or congregation. 492. By temporary vows are dissolved. 493. Of religious in perpetual vows in non-exempt clerical and all local orders. 494. 498. Of religious in perpetual or in solemn vows in exempt orders and congregations. 499. 513. Status of dismissed religious who had perpetual vows. 514. 517. Disparity of cult subject to holy office. 167. Impediment of marriage. 913. Dispensation not valid unless the promises are made and there is grave reason to dispense. 904. 914. Falling privilege cannot be made use of in marriages with dispensation. From 963. No formal trial needed to declare marriage invalid on account of. 1416. Dispensation, who may receive. 36. Rescripts of in marriage impediments. 39. 885. 897. If asked of one Roman congregation and refused, it cannot be asked of another or of the bishop. 40. refused by the Vicar General cannot validly be granted by the bishop unless the petitioner mentions refusal of Vicar. 41. Rules concerning of marriage impediments. 886-900, who can grant from the Common Law. 67 and 58, from Particular Laws. 59, how should be given. 61, interpretation of. 62, cessation of. 63, of the Holy See dissolves matrimonium radum non consummatum of Christians. 962, of vows. 1155 and 1156, divine office. Clerics and major orders are obliged sub gram to say in, must be said in choir by all religious having the obligation of the choir, solemn professed also bound to private recitation. 455, documents, stealing, destroying, etc., of episcopal archives punished with excommunication reserved to the Holy See. Simpliciter. 1601, domicile. Persons who have or quasi-domicile in a diocese are held to the particular laws. 13, of parents determines birthplace of children. 67, how is acquired. 69, of wife and minors. 70, by person obtains proper ordinary and pastor. 71, loss of. 72, donations, by religious to be made only by way of alms. 382, by prelates and rectors from church goods. 1329, to rectors of churches generally presumed to be for the church. 1330, doubt, in positive and probable the church supplies jurisdiction. 140, dowry to be furnished by candidates and sisterhoods before novitiate. 392, it is acquired by the religious community at the death of the sister. 393, investment of and account to be given to bishop. 394 and 395, to be returned to a sister who leaves religious life. 396, dual, excommunication reserved to Holy See. Simpliciter. 1601, 8. Easter communion obligatory for all who have reached the years of discretion. 702, for children obligation. 402. The new canon law rests chiefly with parents. 703, may be received in any rite in church though preferable in one's own. 709, economist takes care of the temporal affairs of the diocese. 287 and 288, in religious communities the local superior may in case of necessity hold the office of but the provincial and general superior may not. 361, enclosure, papal, of obligation in all houses of solemnly professed religious, provincial and general have the right to fix the limits. In houses of nuns with solemn vows the bishop has right to indicate limits. 442, who may or may not be admitted inside. 443, special rules for of nuns. 445-448, in houses of sisters with simple vows. 449, permission of the Holy See required for absence of religious over 6 months except for cases of study. 451, violation of punished with excommunication. 1601, 6. Exceptions for highest ruler of country, for workmen, doctors, etc. 443 and 445, engagement of marriage, conditions for its validity. 860, equity demands that a religious woman if poor be supported for some time after leaving the religious community, bishop to decide in case of disagreement. 488, error in rescripts of dispensations and favors. 42, in actions of legal bodies. 81, in common church supplies jurisdiction. 140, under what conditions invalidates marriage consent. 926-928, Eucharistic fast for priest, subject to holy office. 167, to be observed from midnight. 651, priests to be suspended if they celebrate without keeping the. 1613, 3. Eucharist, blessed, definition of. 644, Holy Mass. 645-687, see Mass, Eucharist as sacrament. 688-712, see Communion. In what churches may be kept. 1108 to 1110, how it is to be kept. 1111 to 1116, private exposition. 1117, examination, newly ordained priests must pass annual for 3 years. 106, by bishop of candidates for novitiate and profession and sisterhoods. 397, before bishop of all candidates for orders. 839-840, For approval for confessions 717. Examiners, synodal, appointment and number 262, new appointments 263, duration of office 264, removal from office 265, duties 266, may be also parochial consultors not, however, in the same case 267, their part in the removal of pastors 1428. Excardination, letter of perpetual and unconditional required before incardination in another diocese 89. Vicar General cannot issue letters of without special mandate 90, effected by perpetual vows 92. 430, takes effect only at the moment of incardination in another diocese 93. Excommunication, when persons under may or may not receive dispensations and favors 36. Definition of 1541, Vitandus and Tolerantus 1542. What is forbidden to persons under 1543 to 1547, 1549, concerning the exercise of jurisdiction of excommunicated priests 1548, E. Communicatus Vitandus 1550 and J. 55, reserved to the Holy See Specialissimo Modo 1599, Special Modo 1600. Simpliciter 1601, reserved to the ordinary 1602, not reserved 1603, persons aiding or abetting an excommunicus vitandus fall into reserved to the Holy See Simpliciter 1601, 4, Frendi Sententiae 1611, Executor in Rescripts 43 and 46, Exemption. Bishop may exempt religious houses and pious institutions from jurisdiction of pastor 309, religious organizations having the index of subjects 403, privilege of 345, extent of the bishop's right of visitation of exempt religious 357, orders of men and women with solemn vows are exempt 460. The religious must obey the bishop's law concerning mass stipends 674. Exposition of Blessed Sacrament, public and private when allowed 1117. 40 hours 1118. Faculties granted to bishop belong also to vicar general, how they are to be interpreted 50, how they are conceded and how they are to be used 132. For the internal forum do not cease if one did not advert to expiration of 138, of cardinals 161, of bishops 230. Fast and abstinence stays for the universal church appointed exclusively by the Holy See 1087, power of bishop, pastor, religious superior to dispense 1088, law of fast 1094, fast and abstinence stays, and fast only 1095, who is bound to law of 1097, favors, who may receive 36, if asked of one Roman congregation and refused they cannot be asked of another or of the bishop 40, if refused by the vicar general they cannot be asked of the bishop without making known refusal of the vicar 41, how the power to bestow is to be used 132. Fear. Actions of legal bodies done by grave unjust may be annulled 80. Clerics who receive major orders through are free from the obligations of sacred orders 108. 145. Marriage contracted through is invalid 930. Fees. Besides the customary stole no charges can be made for the administration of the sacraments 579. See tax. Fetus. Baptism of the indifficult childbirth 589-591. Force. How it affects actions of legal bodies 80. Those who another to enter religious life or the clerical state are ipso facto excommunicated 1603. 4. Form of marriage contract, before a proper pastor or ordinary and 2 witnesses 937. Conditions for valid assistance of pastor and ordinary 938. Delegation to assist 939, conditions for licit assistance 940, marriage without bishop or priest 941, persons bound to Catholic of marriage 942, 40 hours devotion 1118. Forum. Clerics enjoy the privilege of the ecclesiastical 97 and 99. Jurisdiction of the internal and external. 133. Jurisdiction of the internal does not cease in case of inadvertence to expiration of faculties. 138. S. Penitentiary grants faculties for internal. 178. Foundation, pious. Definition of 1338. Permission of ordinary required to accept. 1340. To be made in writing. 1342. In churches of exempt religious major superior has charge of. 1344. Reduction of obligations. 1345. Fugitive from religious life. Definition of 489. If cleric in major orders he is ipso facto suspended. 1606. B. Funeral services reserved to pastor. 307. 5. If possible the body is to be brought to church. 1058. Which church is entitled to the 1059 and 1060, when a person dies outside his parish. 1061. Of cardinals and bishops. 1062. Of religious. 1064. Right of Catholics to choose any church for. 1066. Exceptions for children and professed religious. 1067. Further particulars for choice of church for 1068 to 1072. Obligation of priest to accompany body to cemetery. 1074. Clergy not to carry body of lay people of. 404. The New Canon Law. Any rank. 1076. Funeral charges to be regulated by the bishop. 1077. The poor to be buried free of charge. 1078. Part of fees due to proper pastor if deceased wished to be buried from another church. 1079 and 1080. Record of the deceased. 1081. Persons to whom ecclesiastical is to be denied. 1082 to 1084. Excommunication against those who force burial from church of persons not entitled to ecclesiastical burial. 1603. 2. Those who of their own accord give ecclesiastical burial to persons not so entitled incur ipso facto interdict ab ingressu ecclesiae. 1604. 4. Games of chance forbidden to the clergy. 114. Garb. Clerics are obliged to wear clerical attire. 112. Penalties for die sententiae for breaking this law. 1613. 12. Goods, temporal, of religious orders and congregations. Right to acquire and possess. 376. Power of administration of the superior. 377. Conditions under which sisterhoods may make investments. 378. For contracting of debts over $6,000 beneplacitum of the Holy See is required. 379. Annual account of finances to be given to bishop by sisters in solemn vows, by diocesan congregations and also by other religious if they handle parish and charity funds. 380. Liability for debts. 381. Donations by religious. 382. Renunciation of by novices invalid. 413. When and how renunciation is to be made. 425 and 426. Obligation of solemnly and simply professed. 427 and 428. Common Treasury. 439. Concerning of a religious in case of transition to another order. 480. Temporal goods of the Church. Right of the Church to acquire and possess. 1289. Right to demand support from the people. 1290. Ownership. 1293. Private individuals collecting for church purposes need authorization. 1297. Quadraticum, by whom to be paid. 1298. Seminary tax, by whom to be paid. 1299. Bequests in favor of the Church. 1307 to 1309. Administration. 1312 to 1322. Alienation. 1324 to 1329. Mortgage. 1332. Persons who unjustly retain ipso facto excommunicated. 1601. 7. Habit. Religious obliged to wear the. 441. Heresy. Definition of 1168. Excommunication of heretics. 1600. I. Suspicion of for certain offences. 1616. Other penalties inflicted for heresy. 1618. 1. Holidays of obligation for Universal Church appointed by Holy See exclusively. Bishops Primatum Actus 1087, Power of Bishop and Pastor to dispense 1088, Number of in Universal Church except where special arrangement has been made by Holy See 1090, Obligation of hearing Mass and rest from servile work 1091 and 1092. Holy See, what is meant by the term 7, powers reserved to in the erection of dioceses 146. In the establishment of diocesan religious congregations 337, in the erection of provinces of religious 339, excommunication reserved specially modo for impeding the exercise of, or its legate and for usurpation of the goods and rights of the 1600, 5 and 9, honesty, public, deriment impediment of marriage 921, hospital, see institutions, hosts. Abuse of consecrated punched with excommunication reserved to Holy See specially modo 1599, 1, house, various kinds of religious houses 333, 5, permission of diac, index of subjects, 405, san and other congregations to establish, given by Bishop 340, exempt religious need both Bishop's permission and that of the Holy See 342. Opening of schools and charitable institutions subject to Bishop 342, suppression of a religious 343, hunting on a large scale forbidden to the clergy 114, ignorance of invalidating or inhabilitating laws does not excuse from invalidity of the action 16, how FR affects the responsibility for offenses 1486. How far it excuses from the penalties of law 1513. Illegitimates, when our children considered 957-96 cannot be promoted to cardinalate, episcopate 212, same rule applies to abbots and prelates nullius, cannot be major superiors and religious orders 349. Alness no reason for dismissal of religious 492. Person ill for a month may receive Holy Communion twice a week without fasting 701, impediments of marriage, some subject to Holy Office 167, to the Congregation of the Sacraments 169, of major and minor degree 885, public and occult 880, faculty of dispensation of bishop and priest in danger of death 886 and 887. Faculty of bishop and priest in perplexing cases 888 and 889, rules for interpretation of dispensations 890-900, legitimation of offspring 894, impedient 901 and 902, mixed marriages are strictly forbidden 903, conditions under which mixed marriages are permitted 94-907 Jules Derriment 910-935. Forum of Contract 937-946, Pauline Privilege 06 greater than 97x, Impotence, Impediment of Marriage 911, Manner of proving invalidity of marriage for reason of 1402-1408, Incarnation takes place at THT Reception of First Tonsure 88, from another diocese must be done in writing to be valid 89, Vicar General cannot grant without special mandate 90. Implied 91, conditions of 94, of secularized religious 486. Incola, a person who lives in the place of domicile 68. Indissolubility of consummated marriage of Christians 961, non-consummated marriage is dissolved by solemn religious profession and by dispensation of the Holy See 962. Indulgences, questions of subject to the Sacred Penitentiary 178, concession. Supreme Pontiff and those whom he gives the power can grant 755, faculty to give papal blessing 757 and 758, privileged altar 759-76 I, new not to be published without permission of bishop 762, granted by Roman Pontiff to be submitted to S. Penitentiary 763, translation of feast to which is attached 765, time for granting 766, attached to places or to sacred objects 767, manner of gaining indulgences, conditions 768, if plenary is not gained, Partial may be gained 769. Plenary can be gained only once a day 77 liters. Religious may gain in their own church or oratory 772. Cannot be applied for the living by another 773. When confession and communion is to be made for gaining 7745 GD works prescribed must not be obligatory for other reasons. By indulgence prayers said for sacramental penance can be gained 775. By one and the same good work several cannot be gained 776. Prayer for the intention of the Holy Father 777. Confessor may commute good works 778. How mutes are to say the prayers 779. 5 hooks and leaflets on need imprimatur of ordinary 406. The New Canon Law 1231. Profiteers from are ipso facto excommunicated 1601. 1. Indults granted by the Holy See remain in force unless explicitly recalled in the Code. 4. Infamy of law, penalty of 1577 1579, when incurred ipso facto 1608. Infidels, infants of may be baptized under certain conditions 593. Insane, baptism of persons whose mind is affected 597. Irregularity in ordination 827. 3. Institutions of charity subject to S. Congregation of the Council 170, are established by authority of local ordinary 1283, attached to a religious house 1285, even exempt charitable must make financial statement to bishop 1286. Interdict, definition 1552. What authority can issue 1553, what is forbidden by a local 1554, what services are allowed under a local general 1555, under a local particular 1556, on a community 1558. What is forbidden to those under personal 15591. What the Abingers Ecclesiae imports 1561, incurred ipso facto 1604. Interpretation of Canon Law, authoritative 17, private how to be made 18 and 20, laws enacting penal ties interpreted in restrictive sense 19, of the power of jurisdiction 131, interpreter, making one's confession by is optional, he is bound to the seal of confession 746, marriage may be contracted through 933, interruption of novitiate 401, intervals between reception of various orders, 821, invalidating or inhabilitating laws are those only which explicitly state to have this effect. 10. Irregularities barring from ordinations, ex defectu 827. Ex delicto 828, ignorance of does not excuse 831, multiple 832, faculty of, dispensation of bishop and confessor 833, petition and interpretation of dispensation from 834, irremovable pastors and parishes 299, formalities in depriving pastor of parish 1431 to 1440, jurisdiction. Church has both for the external government of the faithful and the internal forum by divine right 127, ordinary 128 and 129, delegated 130 and 131, interpretation of power of 131, can be exercised in favor of subjects only 132, in the external forum 133. Judicial power cannot be exercised in one's own favor or outside one's territory 132, delegated either in solitum or collegialiter 136, how delegated ceases 138, how ordinary ceases 139, supplied by the Church 140, of Roman Pontiff extends over the whole Church 149, major cases reserved to the of Roman Pontiff 151. Of General Council 159, of the Holy Office 167, civil authorities and those who cause them to hinder of the Church are excommunicated 1600. 6. Key to the archives of the Episcopal Curia and by whom to be kept 260, to the tabernacle to be guarded by priest 1112. Laity has right to receive the spiritual services of the clergy. 527. Laymen not allowed to wear ecclesiastical garb except seminarians and those employed in church service. 528. Latin Rite. Laws of the Code obligatory only for Catholics of one language. Parishes not to be divided according to different of people. 147. Law. General Principles of Canon 163. Liturgical published prior to Code to remain in force. 2. Particular and general contrary to. Index of Subjects. 407. Code abolished 6 and 22. Former. Enacting censures and other penalties not contained in the Code are abolished. 6. 3. Promulgation of. Territorial and personal 8. Are made for the future and have no retroacting effect unless the Code explicitly states this. 10. Invalidating and inhabilitating are those only which explicitly state to have this effect. 10. General, binding Catholics everywhere, particular those only who have domicile or quasi-domicile in the diocese or county. 13. Dispensation from the common can be granted by the Holy See only. 58. Lawyer, clerics not allowed to act as, except in the ecclesiastical court or in defense of their own church. 115. Legal or moral persons, how constituted. 76 and 77, how they must act in elections, etc. 78, are perpetual, how extinguished. 79, prohibitions from legal actions incurred by certain offenses. 1540 and 1617, legates of the Holy See, right of Supreme Pontiff to send, with power of jurisdiction. 185, a latir. 186, duties of. 187, privileges. 189, titular have no special rights. 190, legitimate children, who are considered as such. 957. 96, letters, written by religious, when exempted from inspection of the superiors. 456, falsifying of papal, punished with excommunication. 1610, ligamines impediment. Turn 912, marriage made invalid by this impediment needs no canonical trial. 1416, line of consanguinity and affinity. How figured. 73 and 74, litanies, bishop cannot approve new, for public use. 1102, liturgy, laws of not changed by, the Code except in points specially mentioned. 2. Questions of subject to s. Congregation of Rites. 173, clerics and major orders who in grave matters break the laws of are to be suspended. 1613, n. Loan from church goods, no interest can be charged, if it is purely a loan. 1337, loss of domicile or quasi-domicile. 72, loss of good reputation incurred ipso facto by certain crimes. 1608, major age, age of 21 years completed. 65 and 66, mandate by which delegated jurisdiction is given determines extent of power. 134, manifestation of conscience forbidden to be exacted by religious superiors. 375, marriage, dispensations and impediments of when valid. 39, clerics and major orders cannot validly contract. 108, impediment of disparity of cult, mixed religion and Pauline privilege subject to holy office. 167, other impediments subject to the sacred congregation of the sacraments. 169, to assist at rite of pastor. 307, 45, sacrament of marriage, contract of baptized person. 855, essential qualities. 856, definition of matrimonium radum, consummatum, legitimum, putativum. 858, contract valid by the law of God and canon law. 859, conditions for validity of engagement. 860, requisites before status liber. 862 and 863, baptismal certificate. 864, bans. 866. 873, course of action and doubtful impediment. 874, instruction of young couple. 876, children forbidden to marry against reasonable objection of parents. 877, impediments in general. 878. 884, major and minor impediments. 885, Faculties. 408. The New Canon Law of Dispensation of Bishop and Priest 886 and 887. In perplexing cases 888. Rules for interpretation of dispensations of impediments 889-899. Restriction of faculties of bishops in recent decree 900. Impedient impediments 901-909. Deriment impediments 910-923. Matrimonial consent 924-936. Form of contract 937-946. Marriage of conscience 947-950. Time and place 951 and 952. Consequences of 953-960. Separation, dissolution, privilegium puellinum 961-975. Simple validation 976-980. Signatio in ratus 981-984. Record of marriage 985 and 986. Clerics and major orders and religious and solemn vows attempting excommunicated 1601. 9. Before a Protestant minister punished with excommunication 1602. 1. Masons, excommunicated, 1601. 3. Mass, application for the people by the bishop 220. By the pastor 311. The celebrant, priests only can offer the holy sacrifice 645. Concelebration allowed only in ordination of priests and consecration of bishops 646. When priest wishes to say Mass in a church where he is unknown he must exhibit celebrate 647. Obligation of every priest to say several times a year 648. Bionation 649. Confession of mortal sin before saying 650. Eucharistic fast 651. For whom may be applied 652. Preparation and thanksgiving 653. Cap or ring at permitted only by indult and to certain dignitaries 654. When assistant priest is allowed 655. Should not be said without a server 656. Rites and ceremonies, pure wheat bread, and wine mixed with water 657 and 658. Priest must follow his own rite wherever he celebrates, 659. One species only never to be used 660. Time and place 663-666. Stipends 667-687. Master of Novice. Qualifications and duties 404-410. Master and submaster not allowed to hear confessions of novices 734. Matrimonial cases of baptized persons subject exclusively to the Church 1386. Merely civil consequences of marriage judged by civil authority 1387. Privilegium Paulinum and cases of matrimonium ratum et non consummum exclusively subject to the Holy See 1388-1389. Constitutions of the Diocesan Tribunal for 1392 to 1395. Who has right to demand trial for nullity of marriage 1396 to 1399. Witnesses 1400 and 1401. Bodily inspection in cases of impotence 1402 to 1408. Appeal obligatory when marriage is declared invalid 1412 to 1415. Cases accepted from regular form of canonical trial 1416 to 1418. Medicine, clergy forbidden to practice 115. Meditation. Duty of clergy to make daily 101. Metropolitan, see Archbishop. Military service forbidden to clerics 117. Minor age, persons under 21 years of age 65 and 66. Domicile of minors 70. Missions and its districts in charge of the S. Congregation of the Propagation of Faith 172. Remission and parishes to be held at least once in 10 years 1192. Mixed religion, impediment, subject to holy office 167. No sacred rites allowed in mixed marriages 945, not to be contracted in a church, but the bishop may for a very serious reason allow it without mass 952. Conditions under which dispensation is granted 904. Modernism, Oath against and other regulations on this subject to remain in force until Holy See shall decide otherwise. 6. Index of Subjects. 409. Monition in Trials of Removal of Pators 1427. Month, in law, is a period of 30 days. 32. Moral Persons. See Legal, Morals, Questions of, Subject to, Holy Office 167. Mortgage, Permission required to place church property under 1332. Music in Church 1107. Mutes, how they are to say prayers to gain indulgences 779. Name, in baptism name of a saint, should be given 604. Non-Catholic, Catholic parents who bring up their children in a sect are excommunicated 1602. 4. Not subject to Catholic form of marriage 942. Marriage of Catholic with 903. 907. 914. May not receive the sacraments 574. May receive some sacramentals 092. Notary, the Chancellor is in virtue of his office a 253. Appointment of other 254. Duties of 255. His part in cases of removal of pastors 1426. Novitiate, year of, how reckoned, first day not counted 34. 35 Conditions for valid admission in all orders and congregations 387. I. For licit admission 387. 2. GHT to DMIT candidates belongs to Major Superior 388. Certificates and testimonials required before admission 389. 391. Dowry of candidates and sisterhoods $392.39. H.W. the Begins 398, House of Appointed by Holy See 399, Conditions for valid 400, Interruption 401 J. Qualifications of Master of Novices 404, His Duties 405 410, Confession of November Ices 411, Novices not to be promoted to orders 412, Renunciation of temporal rights for dismissal of novices 416. Perpetually secularized religious need indult of Holy See to be received again into the order and must make their novitiate in profession over again 485. Nuncius, or internuncius, are legates of the Holy See to nations standing in diplomatic relation with the Holy See 187. Expiration of office 188. Privileges 189. Nuptial blessing 944. Oath, definition 1159. Obligation 1160, cessation of obligation 1162, dispensation, commutation 163, persons neglecting to make their profession of faith demanded for certain offices lose their salary 1609, 2, against modernism 6, obedience, clergy owe to their ordinaries 103, obligations of clerics 100 and 120. See Clerics, Ocean, hearing confessions on the 726. The privilege to celebrate everywhere does not include permission to say Mass on the 665. Cardinals and bishops have faculty to celebrate Mass on the 161, 8, and 230. Offenses, nature and division of, 1479 to 1482. Responsibility, aggravating and extenuating circumstances. Juridical effects of 1483 to 1495. Office, see Divine Office. Office or work imposed on a cleric by the bishop cannot be abandoned without his permission 104. Definition of ecclesiastical 121. Must be obtained by lawful appointment I-22, with care of souls can be given only to priests 123. Unlawful conferring of -125. Which are not considered benefices 1255, loss of, incurred ipso facto 1610. Oils holy must not be older than 1 year, non-consecrated, may be added to consecrated 577. 5. Pastor must obtain them from his own bishop, keep them in church. 410. The new canon law, not in his private house, except if ordinary permits. 578. Oratory, definition and various kinds 1031, private chapels of cardinals and bishops considered semi-public in law 1032, Semi-public 1035 and 1036. Private chapels 1037 to 1039. In what chapels one can fulfill the obligation of hearing Mass 1092. Orders. Power of cannot be delegated 141. Sacrament of distinguishes clergy from laity 791. Major and minor 792. Minister. Ordinary minister is the bishop. Others by privilege 794. Consecration of bishop reserved to Holy See 796. Proper bishop of the candidates 798 and 799. Prefects and vicars apostolic, abbots and prelates nullius have the same right as the bishop if they have episcopal consecration 800, who can give demissorial letters 801. Further regulations about the demissorial letters of the secular clergy 803-806, of the religious 807-810. Subject of ordination, baptized men who are free from irregularity 810, must have stayed in the seminary at least for the course of theology 815. Tonsure and minor orders must not be given unless candidate intends to ascend to priesthood 816. Requisites for licit ordination 817. For major orders 818. Previous studies required for the various orders 819. Prohibition to confer various orders on the same day 821. Canonical title for secular clergy 822-824. For religious 825. Irregularities ex defects 827. Ex delicto 828. Simple prohibitions 830. Ignorance of irregularity does not excuse 831. Multiple irregularity 832. Faculty of dispensation of bishop and confessor 833. How to petition and interpret dispensations from irregularities 834. Requisites prior to ordination. Testimonial letters 836-838. Seculars and religious must pass examinations before the bishop 839 and 840. Publication of names of seculars in their proper parish 841. Retreat before major and minor orders 844. Rites and ceremonies. Pontificate must be strictly followed 845. Mass of ordination or consecration of bishop to be said by ordaining bishop 846. Those promoted to major orders must receive Holy Communion in the ordination Mass 848. Time and place. Ordination days 849. Defect in ordinations can be supplied any day 850. Outside his diocese bishop needs consent of local ordinary 851. General ordination should be given in cathedral 852. Record and testimonial of ordination. Names and orders conferred are to be kept in diocesan archives. Those ordained are to receive certificate 853. Notice to be sent to pastor of church where the newly ordained subdeacons were baptized 854. Cases against validity of ordination 1419-1424. Suspension falls on those who receive orders from a bishop who is under public censure, or from an apostate, or schismatic 1605. C. Various suspensions for unlawful ordination of candidates 1605. D. Ordinary, who is meant by the term 129. For the rest see Bishop, Oriental, Congregation of the Oriental Church IN 177. Parents, children of infidels, Protestants, or apostate Catholics shall not be baptized unless there is some guarantee of Catholic education 593 and 594. Children forbidden to marry against reasonable objection of 877. Parishes, dioceses to be divided into 147, cannot be given by bishop to religious without papal 297, not to be left vacant for a long time 303. Division of 1270. Index of subjects, 411. Recourse T.N. Holy See against D.V. Scion of 1271. Pension imposed on a 1272. Pastoress right to live from the revenue of the 1277 and 1278. Pastors, from what laws they can dispense 60, who are real also in the United States 147. Rights of a religious appointed as 475 and 476. Definition of the term pator 296. Must be a priest 298, irremovable and removable 299. Appointed from a religious community 299, appointment of 300 and 304, taking possession of the office 306, parochial rights 307, bishop may exempt hospitals, etc., from jurisdiction of 309, obliged to keep residence, 2 months vacation. If he leaves the parish for more than 1 week he needs permission of bishop 310, on what days he must apply mass for the parishioners 311, parochial vicar, who is meant by the term 316 and 317, assistants to the 320-322, have the right to bless sacred utensils 1147, trial for removal of irremovable 1431 to 1440. Of removable 1441 to 1445, penalties against neglectful on the parochial duties 1466 to 1469, who incites the people against the bishop is to be suspended 1613, 5. Patriarch to be called to General Council 154, 2. Has no superior jurisdiction 191. Patronage, right of, not to be conceded in future 1275. Pauline privilege subject to Holy Office 167, dissolves marriage of unbaptized, cannot be applied when a Catholic marries an unbaptized person with dispensation 963, interpellation 964-966, privilege not lost if baptized party lived in marriage for some time after conversion 967, marriage solved at the moment of new marriage 969, in doubtful cases the Pauline privilege enjoys the favor of the law 970. Payment, religious who either leave of their own accord or are dismissed, or secularized, cannot demand for work done in the religious community 488. Penalties, ecclesiastical, bishop may punish religious within matters in which they are subject to him 464, definition 1499. Species 1500 and 1501, application 1502 and 1507, interpretation 1503, persons subject to 1510 to 1519, how far ignorance excuses from 1513, in what manner incurred ipso facto bind 1516, who has power to remit 1520 to 1523, prescription of offenses 1517 and 1524, censures 1525 to 1569, excommunication 1541 to 1551, interdict 1552 to 1561, suspension 1560 to 1569, punitive penalties, boini vindicativi, 1570. Appeal from 1571, cessation and dispensation 1573, faculty of confessor in urgent cases 1574, penalties for both laymen and clerics 1575, infamy of law 1577 to 1579, punitive special to the clergy 1582 to 1589, penal remedies 1590 to 1595. Penances 1596 and 1507, list of excommunications reserved to the Holy See Specialimo Modo 599 I Specially Modo 1600, Simply Cider 1601, reserved to the ordinary 1602, not reserved 1603, list of interdicts incurred ipso facto 1604, suspension ipso facto 1605, infamy of law ipso facto 1608, loss of salary 1609, loss of office or benefice 1610, penalties, friendly sentential, excommunication 1611, interdict 1612, suspension 1613, degradation 1614, deposition 1615, suspicion of heresy 1616, Prohibitions from legal actions, Vnreals other penalties. Frendi Sententiae 1618, Penance, Sacrament, Definition 713. Minister, must be a priest 714, b. 412. The New Canon Law. Sides valid ordination also jurisdiction required 715. Those who have ordinary jurisdiction 716. Delegated jurisdiction 717. In clerical exempt orders the superior gives jurisdiction for absolving his subjects 718. Special jurisdiction required to validly hear confession of sisters in their convents 719. Reasons for recalling faculties 720-723, limitation of faculties 721. He who has ordinary jurisdiction may absolve his subjects everywhere 724. Every priest has faculties to absolve persons in danger of death from all sins and censures 725. Confession on the ocean 726. Absolution of priest's accomplice 727. The prayers attached to the form of absolution should not lightly be omitted 728. If there is no serious reason to deny or defer absolution it must be granted 729. Penance should be in proportion to sins and circumstances of the penitent 730. Sacramental seal 732 and 733. Master of novices, submaster, superior of college and seminary not to hear confessions of their subjects 734. Obligation of pastor to hear confessions 735. Reservation of sins. Persons having ordinary power to give faculties to others can restrict them 736. Papal reservation 737. How ordinaries may reserve sins 738. Reserved cases in religious orders 739. Cases already reserved to the Holy See should not be made episcopal cases 741. Faculties of pastors for Eastertide and of missionaries during the missions to absolve from the bishop's reserved cases 742. Circumstances under which the reservations of the bishop cease 743. Penitentiary, the sacred rights and powers of this tribunal 178. Peregrine, who are, how they are held to the particular laws of a diocese or country in which they are sojourning 14 and 68. Personal laws are binding in any place 8. Persons subject to the laws of the Church 64. How legal are constituted in the Church 76 and 77. Actions of legal 78. Pious unions, definition 552. May be erected with the approval of the bishop 553. Place of birth 67. Places, sacred, definition 997. Consecration of reserved to local ordinary 998. Blessing of cannot be done without consent of local ordinary 1000. Pontiff, Roman, has supreme power of jurisdiction over the universal church 149. Obtains his power by divine right as soon as he accepts his legitimate election 150. Major cases reserved to judgment of 151. Obedience of religious to 344. Personal attack on the punished with excommunication reserved special imo modo 1599. 2. Appeal from the laws and orders of, to a general council punished with excommunication reserved speciali modo 1600. 4. Cf. Holy See, Pontificals, meaning of the term. Bishop can pontificate in every church in his diocese. Outside it he needs permission of the local ordinary 218. He can confirm his own subjects in another diocese without permission if he does not use the 626. Cardinals have the permission to use the everywhere outside the city of Rome 161. 15. Postulate. 6 months prescribed for all sisterhoods with perpetual vows and in orders and congregations of men for the lay brothers 384. Need not be spent in house of novitiate 385. Retreat of 8 days before entering novitiate 386. Power of jurisdiction can be exercised. Index of subjects 413. Only in favor of subjects 132. See jurisdiction. Preaching. Office of 1170 and 1171. Faculty to preach given by local ordinary to secular and regular clergy and so The religious superior of an exempt order can grant faculty only to preach to the religious subject to him, not to sisterhoods or other orders of men. 1181, recall of the faculty. 1183, in another diocese faculty must be obtained from bishop on recommendation of proper ordinary to the priest who wishes to preach outside his own diocese. Pastor who invites extern priest for preaching must apply for faculty. 1184, duty of pastor to preach on Sundays and holidays of obligation. 1187, precedence. Cardinals precede all patriarchs, archbishops and papal legates unless these latter are cardinals. 161, 21, bishop in his own diocese precedes all archbishops and bishops except his own archbishop. 228, of religious. 336, precepts cannot be urged in ecclesiastical court unless given in form of legal document or before two witnesses. 24, of the Church subject to the sacred congregation of the Council. 170, prefects, apostolic. 198, have the same power of jurisdiction as the bishop, and if they are consecrated bishops they have the same power also for ordinations. 800, prelates nullius to be called to General Council. 154, 3i meaning of the term. 206, their rights and duties. 207, 209, prescription. 1302, matters not subject to. 1303 and 34, time required. 1305, good faith. 1306, against penalties for offenses. 1517 and 1524, primary unions, definition. 552, they can affiliate pious unions. 564, what indulgences are communicated by affiliation. 565, conditions for validity of affiliation. 566, Holy See alone can establish. 568, primates to be called to General Council. 154, 2, have no superior power of jurisdiction. 190, Primitia i.e. 1296, principles, general, of law. 163, privileges, granted by Holy See remain in force unless explicitly recalled in the Code. 4, how are acquired. 49, how to be interpreted. 50 and 51, revocations of. 53, cessation. 54, 56, of clerics. 95, 99, loss of clerical by reduction to the lay state. 144, of cardinals. 161, of bishops. 230 and 900, of religious. 458, 470, procedure for removal of immovable pastors. 1431 to 1440, of removable pastors. 1441 to 1445, for transfer of pastors. 1446 to 1451, against clerics not keeping residence. 1452 to 1459, against clerics living in concubinage. 1460 to 1465, against neglectful pators. 1466 to 1469, processions, definition. 1133, Corpus Christi. 1134, procurator sent to take the place of a person called to General Council. 155, for the administration of the goods of religious in each house, province and at the curia of the general. 361, general for each order and congregation. 362, profession of faith, persons held to, make it. 1249, profession, religious, conditions for validity. 417, age for temporary vows. 16, for perpetual and solemn vows. 21 years. 418, temporary vows must precede perpetual or solemn. 419, one recording of. 421, privileges and obligations of the religious in temporary vows. 423, 426, validation of invalid. 431, solemn dissolves the non. 414, the new canon law, consummated marriage of Christians. 962, prohibition of books. 1238 to 1248, see books, promoter of justice, his part in the canonical trial. 1381, promulgation of law. 8, of the laws of the Holy See by 8 apostolic sedis. 9, of laws of bishops. 216, propaganda, sacred congregation of the has charge of all missions and vicariates and prefectures. Apostolic. 172, Property of churches, questions concerning subject to the S. Congregation of the Council 170. C. Goods, Protector, Cardinal, of a religious order 344. Protestants, sacraments cannot be given to unless they first renounce their errors and are received into the Church 574. Conditions under which infants may be baptized in the Catholic Church 594. Province, a union of several religious houses under one head 333. 6. Proxy, marriage by 932-934. Puberty, age of 65. Publication of names of candidates for major orders in their own parish church 841. Publishers of certain books excommunicated 1600. 2. Quasi-domicile, how acquired 69. By a person becomes subject to local, ordinary and pastor 71. Quasi-pastors held equal to pastors 296. Are removable 299. Appointed by local ordinary 302. Rape, impediment of marriage 917. Reason, use of necessary to make a person subject to the law 12. Recall, bishop has right to recall priests who are not excardinated and received permission to go outside the diocese 120. Reception of novices 398. Reconciliation of desecrated churches, Loic 1020. Records, pastors obliged to keep parish 315. Of deceased parish owners 1081. Recourse to the Holy See, if difficult, the ordinary may dispense from the common law in particular cases 58. From marriage impediments 900. Rectors of churches, who are 324, their appointment 325, have no parochial rights 326, their rights and duties 327-330, are removable 33I. Reduction of clerics to the lay state 142-145. Relationship, spiritual, impediment of marriage 922. Relics, questions of reserved to congregation of sacred rites 173. Making, selling, distributing bogus punished with excommunication 1602. 5. Small may be kept by private people, large ones not without permission of ordinary 1124 and 1125, for public veneration in church 1126. What to do when document of authentication is lost 1128. Of the Holy Cross 1130 and 1131, selling forbidden 1132. Religious, S. Congregation of the, has charge of all religious communities of any kind 171, in missionary countries subject to S. Congregation of the Propaganda in reference to their missionary activity 172, pastors are removable, by whom they can be changed 299, definition of state 332, definition of various terms 333, repeal of particular laws of by the Code 334, canons speaking of religious in the masculine gender apply also to feminine and vice versa 335. Precedence 336, erection of diocesan, index of subjects, 415, congregations 337, suppression of a religious organization 338, supersession of an individual house 343, obedience to the Roman pontiff 344, privileges of exemption 345, power of the superiors 346-348, qualifications of the superiors 349, term of office 350, manner of election 351 and 352, report to Holy See on the status of the order 355, visitation by the superior 356, extent of right of visitation by the bishop 357, administration of the sacraments to the 359, titles of honor 360, Board of Consultors for the Superiors, Procurator for Temporal Affairs 361, Procurator General for Transactions between the Order and the Holy See 362, Confessors of the Religious and Clerical Organizations 363 and 364, of Sister 365-372, In Lical Orders and Congregations of Men 373 and 374, manifestation of conscience must not be urged by superiors 375, temporal goods and administration 376-382, admission into a community 383, postulate 384-386, novitiate 387-416, sisterhoods to inform bishop 2 months before reception or profession 397, renunciation of temporal goods and rights 414, 425-428, religious profession 417-431, studies in clerical organizations 432-436, duties of religious 437-457J, privileges 458-470. Religious cannot be promoted to bishopric, or other office or dignity incompatible with the religious state, without permission of the Holy See 471, raised to the cardinalate or episcopate 472 and 473, appointed pastor of a parish 475 and 476, transition to another order 477-481, secularization 483-490. Dismissal incurred ipso facto by certain crimes 491, dismissal of religious and temporary vows 492 and 493, dismissal of a perpetual professed and non-exempt, clerical and in any lay order 494-498, of religious in perpetual or solemn vows in clerical exempt religious bodies 499-513, status of dismissed who had perpetual vows 514-517, in solemn vows cannot validly contract marriage 916, get jurisdiction for consents of seculars from bishop 717, in clerical exempt orders religious superior gives jurisdiction for his subjects 718. Bishop cannot deprive all confessors of a religious community of the faculties 723, Demisorial letter for ordination 807-810, religious must obtain approval of site for church or public oratory 1005, exempt have right to cemetery of their own 1051, may keep blessed sacrament in church or oratory mo. Religious in simple vows who marry without dispensations are excommunicated 1602. 9. In major orders who by their own fault make invalid profession are ipso facto suspended 1605, e. Fugitives incur suspension 1606, b. Superior who sends his subjects to another bishop for ordination against the law of the code is suspended for 1 month from saying Holy Mass 1607, f. Renewal of vows 422, renunciation of temporal good by novices 414, before solemn prophesying 425-427, before perpetual vows in congregations 428. Reports of bishop on state of the diocese to be made to consistorial congregation 168, every 5 years 221, of religious superiors to the Holy See 355, reprimand, judicial, when to be given. 1373 to 1379, rescripts, when they take effect 37, conditions in a, how to be understood 38, how they are invalidated by untruthful statement in the petition 39, errors in 42, when they, 416, the new canon law, have to be shown to the bishop 43, interpretation of 44 and 45, the execution of 46. Revocation of favors granted by 47, invalidation of 48, reservation of cases, papal cases 737, how ordinaries should make 738, in religious orders 739, bishop may not reserve to himself cases that are already reserved to the Holy See 741, faculty to absolve from bishop s 742. Circumstances under which all bishop SC 743, priest pretending to absolve from without faculties is suspended ipso facto from hearing confessions 1607, a. Residents, clergy forbidden to absent themselves from the diocese without permission 119 and 310, bishop held to law of residence 219, Loss of salary incurred by violating law of 1609. Resignation of office by Roman Pontiff does not need acceptation by anyone. 152. Of benefice or office by the clergy. 1279. Respect which the clergy must show the ordinary. 103. Retreat to be made by secular priests at least once in 3 years. 102. By postulants before novitiate. 386. Before profession. 416. To be made each year by the religious. 440. Before minor and major orders. 844. Revocation of laws contrary to Code 6, 22 and 23, of customs. 30. Of favors granted by rescript. 47. Rights, acquired, under what condition they remain in force. 4. Of clerics. 95-99. Parochial. 307. Of rectors of churches. 327-331. Right. Baptism decides to which a person belongs. 75. Matters touching Oriental subject to the Congregation of the Oriental Church. 177. Child must be baptized in the of the father if he is a Catholic, unless special provision is made for some rite. 599. Priest must use altar bread of his own wherever he celebrates. 659. May celebrate in a church of a different, if there is none of his own. 666. Holy Communion may be received in any Catholic by the people. The Holy Viaticum must be received in one its own. 709. Priests of Oriental may absolve Catholics of Latin and vice versa. 748. Cleric who received some orders in Oriental and obtains permission to receive further orders in the Latin must receive the orders which are not given according to the Oriental. 847. Marriage of persons of different to be witnessed by pastor of husband. 940. Roman Pontiff, see Pontiff. Roman Curia consists of the congregations, offices and tribunals at Rome. 160-165. Sacramentals, definition. 987. Holy See alone can constitute new. 988. The minister. 989. Consecrations can be performed by bishop or by a priest with papal indult. 990. May be administered to non-Catholics. 992. Exorcisms. 994-996. Sacraments. Congregation of the, its rights and powers. 169. Sacraments. Administration of several, reserved to pastor. 307. It is forbidden to minister to heretics even if they are in good faith. 574. Baptism, confirmation and orders can be received only once. In doubt they may be repeated conditionally. 575. Besides the customary stole fees no charge can be made for the administration of the. 579. Baptism. 580. 622. Confirmation. 623. 643. Holy Eucharist. 644. 712. Penance. 713. 753. Extreme Unction. 780. 790. Holy Orders. 791. 854. Marriage. 855. 986. Saints. Veneration of 1119 to 1120. Index of Subjects. 417. Tron 1 121. New images of not to be made without approval of the ordinary. 1122. Sacred images of great value cannot be given away or transferred without permission of the ordinary. 1124. Salary, forfeiture of by neglect to keep residence and by neglect to take the oath for certain offices. 1609. Saloon, clergy must not visit. 114. Signatio in Radis of marriage. 981-984. Schools, Catholic, children of Catholics must be sent to. 1215. Bishop in particular cases to decide and give permission to attend non-Catholic. 1217. Right of the bishop to inspect. 1225. Scripture, holy, original texts and ancient versions published by non-Catholics forbidden. 1242. Also books concerning if published without ecclesiastical imprimatur. 1242. 5. Permission in favor of theological students. 1243. Seal of Confession. 732 and 733. Direct violation punished with excommunication reserved to the Holy See Specialimo Modo 1599. 4. Indirect violation to be punished with penalties Frendi Sententiae 1613. 10. Secrecy. Officials of the Roman Curia held to in the affairs of their office 163. Secretariat of Briefs to Princes and of Latin Letters 184. Secretariat of State, Rights and Duties 183. Secularization, indult of a religious to live outside the religious house is twofold, temporary and perpetual 483. Temporary does not free the religious from the obligations of his state 484. Perpetual separates him from his order and frees him from the vows. Apostolic indult required to receive him again, must make novitiate and profession over again 485. For diocesan congregations bishop can give secularization 483, reception by the bishop of a secularized religious 486, positions and offices forbidden to a secularized religious 487, religious who leave the community or are secularized, or dismissed, cannot demand payment for work done while in the community 488. Seminary, studies in a subject to S. Congregation of Seminary and University Studies 176. Rector of, not to hear confessions of the seminarian 734. Right of the Church to have 1195. Priests to promote vocations 1196. Minor and major 1197. Tax by whom to be paid 1198 and 1199. The Board of Administrators 1202, Rector and other officials 1203, Confessors 1204, Admission into 1206, Philosophical and Theological Studies of Seminarians 1208, Rector has parochial rights over 1211, Senator, clergy not allowed to compete for office of 115. Separation of married people from bed and board 971-980. Shows, unbecoming or scandalous to be avoided by the clergy 116. Signature Apostolica, highest court of appeal of the Church 179. Simony, definition of twofold species 570. Tacit agreement also considered 571. Simoniacal contract concerning benefices, offices, dignities is invalid 572, in conferring of offices and benefices punished with excommunication ipso facto 1601, 10, in ordination and administration of the sacraments with suspension 1605, b. Sisters, religious with solemn vows who have privilege of exemption are subject to regular superior 345. Election of Superiores 351, term of office 350, bishop must visit there. 418. The new canon law, houses every 5 years 357, sacraments are administered to sisters of solemn vows by their confessor, in other sisterhoods by pastor or chaplain 359 and 374, what postulants are held to the law of enclosure 385. Special jurisdiction needed to validly hear the confessions of sisters in their houses 719. Societies, persons leading a community life without religious vows 518-526. See also associations. Sodalities 552, subject to S. Congregation of the Council 170. Solicitation, false denunciation of a priest punished with excommunication ipso facto 1600. 2. Those who neglect to denounce a priest guilty of this crime are ipso facto excommunicated 1603. 5. Priest guilty of to be suspended 1613. 9. Sponsors in baptism 605-612, in confirmation 636-640. Spiritual relationship as impediment of marriage arises only from valid sponsorship at baptism 922. Sterility, no impediment to marriage 911. Stipends for masses subject to S. Congregation of the Council 170. Laws concerning for masses 667-687. Laypersons who are unfaithful in the handling of are to be excommunicated 1611. Clerics trading with or retaining unjustly part of are to be suspended. 1613. 4. Stole fees. Right of the pastor. 2. The poor shall receive services free. 308. Studies. The priests must not neglect after ordination. 105. Rights and powers of the Congregation of Seminary and University Studies. 176. Regulations for in-clerical religious organizations. $432.43, in seminaries. 1207 and 1208. Subdidatigation, when it can be given. 130. Superior, rules for action of when the law demands consent or counsel of other persons. 82. General of clerical exempt orders to be called to General Council. 154. 4. Major of clerical exempt religious to be invited to Provincial Council. 196. Who are major religious. 333. 8. Power of government of religious. 346. 348. Qualifications of major. 3491. Term of office of major and minor. 350. Election of 351. Supplied jurisdiction, when and how the Church gives. 140. Suppression of religious uses of various orders and congregations. 343. Of church societies and confraternities. 544. Surgery, the clergy not allowed to practice. 115. Suspension, rules for inflicting ex informata conscientia. 1470–1478. Definition of 1562. Various kinds. 1563. From benefice. 1564. What is forbidden by. 1567. When are forbidden acts invalid. 1568. Effects of a community or college. 169. List of incurred ipso facto. 1605. 1607. Frendicententiae. 1613. Suspicion of heresy for certain offenses. 1616. Synod, diocesan, to be held every 10 years. 237. Convocation. 238. Persons to be called. 239. Those called cannot send substitute. 240. Proceedings at the 241–243. Taxes, diocesan, subject to Congregation of the Council. 170. For maintenance of seminary. 1198 and 1199. For the Cathedraticum. 1298. Extraordinary for diocesan needs. 1299 and 1300. For dispensations. 899 and 1301. For funerals. 1077. Teaching authority of the Church. 1165–1167. Sin of heresy. 1168. Theaters, unbecoming shows and theatres to be shunned by the clergy. 116. Index of subjects. 419. Territorial laws, if particular, do not oblige outside the territory. 8. Territory of dioceses, how to be divided into parishes. 147. Pastor can assist at marriage only in the of his parish. 938. 2. Testimonials which religious candidates must exhibit before reception into novitiate. 389–391. Of candidates for ordination. 836–838. Theologians invited to General Council have merely consultative vote. 154. Third orders secular, definition. 547. Right to establish given by papal indult to some order. 548. Bishop as consent necessary for erection of a congregation of individuals may be received without bishop's permiss. 548. Religious of any kind cannot be members of. 549. No person can be a member of two different. 550. Time, manner of reckoning. 31–35. 1. For observance of ecclesiastical fast, divine office, fast and abstinence any recognized way of figuring may be followed. 33. Tempus util and tempus continuum. 35. Time of novitiate. 400. In which Holy Mass must be said for stipends. 677. For gaining of indulgences on certain days. 766. For confession and communion to gain an indulgence. 774. Title of ordination for seculars. 822 and 824. For religious 825, of honor in religious orders 360, academic titles or degrees which are recognized in the Church can be Holy See 1220, of a church Ion, of a basilica 1023. Titular bishops may be called to General Council 154, cannot exercise jurisdiction in Church of their title 229, their privileges 230, Feast of a church Ion. Tonsure, first, by reception of which a person is installed in the ranks of a clergy 85, can be given any day 849, by a cleric is incardinated into a diocese 88, shall not be given until after commencing course of theology 819, transaction or settlement of dispute without canonical trial 1351 to 1354. Transition to another religious order cannot be made without permission of the Holy See 477. Vows in new order or congregation 479, status of newly professed 480, 9 of solemn professed to congregation with simple vows 481, trials, canonical, in criminal cases 1359, accusation and denunciation 1360 to 1364, inquisition or investigation concerning offenses 1365 to 1372. Reprimand of delinquent 1373-1379, construction of criminal 1380-1385, unbaptized persons not subject to merely ecclesiastical laws 12, marriage with null and void 913 and 914, unction, sacrament of extreme, how to be administered 780, the minute sister, must be a priest, reserved to pastor 781, obligation of pastor to administer 782, the recipient, must have reached the years of discretion and be in danger of death through illness or old age, cannot be repeated in the same illness 783, if in doubt whether a person is fit subject it may be given conditionally 784, cannot be given to those who stubbornly persevere in mortal sin, if in doubt it may be given conditionally 785. What to do with those who are unconscious 786, obligation to receive 787, rights and seer monies, holy oil of the sick must be properly blessed 788, not to be kept in a private house without permission of the bishop 57 and 789, permission to use short formula with one anointing in cases of 420. The new canon law. Necessity. The other anointings must be made later if person does not die immediately 790. Unions, pious, subject to S. Congregation of the Council 170, regulations concerning pious 552-568. University, studies subject to S. Congregation of Seminary and University Studies 176, erection of Catholic reserved to the Holy See 1219. Clerics to be sent to 1223, religious sent to or other seat of learning must board in a house directed by the clergy 432, privileges of doctors of a Catholic 1221, utensils, sacred, to be kept with due respect 1139 and 1140, belonging to deceased cardinals 1141, to deceased bishops 1142. To pastors 1143, cardinals, bishops, rectors of churches to safeguard the rights of the Church in reference to belonging to the Church 1144 and 1145. Cathedral Church must furnish bishop with necessary for the sacred functions 1146. If a church is very poor, a small fee may with the authority of the bishop be charged to extern priests for use of the 1146, faculty to bless 1147, when lose their blessing or consecration 1148, washing of 1149, vacancy, offices should not be kept vacant for a long time 124, no changes must be made during of bishopric 281, during of parish vicar to be appointed by bishop 317, vacatio legis. Papal laws begin to bind 3 months after their publication in Acta Apostolici Sedis 9, vacation, of bishops 219, of pastors 3 Io, Vulgi, Who are meant by the term and how they are held to particular laws of places. 14. Birthplace of children of 67. Pastor not to assist at marriage of without referring case to Bishop. 875. Validation of marriage invalid for reason of endearment impediment by dispensation and renewal of consent of party conscious of invalidity. 976 and 977. If impediment is public, consent must be renewed in legal form. 978. Consult 880 on public and occult impediments. How marriage invalid for want of consent is to be validated. 979. If the prescribed form was wanting, marriage must be contracted in the legal form. 980. In more urgent cases, bishop may dispense with almost all impediments, also after marriage was contracted. 888. Validation of marriage by signatio in radis reserved to the Holy See. 981. 984. Validity of the sacrament of orders and of marriages can be brought before the S. Congregation of the Sacraments. 169. Viaticum reserved to pastor. 307. 3. Obligation and danger of death may be received for several days in succession. 707. Shall not be delayed too long. 708. Vicar apostolic, if a consecrated bishop, has the same rights as the bishop in reference to ordination. 800. Vicar capitular cannot give letters of incardination and excardination except 1 year after vacancy of bishopric. 90. His rights and duties when bishop is exiled. 274. Transferred, dies, resigns. 275. His appointment and qualifications. 277. 279. His powers. 280. 286. Removal, expiration of office. 288. Accountability to new bishop. 289. Vicar general, dispensation refused by cannot validly be granted by the bishop unless he is told of the refusal of the vicar. Cannot validly grant favors refused by the index of subjects. 421. Bishop. 41. Needs special mandate of the bishop in the following cases: to give letters of excardination and incardination. 90. To convoke a synod. 238. Appoint pastors. 300. Give consent for erection of societies and confraternities. 531. Cannot reserve cases though he can give jurisdiction for confessions. 736. Dispense with the banns of marriage. 947. Consecrate sacred places. 998. Erect a new church. 1005. Authenticate relics. 1126. Bishop freely appoints. 247. Qualifications of 248. His jurisdiction. 249 and 250. Precedence in the diocese. 251. Expiration of jurisdiction. 252. Vicar, parochial, has pastoral rights. 296. Attends to parochial duties in the name of the chapter or religious community. 297. To be appointed where religious community has charge of a parish, nominated by the superior. 316. During the vacancy of the pastorship. 317. Has full parochial rights during absence of pastor. 319. Violence against cardinals, papal legates, patriarchs, bishops punished with excommunication. 1600. 8. Against any cleric or religious punished with excommunication reserved to the ordinary. 1602. 6. See force, visit ad limina to be made by the bishop. 223. Visitation of the diocese when and how to be made. 224. 227. Of the religious houses by their superiors. 356. By the bishop. 357. How to be conducted. 358. Vocation. Pastors and other priests should promote to the priesthood. 1196. Voluntary jurisdiction. How it can be exercised. 132. Not suspended by recourse of subject to higher superior. 135. Voting. Rules for in religious communities and other legal bodies. 78. Vows. Definition. 1150. Various kinds. 1151. Reserved. 1152. Annulling of. H. 55. Dispensation. 1156. Commutation. 115. made before entering religious community are suspended. 1158. Conditions for validity of religious 417 and 418. Temporary, must precede perpetual and solemn in all orders and congregations. 419. Superior may prolong period of temporary not over 3 years. 419. Renewal of at the expiration of temporary may be anticipated for 1 month. 422. Privileges and duties of religious and temporary. 423. 425. At expiration of temporary the religious is free to return to the world. 482. Refusal of superior to let the religious renew. 482. Dismissal of religious and temporary. 492 and 493. Dismissal of religious with perpetual, in non-exempt clerical and in all equal organizations. 494. 498. Dismissal of religious with perpetual or solemn vows in clerical exempt religious organizations. 499. 513. Week, a period of 7 days. 32. Witnesses. The clergy must not act as, in criminal cases and secular courts, in marriage cases. 1400 and 1401. Womb. The fetus may be baptized in the mother as only when there is no hope that the child can be born alive. 589 and 590. Women. Clergy must avoid all suspicious dealings with and observe the rules of law concerning living in the rectory. 109. Worship. Divine. Various kinds of cult. 1098. Public and private. 1009. Catholics forbidden to take active part in the of non-Catholics. 1101. Prayer and religious acts. 422. The new canon law. Exercises held in any church or oratory. Writing. Appointment to any office, subject to bishop's approval. 1102. Should be done in 126. Divine services governed solely by year, period of 300 and the authority of the Church. 1103. 65 days. 32. Year of novitiate, how men and women should assist figured in such a way that the first. 1105. Day does not count. 34. 3. Appendix. The election to offices in religious communities. The elections in religious orders and congregations must, according to Canon 507, be conducted in accordance with the rules of the code laid down in Canons 160-182. Observing also the particular regulations for elections contained in the constitutions of the religious organizations, provided they are not contrary to the laws of the code. It will, therefore, be of value to religious organizations to find here in detail the rules which the code prescribes for ecclesiastical elections. Cf. Canons 504-507, Nos. 349-352. The election of the Roman Pontiff is solely governed by the constitution of Pope Pius X. Vacant Seat Apostolica, December 25, 1904, given in full in the appendix to the Latin Code. In other elections the rules of the following canons are to be observed, as also any particular laws which may have been legitimately passed for the election to certain offices. Regarding such particular laws, however, Canon 6. One of the code rules, they are abolished in those points in which they are contrary to the law of the code. Canon 160. If a college, or body, of men or women has the privilege to elect a person to a vacant office, the election must not be delayed for more than 3 months from the time notice was received of the vacancy of the office. The term 3 months is here called trimester util, which means that there must have been a possibility for the election. If, therefore, for reason of war or other causes an election cannot take place within that time, the electors do not lose the right to vote. If without such good reason the electors let the time go by without coming to an election, the ecclesiastical superior who has the right to confirm the election, or to provide in case of invalid election, has. 423. 424. The new canon law. The right to freely appoint someone for the vacant office. Canon 161. Saving particular regulations and customs for the convocation of the voters. The president of the election shall summon the voters in the usual form to a place and at a time convenient to the voters. If the particular regulations demand that the invitation to the election be given to each voter individually, it is sufficient for the validity of the convocation if the notification is sent to the domicile, or quasi-domicile, or actual residence, of the voters. If more than 1/3 of the voters was not called, the election is ipso jure null and void. If those not called are nevertheless present at the election, the lack of convocation does not invalidate the election. If there is question of election to an office which the elected holds for life, the convocation of the voters before the vacancy of the office has no legal consequence. Canon 162. If the convocation has been legally made, only those present on the appointed day have the right to elect, and voting by letter or by proxy is excluded unless a particular law rules otherwise. Canon 163. If one and the same person has the right to vote under several titles, he can cast but one vote. Canon 164. No one outside the College of Voters can be admitted to cast a vote, saving lawfully acquired privileges, otherwise the election is ipso facto null and void. Canon 165. If laymen interfere in any way in the election against the canonical freedom of the election is ipso facto null and void. Canon 166. The following persons cannot cast a vote. 1. Persons incapable of a human act. 2. Persons under the age of puberty. 3. Persons suffering from censure or infamy of law, if such censure or infamy has previously been announced by a declaratory or condemnatory sentence of an ecclesiastical judge. 4. Persons who have publicly joined an heretical or schismatical sect, or publicly adhere to such. 5. Persons deprived of active vote either through legal sentence of a judge, or by the common or particular law. If any of the aforesaid persons are admitted to the voting, their vote does not count, but the election is valid unless it is, Appendix 425, certain that the elected would without the illegal vote not have the required number of votes, or a person excommunicated by a declaratory or condemnatory sentence has knowingly been admitted to the vote. Canon 167. If any of the voters is present in the house in which the election takes place but cannot take part in the election on account of ill health, his written vote shall be obtained by the tellers, unless particular laws or legal customs provide otherwise. Canon 168. The casting of the vote is null and void unless it is 1. Free, wherefore a vote is null and void if the voter was forced, by grave fear or deceit, either directly or indirectly, to cast his vote for a certain person, or for several persons separately. 2. Secret, certain, absolute, determined. The vote must be unconditional, wherefore any conditions attached to it are to be ignored. Canon 169. No one can cast validly a vote in his own favor. Canon 170. Before the election at least 2 tellers from among the voters are to be appointed by secret vote, unless they are appointed by the proper statutes of the organization. The tellers, and also the president if he also is one of the College of Electors, must take the oath to faithfully discharge their office, and to keep secret the transactions in the assembly even after the completion of the election. The tellers shall with proper diligence take care that the votes are cast by each of the voters secretly, singly and in the order of precedence. After all the votes have been cast, they shall before the president of the election, and in the manner prescribed in their own proper constitutions or by legitimate custom, ascertain whether the number of votes corresponds to the number of voters. They shall open the ballots and make known how many votes each candidate received. If the number of votes is larger than the number of voters, the voting is null and void. The ballots are to be burned immediately after each voting, or after the session if several votings were held in the same session. All proceedings of the election shall be accurately recorded by the one who acts as secretary, to be subscribed at least by 426 the new canon law. The same secretary, the president and the tellers, and the minutes shall be carefully preserved in the archives of the college. Canon 171. Unless the law rules otherwise, the election may be held also by compromise, if the voters by unanimous and written consent agree to transfer for that one election the right of election into the hands of one or several qualified persons of the College of Voters, or also of outsiders, who shall by the power thus received perform the election in the name of all. If there is question of a clerical College of Voters, the persons chosen by compromise must be priests, otherwise the election is null and void. The persons appointed by compromise must, under pain of nullity of the election, observe the conditions attached to the compromise. If they are not against the common law, If no conditions were attached, they must observe the common law regulating elections. Conditions against the law, however, are considered as though not added. If the voters by compromise appointed only one person, this one cannot elect himself. If several were designated, no one of these can add his vote to that of the others who vote for him in order to make his election complete, that is, to obtain the necessary majority of votes. Canon 172. The compromise ceases and the right of election is returned to the voters. 1. By recall of the College of Voters before the persons appointed by compromise have commenced to make use of their right. 2. If one of the conditions of the compromise did not come true or was not adhered to. 3. If the election was indeed held but invalidly. Canon 173. The person who obtained the majority of votes, as prescribed by Canon 101, cf. Number 78, is considered elected and is to be proclaimed as such. Canon 174. The election is to be made known at once to the person elected, and within 8 days at the most from the time he received the information he must declare whether he accepts the election or not. Otherwise he loses every right acquired by the election. Canon 175. If the one elected renounces his election, he thereby forfeits all rights acquired by the election. Though he should afterwards revoke his renunciation, he can, however, be again elected. The College of Voters must proceed with a new election within Appendix 427, 1 month from the date on which they receive notice of the renunciation of the person first elected. By the acceptance of the election, the one elected obtains full rights immediately if he does not need any confirmation. Otherwise he only acquires a jus ad rem. Before confirmation has been received, the one elected is not allowed under the pretext of election to assume the office of administration, either in spiritual or temporal affairs, and any acts he might in the meantime have executed are null and void. Canon 176. The person elected must, if he needs confirmation of the election, ask for it, either himself or through another, from the competent superior within 8 days, otherwise he loses all rights, unless he can prove that he was prevented by some just impediment from asking for the confirmation. The superior who has ascertained that the person elected is qualified, and that the election has been conducted according to the rules of law, cannot withhold confirmation. The confirmation must be given in writing. With the confirmation the one elected obtains full rights to the office, unless the law rules otherwise. Canon 177. If the election was not completed within the prescribed length of time, or if the College of Voters has as a penalty been deprived of the right to hold the election, the free appointment to the office devolves on the superior who would have had the right to confirm the election, or who succeeds in the right of making provision for the office in question. Canon 178. Election by postulation. If the election of the person whom the voters think most capable and preferable is obstructed by some impediment on part of that person, and if the impediment is of a nature that it can be, and usually is, dispensed from, the voters can by their votes request the competent superior to allow this person's election, unless the law decrees otherwise, even if there is question of an office for which the elected person does not need confirmation. In the elections made by religious, Canon 507 rules that election by postulation can be admitted only in extra 428 the new canon law. Plenary cases and only if not forbidden by the constitutions of the particular religious organization. The persons appointed by compromise of the voters to make the election cannot postulate unless this is explicitly granted to them in the mandate or compromise. Canon 179. In order that the postulation be valid, the majority of votes must be in favor of it, and if it concurs with the election there must be at least 2/3 of the votes in favor of postulation. The vote for postulation must be expressed by the term postulo, or its equivalent. The formula eligovo postulo, or an equivalent one, stands for election if there be no impediment, otherwise for postulation. Canon 180. The postulation must be forwarded within 8 days to the superior who has the power to confirm the election if he has also the power to dispense from the impediment, otherwise to the Roman pontiff or to another authority having the needed faculty. If the postulation was not sent to the superior within the prescribed time, it shall be ipso facto null and void, and the voters lose for this one election the right to elect or postulate. unless they can prove that they were prevented by a just impediment from forwarding the postulation. By the postulation the person named for the office does not acquire any right, and the superior may reject the postulation. After the presentation of the postulation to the superior, the voters cannot recall it except with the consent of the superior. Canon 181. If the postulation was rejected by the superior, the right of election is restored to the College of Voters, unless the voters knowingly postulated a person who was affected by an impediment of such nature that the dispensation could not be, or usually is not granted, in which case the provision for the office belongs to the superior. If the postulation is approved, the person thus elected for the office is to be notified, and he must within 8 days answer whether or not he accept the appointment to office. If he accepts, he thereby immediately acquires full right to the office in the same manner as a person whose election is confirmed. Canon 182. The latest official decrees and declarations on various points of the Code. 1. Fast and abstinence on holidays of obligation. The Pontifical Committee for the Authentic Interpretation of the Code answers to the bishops of France that the obligation of fast and abstinence is not removed if some of the holidays of obligation of the Universal Church which have been abolished for France should fall on a day of fast or abstinence. Canon 1252 is therefore to be understood only in reference to holidays which are actually of obligation in a country. Cf. Number 1095. 2. Application of Holy Mass on Sundays and holy days. The Code in Canons 339 and 466 rules that the bishops and pastors must apply Holy Mass for the people on Sundays and holidays. Also suppressed holidays. The Holy See was requested to explain what days are meant by suppressed holidays. The answer is that in this matter nothing has been changed by the Code in the discipline of the Church hitherto in force. It has been stated repeatedly that by the holidays on which pastors and bishops must say Holy Mass for the people, are meant the feasts enumerated in the catalogue of Pope Urban VIII. See number 311 on page 79 in this book. It is also quite certain from the wording of the Code that all pastors in the United States, and other countries not subject to the propaganda, are pastors in the strict sense of the term. Unless, therefore, the Holy See grants a dispensation in view of the difficulties under which many a pastor in the United States is laboring, the decision given here seems to settle the matter as far as the interpretation of the law of the Code is concerned. 3. The number of holidays of obligation as fixed by the Code are the only days of obligation, and the Holy See answers that holidays of obligation kept in some country or diocese, by reason of particular laws, ancient custom or spec concession of the Holy See, are abolished as concerns the duty of hearing Holy Mass and abstaining from servile work. Canon 1247, number 1090, Ada App, Citus, Volume X, p. 170. 1. 429, 430 The New Canon Law. 4. In reference to the nuptial blessing there are the following declarations. 1. Since the ordinary can permit the nuptial blessing also during the closed seasons, cf. Canon 1108, number 951, the question arises whether and how the commemoration prosponsus is to be said if the nuptial blessing is allowed by the bishop on Christmas or on Easter Sunday. The answer is that the oration is to be added under one conclusion to the oration of the day. 2. To the question as to whether the votive Mass prosponsus can be said during the closed seasons of Advent and Lent, the answer is that if the ordinary for a good reason allows the solemn nuptial blessing, the votive Mass can be said except on Sundays, feasts of precept, feasts of the 1 and 2 class, privileged octaves of the 1 and 2 order, privileged ferias and the vigil of Christmas. 3. To the question as whether the votive Mass prosponsus can be said on the privileged vigils of Pentecost and the Epiphany, the answer is that on neither vigil can this Mass be said. Cf. Ada App. Citus, Volume X, p. 332. 5. Term of office of religious superiors. Canon 505 rules that the term of office of local superior shall be 3 years, or at most 6. In the same house. The question was proposed whether this rule is to be applied also to superiors or directors of schools, hospitals, and other pious or charitable institutions? The answer is that the law in question must be applied also to these superiors if they are not only presidents, directors, etc., but at the same time superiors of the religious community. Cf. Number 356. Impediments of ordination. By the law of Canon 987, n. 5, men held to the ordinary military service, in countries where all able-bodied young men are subject to compulsory military service, are forbidden to be ordained until they have served their term. The question was proposed to the Committee of the Code whether this prohibition holds also if they are not yet of military age yet far enough advanced in studies to receive some orders, or if they have been called and examined and declared temporarily unfit. Furthermore, it was doubted whether this prohibition forbids reception of major orders only, or also of tonsure and the minor orders. The answer is that the prohibition holds in the proposed cases and for all orders. 7. Betrothal contract. It has been decided by the committee that the unjustified breaking of a betrothal contract, Appendix 431, entitles only to a suit for damages, and that pending this suit marriage with a third party is not to be hindered by the pastor. Furthermore, that the suit for damages spoken of in Canon 1017, 3 is a matter of mixed forum, that is to say, suit can be brought either in the ecclesiastical or the civil court, at the option of the injured party. Cf. Number 861. 8. Knowledge of Christian doctrine of people about to marry, as the parties should, according to Canon 1020, know the Christian doctrine. It was asked whether in case of gross ignorance the pastor is to delay marriage. The committee answers that the pastor should rather teach them the elementary points of Christian doctrine. If the parties refuse to come for instruction, assistance at their marriage should not be refused, as is clear from the ruling of Canon 1066. Cf. Nos. 863 and 909. 9. Publication of the bans and the testimonium libertatis. If it becomes very difficult to observe the law of Canon 1023, cf. 866, because the parties lived in various, very distant places, may the pastor resort to the supplementary oath tendered to the parties, so as to have certainty that they are not married already to someone else, or not held by other impediments. The answer of the committee is that in such cases the pastor is to refer the matter to his bishop, who may use his own judgment as to what proof is sufficient, and who may also demand the oath. 10. Doubtful impediment of consanguinity. If illicit and secret intercourse had preceded the birth of a girl who is to be married, so that doubt arises whether she is perhaps a sister, natural or adulterous child, to the man, or his daughter in case of advanced years of the man, may marriage be allowed as long as there is a reasonable doubt concerning these relations? Committee answers that Canon 1076, 3, decides these cases by forbidding marriage absolutely as long as these impediments are in doubt. 11. Impediments of marriage contracted before the code came into force and now abolished. The committee declares that engagement and marriage must be judged by one laws in force at the time these contracts were made, such as the 4th degree of consanguinity, 3rd and 4 affinity, affinity from illicit intercourse, and others which have, 432 the new canon law, been abolished, ceased to exist. Wherefore people who marry after Pentecost, May 19, 1918, are not held by these impediments though they had contracted them before the new law came into force. If, however, marriage was contracted before that date without a proper dispensation, the marriage is null and void and remains invalid, wherefore it must be validated either by dispensation, or by signatio in ratis, like any other invalid marriage. 12. Right of keeping the Blessed Sacrament in churches and chapels of religious. The meaning of Canon 1267, cf. Number 1110, is according to the declaration of the Committee of the Code as follows: if the religious house, or pious institute, has a public church, and the community uses the same for the ordinary daily religious exercises, the Blessed Sacrament is to be kept in that church only. If this is not the case, the Blessed Sacrament may be kept in the principal chapel or oratory of the religious house or institute without prejudice to the rights of the church, if it should be entitled by law to have the Blessed Sacrament as, for instance, a parochial church. If there are several formally distinct and separate families in the same house or institution, each may have its own chapel with the Blessed Sacrament, just like so many different religious houses or institutions. 13. Clerical societies without vows. The committee declares that the following canons, about which there was some doubt, bind also the clerical societies without vows. Canon 2386, which rules that a religious who becomes a fugitive is ipso facto deprived of any office he holds, and if a cleric in major orders he incurs suspension reserved to the major superiors of the religious organization. Canon 2387, which states that a religious cleric whose profession is invalid through willful fault on his part, is to be put out of the clerical rank, if he is in minor orders, and if he is in major orders he is ipso facto suspended until the Holy See shall provide for him. Canon 2389, which rules that religious who seriously violate the law of common life prescribed by the constitutions, and do not amend after serious admonition, may be punished with privation of active and passive vote, and privation of office if they are superiors. Canon 2410, which imposes suspension for a month from the celebration of Holy Mass on a superior who unlawfully sends his subjects for ordination to another diocese. This canon applies to societies without vows if they have the privilege to issue demissorial letters. The Law of Appendix 433, Canon 2411, which demands that superiors be severely punished, not excluding privation of office, if they receive a candidate who does not have the requisite qualifications specified in Canon 542, cf. number 387, or without the testimonials demanded by Canon 544, cf. number 389, binds also clerical organizations without vows. Canon 2413, which rules that superiors who interfere in any way, directly or indirectly, with the visitation, or make it ineffective by influencing the subjects in any way, are to be declared by the visitor incapable of being elevated to any office, and are to be deprived of the office they hold, besides other penalties which the constitutions may impose. Acta Ap. Citus, Volume X, p. 347, 14, Latest Faculties of Bishops for Impediments of Marriage, by decree of the S. Consistorial Congregation, August 2, 1918, the Bishops of America, the Philippine Islands, the East Indies, Africa beyond the shores of the Mediterranean, and Russia, receive faculties for the period of the war to dispense from the impediment of mixed religion and from all deriment impediments of marriage except the priesthood and the office in linea recta, consummate matrimonio. At the end of each year they shall make report to the S. Congregation of the sacraments of the number and kind of dispensations which they have granted, and remit at the same time the fees due to the S. Congregation for the dispensations. Acta Ap. Citus, Volume X, Pag. 363.